Hi, Crime Junkie Jurors. Good morning. Good morning. Can y'all hear me? I am setting up. I haven't streamed here in a while. I'm at the beach this week, so I haven't streamed here in a while. So I want to make sure y'all can hear me. It is, we are ready for season two of this crazy show. Can y'all hear me? I want to make sure, get all of our little kinks worked out before they get everything going, get everything started. Right now, I have a beeping noise from the live feed, so I'm going to keep it muted for a moment. Good morning. Good morning. I have Lucy Cam. That is one of the perks of being at the beach. I have Lucy Cam for y'all this morning. She has been on her beach walk this morning and is ready for Karen Read 2.0 to get underway. It's a big day. This is the day we've all been waiting on. It feels like it was never going to get here. And here we are, opening statements today. So today is Tuesday, Taco Tuesday, April 22nd. And it is the day that we finally get underway. Karen Read 2.0. If you did not see the Today Show this morning, they featured us here. They had a segment this morning about the trial and what a big deal it is and how it's made worldwide headlines and everybody's talking about it. And they had us on there this morning. They showed our little clip where I didn't realize how much I do this when I talk, but like, anyway, they had a little clip on there from us this morning. So it showed us on the Today Show today. So we are ready. There are going to be fireworks, I'm sure. There always are. There is always something happening in this trial. So those of you who have been with us before for this kind of know the drill. Those of you who don't, I am nosy and impatient, which means I don't like to pause the stream a whole lot. So I know that there are some who, when they're watching it, like to pause as they go. I am not really one of those people because I like to know in real time kind of what's going on. So I will pause occasionally if there's something that needs to be explained. And then we get to, fast forward through the breaks and sidebars and stuff like that to kind of get caught back up. We usually don't get more than a minute behind because I like to see it in real time because I am nosy. So that's kind of how we do things. And then I will try to answer questions as we go in chat, but I am also watching the screen. And like I said, I'm nosy. I want to hang on to every word. So during all of the sidebars, breaks, stuff like that, we will break everything down. I will be taking notes as we go too, so that we don't forget to go back and talk about anything. If you do have a question, if you put one of the big red question marks on there, it helps me see it. So I will try to answer all questions, any questions I can at break, and we will talk about it. If you watch the first trial, this is not going to be a rerun of that. This is going to be totally different, which is exciting, but also a little bit nerve-wracking, maybe. It's going to be just very different. So we do have our OnlyFans up. So we are ready. We are ready. Normally on the first day, what happens, what we can kind of expect, they will bring in the jury. They'll do their little spiel about the, jury introduction to the case, the jury expectations, all that good stuff. And then they will have the opening statements. Now, we've heard that this is going to be a little bit different this time. If you watched last year, David Yannetti did the opening statements. This time it's going to be Alan Jackson. And also we have, look at her she's got her little toy down there with her. She's so funny. We have Alan Jackson that's going to be doing the openings for the defense. And obviously this time, Lally's not going to be doing the openings this time. We're going to have Hank Brennan, which will be totally different. So, any of you who have listened to the podcast know I am not the biggest Hank Brennan fan. I don't like his theatrics, and I don't like his misrepresentations. So there are more than likely going to be some eye-rolling situations happening up in the right-hand corner of your screen. And if that happens, it's fine. Everything's fine. I have been rolling my eyes since I was a toddler. We will get through this together. But I am not a big fan of that situation happening. I think that there's always going to be like those little situations with certain attorneys who you're like, oh, I love their style. And then there's the ones who are you're like, oh, I don't like this style at all. So let me know what y'all think and who you think is effective. I want to know all of y'all's thoughts on this too, because I've been so like knee deep in this for so long that it's like kind of like one of those forest for the trees things sometimes. Like I like to hear fresh opinions on different things too and see how y'all are perceiving people. So let me know. I want to hear all about what y'all think, who you think is effective, who you think isn't, why. I want to hear all that. So y'all keep the chat going. Let me know what you think. We have, camera guy's getting situated. I get it. We get it. I see you. We're getting moved around, figuring it out. We got it. Oh, fan is gone. Now we've got our only globe and the fan is back. We got it. We got it. Everything's good. Good morning. Good morning. Good morning. I am also stalking, but not in a creepy way, all of the local reporters who are in the courtroom too, so that we can kind of get all of our, all of our inside stuff about what's happening, what's going on, who's looking at who funny, who's talking about who or whatever. Whatever. Anything. Y'all know I'm nosy. Anything we can find out, we're going to be listening for. April says, I can't believe we have to do this all over again. I hear you on that one. I can't believe it either. I remember last year thinking, as long as there's some kind of resolution, we'll have, we'll deal with it. We'll see what it is. As long as it's not a hung jury, because I can't imagine going through this all again. And yet here we are, about to go through this all again. So crazy, but it happens, I guess, right? Day 1 of trial. We have 18 jurors. 18 jurors, 9 men and 9 women, if they haven't lost any. As far as I know, they haven't lost any. But I guess we'll find that out too. So as of now, 9 men, 9 women. I bet her first jury is paying attention this time. I bet they are. It would be interesting to know how many of them are actually going to watch the trial this time around to see what's different, to see what, I wonder. We'll see. All right, let me get some of our happenings. The courtroom has added 2 mounted wall TVs because this trial is expected to use more video evidence. Remember, we saw the motion from the Commonwealth to have, I can't remember if they said bigger screens or more screens or something like that, because they were planning on using more evidence. So they have apparently added some this time around. They are in the small courtroom again this time. So the one that we were seeing some during got construction starting again. They're still working on that condo over here. It's not as loud today though. If it gets loud when they're doing the construction, I'll mute it, but I'm here all week, so hopefully they won't be here all week too. But if it gets loud, I'll mute it. while they're going through all of the testimony and stuff so that y'all can't hear it. But I do have my thing on that's supposed to filter that out. So it should filter most of that out. So if you can hear it, let me know. But I have the background stuff on. Let's see. Are openings limited to an hour like closings? I don't think so. I don't think that they limited these. That was actually one of the crazy things from the last trial. So normally there is a limitation on how long the closing arguments can be, but to limit it to an hour for a 2-month trial was something I've never seen before. So that was really interesting. The defense stuck in that time frame with no problem. Lally did go over and then she let Judge Canoni let him finish his last little sentence, but she gave him a bunch of warnings, and then he still went over. Is it the same courtroom or no? It's the same courtroom as last trial, but not the same one that they were doing the jury selection in. So it is the same one as the last trial, that really small one, which is an interesting setup because that courtroom is really, really small. And it's an interesting setup too, because you have the prosecution that's kind of in that front table, the defense is in that table behind them, and then you have, I hear noise. Did y'all hear the beeping? Making sure y'all hear the beeping too. Hold on, let me make sure. Headphone. Okay. Audio. Testing. Oh, there we go. Okay. Yeah, just beeps. Nothing yet so far, just beeps. Okay, so the family of John O'Keefe is sitting like right beside the defense table, which is kind of awkward. And then Karen's family is sitting behind her. And then the jury looks straight across the room. Like you can see the defense table right here, and then Officer O'Keefe's family right behind them. So it's a very small setup, and they're all kind of right there together, very close. So it's an interesting setup. Good morning. Good morning. I see y'all filing in. Everybody's excited. Everybody's excited for, this is going to be crazy. I'm excited for this because, oh gosh, it's been like the longest time coming, but also it is going to be, trials are always one of those things where there's always some stuff that's very entertaining, especially, you hear some crazy things that happen around there. But of course there's always, there's always a sadness that comes with everything, because we're here for, for reasons that are really sad. So this is always kind of one of those things where it will be an emotional roller coaster for a lot of us, which is why I really, really like watching this with y'all, so that we can kind of go through all of it together, because there are some things that we just have to watch together and be like, snarky about and roll our eyes or get annoyed. There are some things that we watch together and there's funny moments in court. There are some things that we watch together and it's, heavier. So we get to experience that together and be there for each other. So it's always so much better to watch this together. So I'm excited. Long time coming. And today we're perky because it's day 1, but by day 742 of trial, we won't be this perky, but that's okay. We will live off of Monster energy drinks and dry shampoo. Julie says, I hear there are people outside the courtroom drinking from red Solo cups. You know, at least they're drinking from them and they're not being used as evidence collection. So at least there's that. I saw when for spring break here, they had some college kids down there playing beer pong with red Solo cups. And all I can see is evidence collection units now. I am forever and ever ruined by the red Solo cups. So Deb says it's going to be 70s here in Boston area. So excited for today. We are excited for you and for us and for this to get underway. Elizabeth said, I really debated calling in sick, but I need money. How many people called in sick from work? Do y'all hear that beeping? Making sure that. Did y'all hear that beep? Making sure I'm not hearing things. Who called in sick? Hi, Steve. Hello. Hello, Steve Ellery. Hello. Good morning. Sometimes we laugh together. Sometimes we cry together. That is the fact. That is a fact. 100%. Eric Grant says, they are drinking from the Solo cups. My boyfriend drove by on the way to work and sent me a picture of them with their red Solo cups. Oh, goodness. Oh, goodness. Discretionary day for workers. Yeah. Discretionary day. Hear ye. That's how it all gets started. For those of you who didn't watch the first trial with us, they go, hear ye. God save the Commonwealth. I've been working on my Boston accent. Boston accent from a Georgia girl is not super accurate, but we're working on it. I've been practicing. Y'all be proud of me. I've been practicing. You just wait. It's so good. Good morning, Lisa. Hello. Hank Breenan's deviated septum said, I was going to, but couldn't. Thankfully, I can work and listen at the same time. I'll probably check out after opening statements and catch up later. Yes. I'm glad you can listen at the same time. Beth Henderson, hello. Morning. Saw Miss Brandi on the Today Show. Yes. I didn't know that I was going to be on there this morning. And then one of my friends, I'm at the beach this week, so I'm on Central Time Zone. So one of my friends on East Coast Time Zone sent a picture. I was like, hey, just saw you on the Today Show. I was like, oh, really? Didn't even know it was going to be on there. But yes, we were on there. Does the prosecution go first? The prosecution goes first pretty much in everything that they do. So the prosecution will always be first on everything that they do. So they do their first on their openings, they do their case in chief first, and they do their closing arguments first. So because they have the burden of proof, it's up to them to prove it. They're saying, hey, we think Karen Reed did that. Now it's up to them to prove it. So they go first on everything, and then the defense will always go second. Now, on closing arguments, they do have the option to do a rebuttal, and their case in chief, they have the option to do a rebuttal. So after the defense goes, the prosecution has a chance to go again. So they will always go first. And last year was the style of David Yannetti and Adam Lally was so different last year for their opening. So I'm curious to see the difference this year of how it goes compared to last year. So we'll see. Thank you very much. I don't know if you can see it because I've got my light on, but I actually got a little sunburnt yesterday. We have my family's in town, my in-laws are in town, and I was like, let's get out in some sunshine because I'm not going to see sunshine again for the next 2 months. So we went and spent a beautiful day outside. We took a boat out to Shell Island, which is insanely beautiful around here. So I did get some sun, and I was like, but I had a hat on, so I'm only red from here down, but with the light on, you can't really tell. So that's a good thing. I was like, everybody's going to be like, did you wear sunscreen? Did you wear sunscreen? I did. But just apparently not enough. Apparently not enough. What time are they supposed to start today? They are supposed to start at 9 Eastern. So I assume that they are, kind of getting everybody filed in. But, Norfolk County doesn't really go by actual times. That's one thing we've noticed. They will say what time they're going to start, and then it's usually, that's just like a jumping off point to start negotiations, because they kind of usually come in like, 15 to 45 minutes later than what they actually say. So we'll see. But we will be here at 9 just in case they are on time at any point in time during the trial. So we'll see. Oh, yes, the prosecution can defer. They can say, no, go ahead, let them go first. Which sometimes happens. Not always, but sometimes.
2282 CR 117, the Commonwealth versus Karen Reed.
So, good morning. I see all counsel are present. I see all counsel are present. Nobody said anything to Mr. Clerk about needing to see me, but I received 4 motions over this weekend that I assume we need to at least talk about briefly. Commonwealth's motion regarding defense opening statement. I think the first 2 motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader. Is it fair to say that the 3rd and 4th motions, Commonwealth motion to enforce compliance with court's April 16th ARCCA discovery order, and the Commonwealth's motion to preclude new expert testimony, or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them. And I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions.
Is that better?
Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves?
No, Your Honor.
All right. In light of that and the fact that we don't have time, the juror's been waiting for as many as 3 weeks now, I'm going to prohibit you from mentioning ARCCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
On that, I think the court respectfully may be factually incorrect on the key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson couldn't give you the facts. I would like to give you the law on that.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
Okay. So, real quick on that, I turned it up a little bit. Does it need to be up more? I can bump it up more. I'll boost it all the way there, and then I can just turn it down if we need to when they get going. So the real quick, if y'all missed, I did like a little recap update on these motions that were filed. The independent reader thing. So remember last week they had the they talked about it in the that last motions hearing that we did, and the prosecution wanted to bring in independent readers to come in and read the text messages between Officer O'Keefe and Karen Reed. And the defense said at that time, we don't want that. That could be theatrical. Maybe the readers could have, you know, some kind of inflection where it doesn't belong, whatever. So they kind of had their little argument against it, but they did file an opposition, like an actual official opposition. And in that opposition, they said that, but also they said that that's kind of creating evidence that doesn't exist, because they're looking to create this as or present this, I should say, as a conversation when it wasn't a conversation. These texts took place over the course of an entire day, not just back and forth all in one conversation. So having an independent reader come in, or independent readers come in and read them, makes it appear as though this is all one conversation, instead of them kind of sporadically communicating throughout the course of the day. So that was part of their official opposition. So the judge has said no independent readers will come in and do this. Last year for the trial, they had Trooper Gorino read them, because he's the one who did the phone extraction. So he's the one who read them. So they're saying no independent readers. So it will probably be Trooper Gorino who reads those this time. The other thing that she just ruled on was she will not limit the defense openings with an order. So this is another motion that they filed, that the prosecution filed. The prosecution is asking, or asked, to to limit the basically wanted the judge to order the defense to not be allowed to say that the injuries on John O'Keefe's arm, that they will have somebody come in and say that those are from a dog. Here's the issue with that. Brennan, in that opposition, or in that motion, put in there that he didn't want them to do this because they can't mention third-party culprit in the openings. Now, it is Massachusetts law, you cannot mention third-party culprit in the openings. So that's fine. That is something that has to be developed throughout the course of the trial with evidence. The opening statements are basically each chance's opportunity to get up there and tell the jury, this is what the evidence will show. This is what you're going to see. So you can't do that with third-party evidence. But the dog isn't listed as a third-party culprit, y'all. So that's not like that. That's going a little overboard and trying to limit the defense in a way that's not really constitutional. So I had a feeling that would get denied. It's no surprise that that's not being denied, or that that's not being allowed. So the judge said, I'm not going to limit them. They know that they can't bring up third-party culprit stuff, but you can't really tell them, like, you're not allowed to say that those injuries came from, that the evidence will show that you were going to have, experts come in and say that they came from, an animal. That's not third-party culprit stuff. That's a defense. So no surprise there. Although I shouldn't say no surprise, because sometimes when I think it would be an easy, ruling, I do get surprised. So the dog is probably in witness protection now. It would not surprise me. Shout out to Chloe and her teeth molds. The other one is the text from ARCCA. So the text from ARCCA, between the defense and ARCCA, have been ordered by the judge to be turned over. That was part of the discovery. They're saying that the sidebar that's happening right now is very animated. And apparently they're it says that Alessi is loud and animated at sidebar. He's very upset, as is Alan Jackson. So the text between ARCCA and the defense have been ordered to be turned over. So that's kind of what that was. I don't know. I wish we could have heard what was said at sidebar, because y'all know I'm nosy and I want to know. But she said that because they weren't turned over, they can't mention ARCCA in the openings. And then that's when he said, I think that the court is factually incorrect on something. And then they went to sidebar. So we don't get to hear exactly what they're saying they're factually incorrect on. We'll see. We do know that when they've talked about the communications between ARCCA and the defense before. The defense has said, look, y'all got everything that we have. We turned over everything. And Brennan has said that he doesn't think that they have. He thinks that they are going to be able to find more stuff if they order them to bring in, or if the judge orders ARCCA to bring in their communications, that there will be some that he believes will be turned over that the defense did not turn over. So he basically is saying, I don't believe them. I think that there's more and they're not telling us. And the defense is like, nope, we've given you everything. So I guess there are a couple reporters that are in the courtroom right now saying that that was a very heated exchange, a tense sidebar. So court is in recess for 20 minutes now. So off to a good start, right, guys? We'll see. We'll see. I'm sure we'll hear eventually about what that came in. Can y'all hear that hammering? I've got the noise stuff on. They're not as loud today doing the construction as they normally are, but they are loud. Michelle Dunn, thank you so much. I listened to the podcast I missed over the weekend. Brandi, you never failed to deliver. Thank you very much. I will be doing them here as well. I will be having the recaps at the end of the day to kind of give you, top points of the day. And then, of course, the podcast will be much more detailed on putting everything together on what's happening. So make sure you check out our recaps here at the end of the day. Are we sure there even are texts? No, because the defense says we've given everything to you, and Brennan is saying he does not believe them. He thinks that there's more. So we don't know. Beham says the arm injuries weren't the cause of death, though, and therefore should be allowed an opening. This isn't a dog attack trial. Yes, because the dog is not part of third party. Like, you don't have to bring in third party evidence to introduce, the dog. Like, we're not like it. You're allowed to say, the defense is generally allowed to say, this is our theory. This is what we say the evidence will show. Because remember, both sides all have the same evidence. They're all looking at the same stuff, but both sides will look at that evidence and have two totally different versions of what they say the evidence shows. When you have circumstantial cases, it's always like that. You look at the evidence, because this isn't like you're going to look at the video of exactly what happened and then you can come up with two different things. This is circumstantial cases are looking at evidence, and each side will come up with what they say the evidence shows. And then that's what they're going over in openings. They're telling the jury, this is what the evidence will show. You're going to hear this and this and this. And this is their chance for them to lay out what their version of events is based on the evidence that they're going to see. Now, that evidence can include the circumstantial stuff like, evidence that was collected at a crime scene, or, some of this stuff is going to be, we've already heard, it's going to be statements from witnesses, but also from Karen Reed herself in a lot of the media that she's done. So they're going to use that against her in all of this. So we're going to hear evidence that is all what they say. They'll be looking at the same thing and saying that it says something totally different, which is always one of the very interesting parts of this. And then it's going to be up to the jury to decide, is this the only reasonable version of events that the prosecution is giving us, or is what the defense is saying also reasonable? Or did the prosecution prove their case beyond a reasonable doubt? So we'll hear both sides, and then the jury will decide what they think. So they can't turn over something that doesn't exist. True. Brennan thinks it exists. So I don't know. We'll see, I guess, see what comes out. It's going to be 84 years again. Yes, it will be. It will be an 84-year long trial. It'll be an 84-year long trial. Yes. I have the reporters that I'm following in the courtroom. Ted Daniels in there. Katie Benoit. Aiden Carney. Matt Johnson. Who else is in there? There's a few of them. I'm stalking all these people, y'all. I'm stalking all these people. Why is it 20 minutes? I'm not really sure. I'm not really sure. look, yeah, Lucy, she is unbothered. She is unbothered by whatever's happening in Norfolk County, Massachusetts. Are you sacrificing your precious time with Chat Daddy to be here with us? Yes, but he is spending time with his family who's here. So I did get to spend some time with them this weekend. So I got a nice little weekend breakaway before everything started. So I wouldn't want to be anywhere else but here with y'all during all of this. Recess already and they haven't even started. Yes, Dev, good point. It is. This is how it goes. Will they call Trooper Paul again? Yes, he is on the witness list again. So we'll see. They kind of have to because he was the one who did the accident reconstruction last year. But they do have, the prosecution does have different crash reconstructionists this time. Ones who are not state troopers. They are actual biomechanical engineers and kind of like their own version of the crash daddies is who they're calling. So, but yes, Trooper Paul is on the witness list. So, oh, bless his heart. If y'all missed his testimony last time, I will say this. The podcast episode I did comparing what he said and his testimony and how he explained things, the episode that I did comparing and contrasting that to the crash daddies was one of the most difficult episodes I've done, but also my favorite. That is my favorite episode or series of episodes. I think it was like a 2 or 3 parter, but that was my favorite that I've ever done. Very different. Very different. Shay Turtle, hello. Brandi, hi. Also, what are the top things you expect to be different in the second trial? The style of everything from the prosecution is going to be totally different. Hank Brennan is a defense attorney. He is a former prosecutor. Most defense attorneys are, but his career as a prosecutor is much shorter than his career as a defense attorney. He has been a defense attorney for, a very long time. And we have already seen him going into this, treating it like this is he's prosecuting it the way that a defense attorney would. And when I say that, I mean, the defense a lot of times a lot of their strategy is limiting what can be brought in evidence, trying to keep anything out that could be prejudicial, trying to keep anything out that, wasn't collected the proper way, basically trying to limit what's presented to the jury for whatever, valid reasons under the law that they can. And we've seen that a lot from Hank Brennan. His style is also very, very, he's so different from Lally, where Lally was just very kind of monotone and very tedious. Hank Brennan is very theatrical and he's dramatic and he is very loose with facts in a very irresponsible way. And I think that is going to play a huge role in this, because this is one of those things where you always hear, you can't unring that bell. He will say things, and we've seen him do it so often in these pretrial hearings, but the theatrics that he's shown at this point have been all for the court and the media. Now he's got a jury. So it is going to be very interesting to see how that theatrical style plays in front of a jury. And that can go either way, because especially depending on which witness you're going after, because if somebody from the jury really likes a witness and there's an attorney who's like, hardcore going at them, that will not play well with them. But if they don't like the witness, then they're like, yeah, get them, I don't like their attitude, or I don't like what they said, or they're lying, or whatever. Depending on how, that's a hard thing to tell sometimes. So depending on how they feel about a specific witness, the way that the defense attorneys question them can have a big impact on their attitude toward the prosecution or the defense. So that will be very interesting to see how that part plays out. So we'll see. We'll see. I'm assuming Bev has blocked ARCCA in opening and given defense 20 minutes to rewrite that. Bev will make a nod to be indifferences. Well, I'm curious to know what the argument was when, and this is pure speculation. I'm wondering if it has something to do with, because she said, were those texts provided? And they said no. And she said, well, you didn't turn them in. I said to turn them in, so you can't mention them at openings. I'm wondering if the reason that Alessi is saying, I think you're factually incorrect on this one thing, is because their argument is, we didn't turn anything else over because we've already turned everything else over. So that's pure speculation. That's just a guess. But we'll see. We'll see if that's, we'll see. But also, they didn't mention ARCCA in the openings last time. I'm assuming that they probably had, ARCCA as a big portion of their, not necessarily a big portion, but a key portion of their openings this time. So we'll see if if they're not allowed to turn that in, or not allowed to have that in there because she's saying they didn't turn in whatever other text messages they think may exist, and they have to redo everything. That'll be interesting. That'll be, I don't know. You just can't predict some of these things, right? Lucy, she's just a snoozing. Just a snoozing. Lucy is our little emotional support pooch for all of this. Melanie says Lally was clueless. Hank is calculated. I think that Hank is very, very calculated, which is, but let's be honest. I mean, honestly, like, being very calculated is part of being a great, attorney a lot of times. So I think that I do acknowledge that part of it, but it is frustrating for me personally to watch sometimes when I see things that I don't like how it plays out. I just, I'm not a fan. I'm not a fan. Good morning. Good morning. Welcome in. Welcome in. They didn't mention ARCCA the last time in the openings. Because they didn't, they talked about this in one of those recent motions or recent motions hearings that they had, that they didn't mention ARCCA in the openings because they didn't yet know if they were going to be allowed to have them testify. So they did put them in closings, but they did not put them in the opening statements. Here we go.
You are muted. You are unmuted.
Here we go. The talks about being ambushed.
All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, now holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
2282 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Morning, Your Honor. Adam Lally for the Commonwealth.
Morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Good morning, jurors. So I have 3 questions I have to ask you because I haven't seen many of you for a long time. And we do appreciate that you are all here, ready, willing, and able to get started early. We sometimes have to deal with a few things before bringing you in, but we do appreciate your patience. So those questions are, were you all able to follow the instructions and refrain from discussing this case with anyone since we last saw you? Everyone said yes or nodded affirmatively. Were you also able to refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we last met? Everyone said no or shook their heads. Thank you very much.
Jurors, can I have each of you stand and raise your right hands, please? Do each of you solemnly swear you shall well and truly try the issue between the Commonwealth and the defendant according to your evidence and according to the law, so help you God? Yes. Thank you. You can have a seat. Jurors, hearken to these indictments. Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the 2nd degree and not in the 1st degree in violation of Massachusetts General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did operate a motor vehicle upon a way as defined in General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described to cause the death of another person, to wit John O'Keefe, in violation of General Law, Chapter 265, Section 13 and a half. 003, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24, Subsection 2, Subsection A and a half, Subsection 2. To these indictments, the defendant has pled that she is not guilty and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you say so and no more. Jurors, hearken to the evidence.
All right, thank you. All right, members of the jury, I'm about to make some preliminary remarks to you to acquaint you with some of the legal principles, procedure, and terminology that you may inquire during the course of this trial. These comments are not intended to be a substitute for the more detailed instructions on the law that I'll give you at the conclusion of the case. So you'll remember that this is a trial of a criminal case. Ms. Reed is charged with 2nd-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death, the indictments that Mr. McDermott just read to you. I'll describe the law in detail at the end of the case and the elements of these charges, but briefly, murder is the unlawful killing of a human being. In order to prove Ms. Reed guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. And leaving the scene of an accident after causing personal injury or death requires the Commonwealth to prove that Ms. Reed knowingly collided with John O'Keefe, that she caused him injury or death, and then she fled the scene. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, please remember that Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. It is merely a formal manner of accusing a person of a crime and bringing that person to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law never requires a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, As you listen to the testimony about the people involved in this case, please consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, when I finish these initial instructions, the Commonwealth, Mr. Brennan, will make his opening statement. Then Ms. Reed's lawyer, Mr. Jackson, can choose to make an opening statement or not, because again, remember, the defendant has no burden of proof and doesn't have to prove anything. Her lawyer does not need to make an opening statement. An opening statement is a summary of what the lawyer expects the evidence at trial will be. It is intended simply to introduce the main issues in this case to you. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may present evidence on her behalf if she wishes to do so, but she is not obliged to do so. Remember, the burden of proof is always on the Commonwealth to prove that the defendant is guilty. The law does not require any defendant to prove her innocence or to produce any evidence at all. After all the evidence, each side will have an opportunity to offer you closing arguments about what conclusions you might draw from the evidence. Like the opening statements, the closing arguments are not evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you are to apply in your deliberations when you retire to consider your verdict. Your verdict must be unanimous. Let me speak briefly about our respective roles in this case. As the judge, my responsibility is to see that this case is tried orderly, fairly, and efficiently. It's also my instruction to decide any questions of law that come up during the trial and to instruct you about the law that applies to this case. It is your duty to accept the law as I stated to you, whether you agree with it or not. Your function, you folks are the most important people in the courtroom. Your function is to determine the facts. You are the sole and exclusive judges of the facts. You alone determine what evidence to believe, how important any evidence is that you do believe, and what conclusions all the believable evidence leads you to. You will have to consider and weigh the testimony of all the witnesses who will appear before you, and you alone will determine whether to believe any witness and the extent to which you believe any witness. You can believe all of what a witness says, some of it, or none of it. It's entirely up to you. It is part of your responsibility to resolve any conflicts in testimony that may arise during the course of the trial and to determine where the truth lies. Ultimately, you must determine whether or not the Commonwealth has proved the charges beyond a reasonable doubt. The lawyers have their own important role in this trial. They are, of course, advocates. Their job is to bring to your attention the evidence and arguments that best support their position. They may also object to evidence offered by the other side that may not be admissible under our rules of evidence. Similarly, we may engage in sidebar conferences out of your hearing. These sidebar conferences are not intended to keep secrets from you, but to allow the lawyers a little more time to argue their points so that I may rule on what you may consider as evidence. If I agree with an objection to a question, the term I will use is sustained. You are to disregard that question, and you're not to speculate as to what the answer might have been. In the same way, you're to disregard any evidence that I tell you is stricken from the record. If I reject or overrule an objection, I'll permit the witness to answer. This happens a lot. You'll find this during the course of the trial. If I let the witness answer the question, but you're not allowed to give the answer any more weight than you would have no objection had been made. Please do not hold it against the lawyers if they make an objection. That's the important part of the lawyer's job. The lawyers have to let me know when there is a potential issue about the admissibility of certain evidence under our law. You must decide this case solely on the evidence presented in this courtroom. This will include the sworn testimony of witnesses and may also include any exhibits that are admitted into evidence, any facts that I tell you have been agreed to by both sides, and any facts that I indicate to you may be taken as a matter of common knowledge. Questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers which you receive from the witnesses who are testifying under oath are evidence. So if a witness is asked, isn't it true that after you learned that your uncle left you money in his will, you poisoned him? And the witness's answer is no. Based solely on that question and answer, there is no evidence that the witness has an uncle, that the uncle had a will, that the uncle left the witness money, that the witness knew that he did, or that the witness poisoned him. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I may make, the lawyer's openings and closing arguments, and any comments they may make are not evidence. I will emphasize this point because it's crucial to your understanding of your role. If the lawyers or I make any comments during the trial, those comments are not evidence, and your verdict must be based only on the evidence. In Massachusetts, lawyers are not allowed to make comments other than during opening statements and closing arguments. They are permitted only to ask questions, but they cannot comment on the witness's answer. If a lawyer comments, you are to disregard it. In this way, communication in the courtroom is not like everyday conversation. If a lawyer seems to agree or disagree with an answer, or if a lawyer expresses confusion or any other reaction or emotion, you are to give no weight to what that lawyer does. In the interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. In a similar way, any comment I make is not evidence. But of course, you can't disregard what I say when I provide you with instruction or direction. Remember, however, I'm the only one who can instruct you or direct you in any way. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. Now, in this case, I anticipate that we will go by bus to an area that you'll hear about during the trial. You may consider as evidence anything that you observe about the layout of the area, including the scene of the alleged crime when we do go there. I will give you further instructions prior to our leaving for the view. Now, in this case, I'm going to allow you to take notes. Any jurors who wish to take notes during the course of the trial, except during opening statements and closing arguments, because remember, those aren't evidence. If you wish to take notes, you may do so once the evidence begins. Notebooks and pencils will be provided to you. The notebooks will be collected each day, and they'll be locked up, and they will remain confidential, and they're destroyed at the end of the trial. Nobody sees them. You're not required to take notes. The choice is entirely up to you. Some jurors may feel that notes are helpful, particularly if the case involves many witnesses or complicated issues. Notes also can help you remember specific testimony or evidence, such as times, places, dates, names, relationships, events, distances, things like that. Other jurors may feel that note-taking is a distraction and may interfere with hearing and evaluating the evidence. If you do take notes, I suggest you keep them brief. They are not and cannot be considered official transcripts of the trial testimony. However, bear in mind that although the court reporter is recording everything that transpires here, we do not have the capability of providing you with a transcript of the testimony at the conclusion of the trial. So you'll have to rely on your own memories of the testimony, perhaps supplemented by your notes. Regardless of whether or not you take notes, please remember that how a witness testifies may be just as important as what he or she says. Therefore, your observations of the witness's appearance and demeanor on the witness stand may play an important part in your assessment of his or her credibility. Do not let note-taking distract from an appreciation of all the evidence. If you have any trouble hearing or seeing during the trial, please raise your hand or let a court officer know, and we'll make any necessary adjustments. We generally take a morning recess at around 11 o'clock or so, but if you need a break at any other time, please raise your hand and let a court officer know. We'll take a break. If you need to communicate with me during the trial, and I'm not suggesting for a minute that you need to, but if you do, please speak with the court officer or give the court officer a note to bring to me. Now, I'm going to address the issue of public interest in this case again, and the duty of this court and this jury to adhere to the rule of law, because it is so very important. John Adams famously said that we are a government of laws, not of men, and that the law must be deaf as an adder to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with great intensity, but unbound by any oath or even any inclination to follow the actual evidence. The law works in a different way, and the difference is crucial to our system of justice. This jury, selected for this trial, will hear and judge the evidence. You will decide what the facts are. Where the evidence is contested, you will determine where the truth lies. Ultimately, this jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this trial will be decided by you, an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, you must ignore it so that the rule of law will be upheld. Which leads me to the fact that it is very important that during this trial, until you deliberate, you must not discuss this case with anyone. This includes your family and friends, and even your fellow jurors.
That would be so hard.
Nor should you allow anyone to communicate with you about any specific aspect or any aspect of this case. You must not conduct any independent research about this case, the matters in this case, and the individuals involved in this case. In other words, you must not consult the internet or do anything else to try and find out information from any source outside the confines in this courtroom. Please be very careful with your social media use. Please do not use X or Twitter, Facebook, Instagram, or Reddit. Though you may never have seen anything about this case before on your social media feed, you cannot control what may pop up. You should also remember that use of these platforms can be public and traceable, and any searches undertaken or information received by you can and likely will be discovered. So please be extremely cautious. If you inadvertently see something about this case, please disregard it and let us know. As best as you recognize them, please have no contact with any of the participants in this trial or anyone associated with either side, including the lawyers. Please do not visit any locations that may be mentioned during the trial. We'll go on a view, as I told you, and I'll discuss that with you before we go. Remember, you were instructed that you must not, and you assured us that you would not read, watch, or listen to any account of any aspect of this case in any news media, social media, or from any other source. It is critical that you follow that instruction. Finally, please continue to keep an open mind. I know that you will try this case according to the oath that you've just taken as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict, and that's all we ask of you. So it's now time for the opening statements. Mr. Brennan.
Here we go.
Thank you, Your Honor.
Here we go.
At 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat. He raced to his equipment and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter and paramedic, that means that a person's heart has stopped. He didn't know who it was, he didn't know where it was. He took his bag, he had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34th Fairview Road. As they drove, firefighter Nuttall could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure that all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamati's ambulance, and it was well stocked. He calmed himself, and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and eerie calm was above him. As the car pulled up to 34 Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow. And when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man and he reached down and he tried to find any signs of life, pulse, anything. And he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Karen Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Flamati, the chief, and he said, "Come back, let's go." Because you'll learn that in the cold, even if somebody's heart stops, even if they're presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear from testimony, he went back to that man who's John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain as he kneeled over John O'Keefe. He looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, "What happened?" And you'll hear her words through firefighter Nuttall. She said, "I hit him, I hit him, I hit him." And it was at that time, through the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context, they didn't reconcile with the injuries, it didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator, he is not a detective. He's a first responder. And so he takes that information, it was useless to him, he continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body lay his cell phone. They bring him to the ambulance, and while they're bringing him to the ambulance, you'll see on the videos that other first responders speak to the defendant. One first responder, Mr. Flamati, she will say, "I hit him, oh my God, I hit him." And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background. And during that conversation, you won't hear her see the defendant with a person by the name of Jen McCabe, and a firefighter McLaughlin, and she tells Fire McLaughlin, her first responder, I hit him. They bring Mr. O'Keefe to the Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his corpse. And unfortunately, firefighter Nuttall's first instinct is accurate. John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in that dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited 2 seconds. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded, yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. John O'Keefe was a help. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his own. They were his passions, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together, they did activities with the children together. She helped with driving the children, feeding the children. It was a steady relationship until about the beginning of 2022. And then things began to unravel. There was tension, there was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave, but she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022. You will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only companion to John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on, and Waze is like a breadcrumb that will show exactly where the phone goes second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping, moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Okay. And the third thing, remarkably, will be an expert in this case who found a data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to the timeline of that night. After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar, a blizzard is pending, and people are getting together in a celebratory mood. They go to McCarthy's and you see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrive at 8:50, they stay till 9:45. She consumed at least 7 of those drinks in less than 2 hours. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friends and the defendant and many of the people there. And they spend some time together, they're drinking, and they all do a shot. And that will be at least the 8th drink within 3 hours that you consume. You will see from the data, not just the cell phone data, but there's some other very important data. And the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, where there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so they leave the Waterfall bar at 12:12, and you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're going to go back to 34th Fairview Road, where we talked about earlier. They're going to go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, you will be able to follow them with this location data. When they go back to Fairview, they don't know exactly where it is and they get lost. And so John O'Keefe makes a phone call, has a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, and trying to get directions, Jen McCabe tells John O'Keefe, it's near Bella's mom's house. You'll learn that Bella, or her mom, was somebody that John had dated before. And so as they make their way through Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop and then they do a 3-point turn in the driveway. You'll see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because that's 7 minutes before the collision. And you'll see from the waves exactly where the car was. You'll see from the black box the event of the 3-point turn in the driveway, and then a return down to Fairview. But before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights. One of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, you'll hear, because of the waves, can be counted second to second, never stops. It rolls very slowly all the way to the end of the yard in the corner where there's a tree line and a flagpole. And they reach that location at 12:34:33. And they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out, the person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside at 12:27, John gets a text from Jen McCabe, park behind us in the driveway. 12:29, she texts again, are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. You will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus. And in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message he Jen McCabe. It's now 12:32:09. He closes the phone the last time. It will be the last time he uses that phone. From the waterfall bar, you see that he keeps it in his back pocket. And at that time, 12:32:09, last user, he has 7 more seconds he will move before he lies dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. The clocks run differently. There's a 30-second variance, but it's right in the heart of that time. And you will see through the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops, neutral, and then shoots into reverse with the tires spinning right towards him, right where he got out. You'll know they're arguing because the next morning she tells a firefighter, I'm sad because our last moments were fighting. She drives away. They said she's made later statements that when she left, he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow, the snow now picking up. And he's just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the warm car. Now that he's been outside the car for 5 minutes, it drops to 72 degrees. She drives to his house. She makes a phone call at 12:33 after she's left Fairview. She calls again at 12:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking hate you. Pardon my language. You will hear the simmering. And she leaves that message. He lies on the side of the road. He gets another text message that's unanswered. Where are you? 12:45. Battery temperature, 61 degrees. So he gets almost 40 calls from the defendant that night. His phone rings, but he never answers. You'll hear from an expert that the light never initiates, the healthcare data never moves. John alone with his only companion, his phone. At 12:53, cell phone drops to almost 60 degrees. 12:59, the defendant leaves another message on John's phone. Now, she hasn't spoken to anybody. Nobody has spoken to her, but her message is out. You'll learn the message says, John, nobody knows where you are. And this is where the plot in the cover-up begins. The evidence will make clear that she knew who was there. But she did not call 911. She did not go back to him. She did not leave an anonymous tip. She left him. The night wears on. It's now 1:07. Battery temperature 55 degrees. 1:14, she calls her mother. No answer. 1:14:53. Battery temperature 50 degrees. The defendant had healthcare data on her phone as well, and you'll hear that it stops around that time. You later learn that she admits to falling asleep and passing out. But then she wakes. 5 o'clock, she is frantic. She wakes up John's niece, and she is unintelligible. She is yelling, she's screaming, she asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount out of a deep sleep. She wakes up and she hears, Jen, 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 screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe calls back. And then she, what's going on? And she's told, well, I left him at the waterfall. At the beginning of the cover. She tells Jen McCabe, I left him at the waterfall. Jen calls back and says, you saw you up front. You did leave me at the waterfall. She hangs up. She then minutes later calls another person, Kerry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids and they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, I think John got hit by a fly. I think he's dead. Now, Kerry, with that information, calls 911. She calls hospitals. You can hear her voice. She's concerned. Okay. And then she gets another call from the defendant. And she tells the defendant, come to my house. I will help you look for him. And the defendant says, I was so drunk last night, I don't remember anything. Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Kerry Roberts, the other friend, then goes to Jen McCabe's house, pulls behind the car. And when she does, she's on Bluetooth, and she can hear the defendant saying, my taillight's broken, my taillight's broken. And she looks, and the snow packed in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34th Fairview Road, but Kerry Roberts takes over and says, we're gonna go back to John's house. Maybe he's in the house when you didn't see him. So both cars, driven by Kerry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Kerry, enlisted into this task. Look for John O'Keefe, they cannot find him. And then when Kerry Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they got to go back to Fairview Road. They decide to take one car. Kerry Roberts is taking charge. She's going to drive. They leave Mr. Lexus and John O'Keefe's driveway, and they drive back towards 34th Fairview Road. You'll hear it is blizzard-like conditions. It is dark, they can barely see a thing. And when they get close to the edge of 34 Fairview, you hear the defendant start to scream, "There he is." Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door, "Let me out." Kerry Roberts stops the car and lets her out, and she sees the defendant run exactly to where John O'Keefe is in the darkness, just where she left him. Kerry gets out of the car, starts to walk towards where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes it's one of her best friends in the world is John O'Keefe. And she starts to try to do first aid. They start to move him, and coincidentally at 6:06, when they start to move him, the cold air hits that cell phone battery. It drops from 50 to 43 degrees. And they try, Jen McCabe calls 911. And that's when a police officer arrives, firefighter Nuttall and his crew. And when they lift him, that cell phone battery that is shut down to 37 degrees, Kerry Roberts picks it up and puts it in her pocket, and it immediately starts to warm as she moves to help get data, showing movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers. They're not sure, so they look in the area where John's body is and find a glass from the bar near his body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work of the Canton Police Department to try to uncover a little bit around his body to see what they could find, which was very little. And then Kerry Roberts goes and picks up Peggy O'Keefe, tells her the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Kerry Roberts is walking, and Peggy O'Keefe is going to go see her son, with her husband. And as she walks down the hall, Karen Reed is also in the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her into evaluation to make sure she was safe. You'll hear Peggy O'Keefe tell her she walked down the hall to go see her son. The defendant was screaming, "Is he dead? Is he dead?" As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you'll hear that Karen was excited and yelling, "Is he dead?" She stops her excitement. He puts stolen. Doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to tell the children. Now, while she's out, the Canton Police Department sent an officer to the house to make sure the children are safe because they're alone if they're home. And when the officer pulls in, he doesn't notice anything, but you'll see on the dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, a friend has taken them, and they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in, no condolences to Peggy. And they ask, "Can we go upstairs to John's room?" And she's busy consoling her grandson. They go upstairs. They're upstairs for about 15 minutes. They come down. And quickly they leave. Now they got there from the defendant's father, drove his wife and the father to that house. But when they leave, they take two cars. They take the Lexus with the broken tail light with them back to the defendant's father's house. And you will learn that when police start getting some of the information, they learn about the broken tail light, they learn information that she had told people that she had hit him. They went down to see her. And on their way down, they decided they would get a warrant to take the Lexus. When they get down to Dighton, where the car is, You'll hear from Trooper Buchanan, who took a look and you can see the missing tail light. They went in and spoke briefly to the defendant. They took the car, they brought it back to Canton. And so what you'll learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken taillight was littered around John O'Keefe's body. Littered around that area. When they got to the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug the excavations, they found his shoe on a little berm on the border between the street and the grass. We learned days later when they did a plant excavation, they found his hat frozen into the ground. Ultimately, they would find over the course of 10 days that the snow melted almost all, every piece of that broken tail light in that area. The hat, the sneaker, the glass. When the defendant left Mr. O'Keefe behind, took with her something of Mr. O'Keefe, it's called trace evidence. You'll learn on the back of her Lexus, around the taillight area, is John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's hair. Now, John O'Keefe fell backwards and hit his head after he was clipped by a car. And you're going to hear from a very renowned doctor, a neurosurgeon, who's treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, not the crack in the skull, it's called a basal fracture, it created an injury called counter-coup. After he was put by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusting at this point, the back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, treated thousands of patients, that this injury, with reasonable degree of medical certainty, is counter-coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said one force trauma, they had it undetermined. So we brought it to the renowned neurosurgeon who does exactly this. You're also going to hear from an accident reconstruction. His name is Doug Welcher. He does not work for the state police or local police. He was hired to take a look at this case and the data. He will come in and explain to you exactly what I talked about, how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant struck John O'Keefe with her car. Now, just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, bringing deliberate premeditation. Our Honor will instruct you on the law. I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we will prove to you is she engaged in an intentional act, driving back at him at that speed in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act would cause a plain and strong likelihood of death. That's what will prove to you second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. He died. That's what we'll prove. This case will come down to the science and the data. The science and the data that cell phone is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign. A campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent about what she did that night. Her word simply confirm that your judgment is sound. And you're going to hear from her own lips in many of her statements, her admissions to extraordinary intoxications, her admissions to driving the Alessi, her admissions to being angry at dawn that night. And I dare say her admissions that she told shit. Like to play for you clip one. You're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in his drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29th, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you the truth, and the defendant's own words will confirm everything you've already concluded.
All right, thank you, Mr. Jackson.
Could I have just a moment to readjust?
Sure, the court officers will be kind enough to help you.
Okay. When they're not standing at the microphone, there's nothing I can do about it. I have the sound boosted as far as it will go. When he's walking around and he's not in front of a microphone, I have it boosted 600%, which is as high as it'll go, so I can't make it any louder.
The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle, period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop who owned the property where John O'Keefe's body was found. Text message with a buddy. Question, is the homeowner going to catch any shit? Answer, nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted and corrupted from the start, corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn, literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. And that was for one reason and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that in Michael Proctor's world, rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer, Brian Albert, and his friends, they do get. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Alberts' house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Bryans, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier, she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the Waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out. And when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why. Let's talk about that. We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where ultimately at 6 a.m., Karen found him the next morning. You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. LaPosada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. LaPosada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside the Albert house that night. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her, but she was gone. Dr. LaPosada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. LaPosada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth. And he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did. And we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was nobody on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here, a collision. And there's no evidence of one, zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that too is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. shortly after Higgins completed that late night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation: a butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call? You'll also learn after this incident, and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations. He literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start, and he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night, and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Cellebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now, she misspelled the first word. Hos is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Cellebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, obstructed by a Ford Edge like the one the Albert family like to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m. And that's when she realized in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time, Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none, but they'll make the claim. We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him. And she was worried about possibly the worst. He had gotten out of the car. He'd walked to the house. She was confused. And later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling. Oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about. Your job will be to make sure that the evidence isn't presented to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other, a woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Kerry Roberts, Jennifer McCabe. They were all there watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, "I hit him." Not one. Not one civilian reported having heard Karen Reed say, "I hit him." The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this, in an interview coordinated by a Canton police detective named Kevin Albert, Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years-long close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family, and that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants. He transported the evidence. He secured it. He submitted it. He did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were 2 searches. The first and second search found 0, nothing. Nothing around John's body, nothing in the street, not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items, 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. It came up with 0. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. DNA was on the taillight, but you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show it was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the house and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all 3 of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
Thank you, Mr. Jackson. Folks, why don't we take our morning recess? It's 12:15.
Court order, please.
Woo!
You are muted.
All right. Dang. All right. So what are we thinking? How are we feeling? Tell me in chat what you think about the two openings, what you think worked, what you think didn't, what you noticed that's new or different. We heard some new information this time around too. Tell me in chat, based on openings, I know it's kind of hard to like remove yourself since we know, we are not normal jurors in this case. We are crime junkie jurors in this case, which means we are all up in all the details on this. So it's a little bit different for us. But tell me what stuck out to you the most. I want to hear your thoughts on this. I'm going to turn this off for a second while we're on break, because the OnlyFans tends to make people dizzy sometimes, and I can understand that and respect that. So we will come back to it in a moment. Okay, so tell me what stands out to you. What are you thinking about each of the things that they brought up? There were a few new things that we heard, like that were the first time for us hearing a few things. Hold on, let me go back to my notes. I gotta take notes while I'm doing this because my brain's working like the temperature. Okay, the temperature of the cell phone battery. Let's talk about that for a second because that's new this time around. We did not have that information during the first trial. So that's something that we are going to hear. And Brennan talked about it in his openings for the prosecution, talked about that a good bit, about the different cell phone battery temperatures as the evening is progressing. So that's something that we're going to hear out of this case in chief that we did not have access to in the first one. How we have information this next second trial that we didn't have the first is mind-boggling to me because I don't understand how that can even be a thing, but whatever. They're going to go over that. So that was one thing that they said during the prosecution's opening that they will be talking about. And he did give a little bit of the Lucy's on the move. Lucy's on the move. They did give a little bit of that timeline that they're going to be going over for that one. The part about driving, let me go back to where I wrote it down. He said she drove 34 feet forward and then put it in neutral and then reversed toward him. Some of that was a little bit different than what we've heard the first time. Tell me what y'all think about that, because that is the first time we heard that it was, 62 feet in reverse and all that stuff. Hearing the 75% acceleration and some of that stuff was a little bit, some of that stuff is new. They do say that they have more information this time from black box stuff that they didn't do. Remember, we had the motion to redo the testing and redo the black box stuff. So they did all of that last year towards the end of the year. So we will be hearing more about that this time around, which is interesting. Marie Moss, our official statistician, tells us that the Commonwealth's openings were 52 minutes and the defense's openings were 46 minutes. So very interesting. It's going to be so different. It's going to be so different. Put it in neutral to reverse. Yeah, he said she put it in neutral and then put it in reverse. I want them to explain more of this to me because I don't understand why, if she's so angry, why she would pull forward and then put it in neutral and then put it in reverse. So I'm going to need to hear more information on that. If I'm really mad, like neutral is not like that's not an angry woman's setting, neutral. So I don't know. I'm going to need for them to kind of explain that a little bit more. We'll see. The defense, I think one other thing from the Commonwealth, he said that we're going to hear from Peggy O'Keefe, John's mom. She did not testify in the first trial. We heard from Paul, which is obviously his brother, and then we heard from Aaron, which is his brother's wife, his sister-in-law. But we did not hear from Peggy O'Keefe. So he said this time we are going to hear from Peggy O'Keefe, that when they were in the hospital, she asked what happened as Karen was screaming, is he dead? Is he dead? And then she asked what happened. And he said that Peggy will testify that Karen then became stoic. So we'll see what they have to say about that. All right. As for the defense, I think the biggest thing on this, like the biggest bombshell on this part, as far as new stuff goes, is this new doctor. Now, this new doctor is going to testify that John O'Keefe did not suffer from hypothermia because there was no evidence of cold-induced injuries to his organs and no frostbite. If I had $1 for every single time somebody emailed me through like email or website or DMs or anything and asked like, how was there no like frostbite? I have heard that time and time and time again. And all I can say is, I'm not a doctor. I talked to my brother who's a doctor and asked him about it. I'm not a doctor. I can only give you, what other people are telling me, because that was something I was always curious about. So it's very interesting to hear that that's going to be brought up in this trial. So that's a huge bombshell, a huge thing that's different this time around. This doctor is Dr. Lapasada, is going to say that the injury to the back of John O'Keefe's head incapacitated him immediately, and that the injury could not have come from a flat surface like the ground or from hitting the ground, which is what the Commonwealth is saying, and that because there was no evidence of damage due to the cold or frost, that he was actually injured in a warmer location and then moved there. That is going to be totally new. First time hearing this, and I'm really curious to see what that says. The medical experts and the crash reconstructionist are the two that I'm the most interested in, just because that was the thing from the very beginning of this, that none of that made sense to me. Like looking at those injuries, especially the part, and Jackson hammered home on this, not even a bruise. Not even, I think he had like one tiny little bruise on like the side of his knee or something, but it wasn't like a got hit by a car bruise. It was like a previous bruise or whatever. But that was one of the biggest issues about all of this to me, was how does that car hit somebody and not have any kind of damage in order for it to do it? Just none of it made sense. In order to bust that taillight, that was one thing that I said in the first trial as we were going through it. I need them to explain that to me, because none of that seems to make sense to me. And I said, if they can't make that part make sense to me, then I'm not going to be able to ever get past reasonable doubt, because this is, and Jackson even said it, this is one of those cases that is just, there's reasonable doubt at every corner because of so many issues with the case, so many issues with the evidence, so many people, that have connections that shouldn't have been involved in this, so many issues with how evidence was handled. There's just so many issues with this. And so I'm really excited to hear that part, because that is going to be very different. Sorry, I'm going to put it back on the OnlyFan in just a second, but Um, it's kind of blinking. I'm texting. How are there no light shards in his arm? That's another thing that has kind of been one of those issues. So they talked about the DNA on the taillight, right? Brennan brought it up during the prosecution, and Jackson made the point of, okay, yes, there is taillight, or there's DNA, on the taillight, but it wasn't just John's. There was also 2 other male DNA profiles that were found on there that are still unidentified. And it was not on, here's the thing. If the DNA on the taillight had been, like hair with, like not just like one lone hair that somehow made it through the storm as it's being towed, however far away. If there was, have you ever hit a deer? You know how like when you hit a deer, there's like you'll see like the deer hair, but it's like there's clumps of like blood and stuff on there too. If it were a situation like that where there was DNA coming from some sort of evidence that showed some kind of interaction, that would be a whole different ballgame. I think it would be a totally different situation for, for both sides, for the prosecution and the defense. But that's not what we have. We have the DNA of 3 different males, including John O'Keefe, who obviously that's his girlfriend's car. His girlfriend is at his house all the time, parking that car at his house. It's not surprising that his DNA is there. If it had come from a source like, like blood on the taillight or something like that, I think even that would be a lot more solid evidence. But it was just his DNA and 2 other dudes' DNA on there. And that's not like a slam dunk type of thing. That's just like yeah, of course his DNA is on there. They're always, together. They're like, that car's always at his house. So that's not surprising. The other thing is the blood. Like if that taillight had caused the injuries to his arm, I've always thought, well, shouldn't there be some kind of blood or skin cells or something right there, like on those, pieces? And, there's none of that. So that part has always been one of those reasonable doubt issues for me as well. I feel like in order to do that kind of damage, that would have left some kind of evidence of doing that kind of damage on the car. And, we haven't seen any of that. So that's something that I've always questioned. The little hair that could, that hair has been one of those things that everybody's also confused about. Here's the thing. If the hair was, and some people are like, well, it froze to the car. But remember, she parked the car inside the garage when she got to John's house. And then and at that point, it wasn't a blizzard yet. This is like when the snow had started falling. So I don't know how a hair could have frozen to the car in that short of time. I am not a hair freezing on a bumper expert, but just as a layperson listening to this, that part always kind of didn't really compute with me, because it's just one hair and it's on the bumper, but then she parks the car in the garage. So the bumper is in the garage. So any of that light dusting that had started, you wouldn't expect it to be, frozen solid on there, like stuck in an ice cube. And then all of a sudden it melts at the Canton Sally Port. And here we have the little hair that could. She went to John's house first, parked in the garage, then, went driving around that morning, then drove all the way out to Dighton where her parents live. And then it was, the car was taken to the Canton Sallyport, which is what I can't remember what hour-ish away. I can't remember. Don't quote me on that. I've looked it up 100 times, but it's one of those details that I can never remember the exact moment. So somewhere it ain't a little hop, skip, and a jump down the road. So it makes it all the way back again. And at this point now, it really is like, snowing really hard, blizzard conditions, and then somehow it's there. So that part has always just been so weird to me. Again, I am not saying, ooh, somebody planted it. I am saying that doesn't make sense. I am not trying to solve this case or figure out who did what. I am trying to weigh the evidence and see what makes sense, what doesn't, what is more concrete than other things, what I have questions about still. And that is one of those things that I have questions about. So that's me personally, but let me know what you think. I am also, I see some of y'all talking about the 5 male DNA profiles on his shoe. So yeah, that's something that that Jackson is saying, that could also support this theory, or that he says that does support this theory that John O'Keefe was injured somewhere warmer and then was moved to this location. And then also, of course, Lucky the snowplow driver. We will hear from Lucky the snowplow driver. Now, this is the perfect example. These openings that we just heard are the perfect example of how you can have two sides looking at the same evidence and coming up with two completely different scenarios and telling you that the evidence will support their scenario. Both sides are looking at this saying, yeah, we've got all this evidence we're about to show you, and it's going to prove this thing. When you first hear the prosecution's opening, when they finish their opening, you're supposed to look at it like, oh yeah, like if that's what the evidence is going to show, this is a open and shut case, right? But then the defense gets up, and if it's a good defense attorney, then you should end their opening by going, now wait a minute, maybe it's not so open and shut. Maybe there is reasonable doubt. Maybe, maybe I should be looking at, other options. Sometimes, as much as you're not supposed to, we can see this a lot. Inherently, people will go into the situation with somebody who's in the, defendant's seat and say, okay, they're there for a reason. So if they're there for a reason, I'm here to be part of justice and to, help put away the bad guy. But is that really, is that really how the Constitution is supposed to work? No, we're supposed to go with presumption of innocence. We're supposed to say, if you're saying that this person did it and you want me to put them away potentially for the rest of their life in prison, you're going to have to prove that I'm doing that for a good reason. And if you can't do that with the evidence, then you have to acquit. So, so we'll see. Very, very interesting. Beto just pointed out that Nuttall, who Hank says heard I hit him, also testified that OJO was wearing a heavy coat. Yes. So this happened in the first trial. And this is one of those things I kind of hammered this in the podcast episode that I did on this last year, because the first responders got a lot of pushback last year because there were some things that, that they are testifying to now that were not in their reports. There were some things that had changed. There were some things like this, like, Nuttall said he remembered a heavy coat having to, I think he said he had to cut it off of them or off of John O'Keefe or whatever it was. Obviously there was no heavy coat. So one of the things that I wanted to make a big point about this last year when we were talking about this is that this does not mean that these witnesses are getting up there and lying. What this means is that these witnesses are focused on saving a life. So that's what their concern is when they're going into it. They are not going into this thinking about like, oh, this is a potential crime scene and I need to preserve it and I need to keep, every piece of little detailed information in my mind that I can. That's not what they're doing. And that's not what we want them to do. We want them to be focused on saving lives, right? That's what they're there for. the thing is, when you are so focused on that, and even if you're not focused on it, even if you're just wandering around, not focused on anything, just, chewing bubble gum and, like listening to podcasts, it doesn't matter. Whatever the situation is, if the more time that passes, the less your memory is going to be concrete, right? Like that's number one reason for wrong confessions, or I'm sorry, for wrong convictions is, fallible memory. But also the testimony from these first responders, they've said that, they've sat around the firehouse talking about this case. They've sat around talking about this. There's this phenomenon called implanted memories. And you can say, like, let's say you and I are talking about something that happened, 3 years ago, and I tell you my memory of it. It's this weird psychological thing that can happen with your brain to where my memory and what I say can become part of your memory too, especially the more times you retell a story or the more times you talk about it. Having outside information from a situation can change your story, which is the entire reason that they usually separate witnesses when they are, interviewing them, because they don't want somebody else's story or recollection or memory to become part of yours. So that's why they do that. Now, having said that, I personally feel like, based on what I have seen from, because I have read every statement there is, I have made a timeline on every statement there is, I have looked at who, if anyone, was driving the ambulance and where everyone was sitting and where everyone was standing and all of these other things. I've gone through all of that for so in depth for so long. My personal theory on this is that McLaughlin was the first one to say that she heard that. It was testified to in the last trial that she then went to the ambulance and told that to Flamati and Nuttall. I personally believe that when she told them that she heard that, if that's what happened, that could have been a point where, now their memories are kind of altering, which is a very common thing. It's not anything that anybody does wrong. It's just, but my theory is that could be potentially when that changed, or as they're talking about it at the fire station, because we heard in the last trial that they talk about this. It's a big case. It's, one of the biggest things that has happened around there. So I think that it is very possible that as they're talking about it, their memories can, kind of change. So we'll see. That's, it'll be interesting to see what they remember this time. But yeah, he does remember the heavy coat. And I think that's also a great example of pointing out that memory is not concrete evidence. And we can remember things that aren't true and aren't real. And it's not a nefarious thing, nefarious, as Brennan would say. So we'll see. John O'Keefe had his coat on because the pictures were through it. I don't know what that means. That is what a report is for, detailing everything. Yes. Oh, if only. And that's been one of the biggest issues with this case, though, is that the reports were not as detailed as we would like for them to have been, or would like for them to be. But, all we can hope is that those are lessons learned, maybe. Now they know better, maybe. Hopefully. I wonder if allowing the jury to go to the site this time will make any difference to them. What's interesting about that is I've heard from so many people who have gone by there or seen it in person, and they're like, it is so much smaller than what it appears in those pictures, because those wide angle pictures and, you know, Google Maps and stuff is kind of hard to see. But even if somebody's driving by there and they record it, we've seen those floating around. I think it makes a difference, especially when it comes to you know, not being able to see him.
Put us back in session. You may be seated.
All right, Mr. Brennan, your first witness, please.
Thank you, Your Honor. The Commonwealth calls Timothy Nuttall.
Okay, so this is one of the first responders.
Raise your right hand. You solemnly swear the evidence given to the court and jury in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help you God. Sir. Thank you. You can take a seat.
Sir, could you pull the microphone down a little bit closer to you, please?
Yes, sir. Or yes, ma'am. Excuse me.
He was the fifth to testify in the last trial.
Whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury?
So my name is Timothy Nuttall. I'm 28 years old. I've been a firefighter paramedic ever since I graduated high school. I graduated in 2015. I took my EMT class and got my certification while I was actually still in high school. From there, I moved on to the BLS transfer side of EMS. There's 911 EMS, and then there's transfer, which is basically back and forth from hospital to hospital. I was brand new and very young, so I started on the transfer side, kind of learning the job. I started primarily in the city of Chelsea, Everett, Malden, Somerville, up there. And then after a little while, I got my feet wet in the 911 side. So I was running BLS 911 in those cities as well. And then I progressed on to become a paramedic. So
Why do you have such an interest in being a first responder at a young age?
I kind of grew up in a first responder household. My father was a firefighter in a local town. So we spent kind of a significant amount of time at the station when he was on shift. It's just kind of how I grew up, kind of learning the ins and outs of public safety. That's just kind of how I came to be interested in the profession, and then I took it from there. So
I want to take us back just a little bit. When you first became interested in training to be a first responder, did you share with us your first training was as an EMT?
Yes, sir.
Can you share a little bit with the jury what that entails?
So to become an EMT, like there are two sides of EMS, and then there are two sides of providers. There's EMT basic, and then there's paramedic. To answer your question, sir, to start as an EMT, it's about a 4-month process. You take classes. I believe mine was Tuesday, Thursday, every other Saturday. Learning just anatomy and physiology, basic pharmacology, and kind of how medications interact with the body and different disease processes. From there, you start learning basic interventions, backboarding, C-collars.
As part of your work in learning to be an EMT, are you active in the field?
The initial training is, that's mostly classroom based, but once you sit your national written test and you're able to pass all that and pass practical, then you're able to progress into the field.
And did you succeed through the EMT training?
Yes, sir.
At that point, did you decide you wanted more training? You wanted to proceed through the profession?
Yes, sir. So after a little while, I worked for about 1.5 years in the field and decided that I genuinely enjoyed the work that I was doing. I then made the decision to progress to the paramedic level. That's a significantly more challenging academic portion. And
can you briefly share with us a little bit of the training that you needed to complete to be a paramedic?
Yes, paramedic training is about, I would say, generally takes people about 2 years to complete. There's about 1 year of classroom. It delves far deeper into not only diseases, but how they interact with multiple body systems, multiple different treatment modalities that we can pursue, multiple different interventions, a whole host of medications, far more medications than a BLS. As a paramedic, I have a much wider range of drugs that I would be able to select to treat different patients.
As you worked through your training and got this experience, did you ultimately become employed by the Canton Fire Department?
Yes, sir.
What did they hire you as?
They hired me as a firefighter paramedic.
And so you were both a firefighter and a paramedic?
Yes, sir.
Does the Canton Police Department, in their units, do they include paramedics and firefighters in the same division?
The Canton Police Department or the Canton
I'm sorry, the Canton Fire Department.
Canton Fire Department, the vast majority of the employees of the Canton Fire Department are paramedics. I believe there are I want to say 5 EMTs, but now as a requirement to remain employed by the Canton Fire Department, you have to become and maintain a paramedic certification.
So when you would go to work as a firefighter or paramedic, was it always the same, or did you get assigned as a firefighter one night and a paramedic a different night?
So we would cross-man trucks. We were always fire suppression personnel, but we were also cross-trained as paramedics. So for example, if a fire call were to come in the town of Canton and I was assigned to ambulance 1 for the day, I would take all my equipment off ambulance 1 and I would transfer it to ladder 1. And then we would take ladder 1 to the fire call and operate as fire suppression personnel. If a medical call were to come in, I'm assigned again to ambulance 1. Then we take on the role as EMS. I take my paramedic skills and put them to work in the town on ambulance 1.
Let me ask you one more background question about how the Canton Fire Department works. When there's a call, an emergency call, is an ambulance sent with other vehicles or alone to the call?
Yes, sir. It's typically the engine of that district and the ambulance of that district. Depending on call volume, that can change. But if all is not to use the word quiet, it's kind of a taboo word, but if all is everybody's in quarters and there's a dispatch in District 1, it'll be Canton Engine 3 and Canton Ambulance 1, and they go as a unit together.
Mr. Nuttall, I want you to take us back, if you would, to the early morning hours of January 22nd, 2022. I want you to bring us a little bit before 6 a.m. Do you remember what you were doing?
Yes, sir. So that particular morning, I arrived at work earlier than I normally do. There was inclement weather that morning. So I left earlier than normal just to get in before the roadways got particularly difficult to travel and to relieve anybody that may need to get out if they needed to get home before the roads got particularly bad. I arrived just before 6 a.m. I was walking in. I was assigned to ambulance 1 for that oncoming 24. I was scheduled to be there at 8 a.m.
Could you share with us a little bit about how the weather was as you arrived around 6 a.m.?
It wasn't great. I was driving. It's about a 35-minute ride for me to get to Canton. The roads were starting to they weren't great. They had been treated, but they weren't pristine. The wind was starting to pick up. The snow was starting to come down a little heavier, which is the reason that I left at the time I did.
And so I may have misspoke. January 29th, 2022, that morning, around 6:04, did you hear a tone or did you hear an alarm?
So the tones went off right as I entered the building.
Tell us what a tone is.
So the tone is the emergency alert tone. In the town of Canton, we have 3. We have 1 for fire, we have 1 for investigation, and we have 1 for EMS. The EMS tones went off and the lights came on. Whenever there's the tones go off, the lights come on as well. I was just walking into the building when the tones went off and the lights came on.
And is there information that accompanies the tone, information about the call that needs response?
Yes. So after the tones had cleared, there's an overhead dispatch, which is our dispatch center, communicates to us before we get in the trucks and on the air responding. basic nature of the call. In that particular instance, we were dispatched to an unresponsive male in a snowbank with no real further information to follow up on.
So what do you do?
So as I said, I arrived pretty early that morning. But hearing that dispatch and that nature of the call, those typically tend to be more involved, both personnel-wise and work-wise. The crew that was working that morning was getting on the truck, and it was firefighter paramedic Anthony Flamati and firefighter EMT Matt Kelly. Matt Kelly has since become a paramedic, but at the time he was an EMT. So off the bat, that crew, not to say that they were at a disadvantage, but paramedic Flamati was the only paramedic on that
So
ambulance.
what did you do?
So I made the decision. I checked with the shift commander, and I jumped on ambulance 1 to just give a second set of hands as being a paramedic myself, just being able to hopefully help if there was any advanced interventions that needed to be done or needed to be performed.
What
And
happened?
just a second set of hands.
What happens next?
So I got in the back of the truck. I was actually still in civilian clothing at the time because I had just walked in the door. So I got in the back of ambulance 1 in the patient compartment. The other 2 gentlemen were up front driving to the scene. I actually had to don my turnout gear because, again, I was in civilian clothing. I wasn't quite ready to go. So I had to put all my structural turnout gear on and then my Canton fire jacket. Once I was sufficiently dressed for the call, I started prepping all the gear that we might need for a call such as that, for an unresponsive male in the snow. In this case, it was our first in bag, our airway bag, and our cardiac monitor. Everything was all together. They were all in 3 separate bags. But on the way there, I just got in. I didn't know how their night had gone. So I just took a real quick look at everything just to make sure everything was there and everything was exactly how it needed to be. So I was able to just grab all 3 bags, put them on my person, and get ready to, so as soon as the ambulance was on scene, just step off and go to work.
Not knowing much information about what you're going to confront, what goes through your mind as you prepare before you get off the ambulance?
Just basic scenarios. I mean, again, unresponsive male in the snow could mean several things. Not having much to go off on the dispatch was, it left much to be desired in terms of what we might need. So in gathering all the equipment together, that can kind of cover all the major bases, if you will, in terms of what we were expecting to meet once we got on scene.
How was your focus before you get off the ambulance?
I was ready to go. A dispatch like that, any unresponsive male in the snow, it can kind of up the level because you just don't know what you're walking into. You know, it could be anything.
In the back of the ambulance, you can't see outside. Could you tell anything about the weather conditions based on the way the ambulance was moving?
Again, being in the back, as you noted, it just seemed to be taking a little bit longer than normal. I really had no visibility at all. Like I said, I was in the patient compartment. It's very limited visibility in the back, and it's limited visibility. There's like a peephole that's maybe 1.5 feet by 1.5 feet to kind of peek up front. But again, I was so busy getting everything together, I really didn't notice, but I did note it took a little bit longer. We were going not slow, but we were going cautiously.
When the ambulance finally stopped and the doors open, tell the jury what you see.
So as I mentioned, I had the 2 bags and the cardiac monitor. So 3 pieces of equipment with me. And I stepped out of the back or the side of the truck. There's a back compartment or a back door and a side door. I stepped out of the side door. And I immediately noted the wind had picked up and the snow seemed to be heavier. And I could hear like a distant screaming off in the distance. Wasn't exactly sure where it was coming from.
What was the visibility like?
It wasn't great. It was still dark out. The sun had not come up yet. The snow was coming down, as I said, heavily. And it wasn't great all around.
Was it cold?
It was cold. Yes, sir.
And so when you hear the screams, what do you do next?
I started making my way kind of towards the sound, following the sounds. I couldn't see anybody yet. So I just kind of followed the sounds. And then once I was able to get around the side of the truck, that's when I was able to see a group of 3 individuals with Canton police and I started making my way over to them to see where the patient might be located and what was going on.
As you get closer, tell us what you see.
So as we approached the scene, as I said, there were 3 individuals, and Canton police were on scene as well. And then there was what appeared to be a human figure laying supine in the snow. I'd say about 6 to 8 feet, kind of where the sidewalk met the front lawn of a residence.
What does supine mean?
So he was laying on his back. From there, I made my way directly over to that individual and started checking for signs of life.
How do you check? Do you get close? Do you get down on the ground?
Yep. So I knelt right at his head. Typically, to check for any signs of life, it's just as you see in TV or anything like that. You check the carotid pulse, and you check for any signs of breathing or anything like that.
Where's the carotid pulse?
So the carotid pulse would be right in the neck. Like just real quick, 2 seconds, you can check either side. They're on both sides. Those are the strongest pulses that you can grab quickly. So I just real quick went right to that gentleman. Like I said, I looked for any signs of breathing. I found none. I checked a carotid pulse, and I found none.
How was his skin to the touch?
He was very cold to the touch.
He wasn't warm?
No.
So after you touched his cold skin and you felt the carotid artery? Is that how you
Yes, sir. Carotid artery.
Did you come to any initial quick assessments or conclusions in your mind?
So I found, like I said, I checked for signs of life, the carotid, the signs of breathing. I found none. From there, we had ascertained that there is no signs of life. As I was checking that, the other 2 individuals on the ambulance came and met me, and they began doing the same thing just to check. Sometimes you can look and you can miss. So the other paramedic, Anthony Flamati, started checking my work, and then we kind of went from there. But I found no signs of life in my initial.
So firefighter paramedic Flamati arrived to this person after you did?
Yes, sir. I was the first one to actually put hands on the individual and check for signs of life.
Did you later learn the name of this man?
I did.
And what was that?
John O'Keefe.
After you found no signs of life for John O'Keefe, did you get up and go to speak to anybody?
I did. So as being a second set of hands on the call, it's really not my call, like in terms of treatment modalities and how we want to progress. So after I found no signs of life, I kind of got up to kind of look around real quick. I went over to the individuals, the 3 individuals that were there, and just said, hey, I just have found no signs of life. We're gonna see the next steps. And as I was saying that was when Anthony Flamati, who is the lead paramedic on this, made the decision. This is a workable cardiac arrest.
Let me ask you 2 questions. The first is, as a paramedic firefighter, are there times when you're the lead paramedic on a call?
Yes, sir.
And so it changes call by call, but this one was firefighter or paramedic Flamati's lead?
Correct. He was the lead paramedic on this call.
There are other times when you're the lead and firefighter or paramedic Flamati is on your crew and you lead?
Yes, sir. So we typically switch off. We'll do one, and then once my rotation is complete, we'll do the next one. So it's patient for patient, typically.
When firefighter paramedic Flamati called you back and said it was a workable situation, can you explain to the jury what that means?
Yes. So in medicine, there is a term that is, you're not dead until you're warm and dead. Meaning your core temperature, your core body temperature has to be within normal limits for it to be considered a futile attempt at resuscitation. Noting that, Tony, the other paramedic, Tony Flamati, realized that this gentleman was very cold to the touch and that this was now a hypothermic cardiac arrest, or a cardiac arrest in a hypothermic setting, which means as providers, we have a duty to initiate life-saving measures, CPR, ventilation, and continue those efforts until we get him to a hospital and a physician is able to take over and they are able to monitor his core body temperature for a certain amount of time.
I want to ask you about a term you used. You said a hypothermic situation. as a firefighter paramedic treating a patient at the scene, you're not diagnosing hypothermia, are you?
No, sir.
So you're not making a medical diagnosis. You're just saying it's a hypothermic situation because of why?
Just because of the conditions. He was extremely cold to the touch, and he was in the elements. We didn't know how long. So taking the fact that he is extremely cold to the touch and he had been outside for an unknown amount of time, that quantifies it to us as a hypothermic arrest or a cardiac arrest in a hypothermic setting.
Is there anything about Mr. O'Keefe's fingers or hands or his face that gave you any indication if he had been there just recently or had been there for a while?
His fingers were quite cold. They were not well perfused at all. They were very, very.
Mean? I don't know. What does not perfused mean?
Sorry, there was did not appear to have been any blood flow at all. Just because he was, again, presumably being outside, his fingers were very, very white. They were very stiff, which can be signs of hypothermia and frostbite. And again, touching the neck. So typically when you get cold, you kind of work back from your extremities in. So again, I noted his fingers were quite cold, but also when I checked his carotid, his neck felt quite cold as well. That just kind of tipped us back further down the road of a hypothermic cardiac arrest.
I see. When firefighter Flamade called you back,
yep,
where did you go exactly?
So when I was told that this is what we're doing, I turned around and I went right back to where I previously knelt, which was right at Mr. O'Keefe's head. And then I took over the ventilation aspect of a cardiac arrest. So I was in charge of the airway. So I began giving him positive pressure ventilations with a bag valve mask, which is just a glorified balloon that you can push oxygen through and down into your respiratory tract to get oxygen moving. While I was doing that, I believe firefighter EMT Kelly had begun CPR.
So is this fair to say it's a team effort?
Yes, sir.
A coordinated effort?
Very much so.
And depending on where you're placed, whether in the back of the ambulance or driving or leading, does everybody have an important role to play?
Yes. Yeah, we work in conjunction with each other. Typically, the most well-defined roles in a cardiac arrest in EMS is your airway monitor, which was myself in this situation, and then your cardiac and medication administration, which is, that would be Anthony Flamati, that would be Tony. Just because of my position at the head, I just took over the ventilation aspect, and that was where I remained throughout the call.
You said you went back to try to help Mr. O'Keefe, and you were helping at the airway. Do you have to actually get on the ground to do that?
Yes, sir. I was kneeling at his head.
While you were kneeling at his head, well, let me ask you a more of a background question. Is it helpful to get information about the history of the person when you're trying to treat them when you happen upon a scene and you don't know the history?
Yes, sir. Very much. Getting information on medications, history, and allergies is our top priorities in any call, not even this call, just really any your run-of-the-mill fall or chest pain. Typically the first questions that we ask: what medications are you on? What medical history do you have? And do you have any allergies? The medical history is important because if you've had heart attacks in the past, or just using a generalized example, if you've had heart attacks in the past, does this feel like a previous heart attack? We kind of gives us something to go off of.
As you were nailing, I want you to take us to that moment. As you're nailing, trying to help Mr. O'Keefe, did you have a chance at any point to look up?
I did.
And when you looked up, when you were trying to help Mr. O'Keefe, can you tell us who you saw?
I saw a middle-aged middle-aged female with blood on her face. And I, real quick, as I was in the process of providing ventilations, I said, do you know this person?
The person that you looked up and saw that was standing over you with blood on her face, do you recognize that person in this courtroom?
Yes, sir.
With the court's permission, sir, could you point out that person that you looked up and saw?
In between Mr. Jackson or next to Mr. Jackson.
I see. So when you looked up and saw that person, and asked about any background, what did she say to you?
I hit him. I hit him. I hit him.
How clearly do you remember her words saying to you, I hit him, I hit him, I hit him?
I remember it very distinctly.
You've been to a lot of calls over the years and since.
Yes, sir.
Would you say hundreds or thousands?
Thousands.
Do you remember all of them?
I remember aspects of various calls, but not all of them, no.
Do some stand out more than others?
Yes, sir.
Did this particular moment stand out more as compared to your typical or most calls that you've been to?
It did, just because of the setting. I mean, it was the weather, it was the unknown factors, and it was the attempting to try and get information and not really being able to glean anything from that.
After the defendant said to you, I hit him, I hit him, I hit him, did you ask any follow-up questions?
I really didn't get a chance to, because following that, the individual just kind of walked away, or just kind of went in a different direction. I wasn't able to ask any follow-up questions.
Have you ever received any police training?
No, sir.
Are you a police officer?
No, sir.
When you're helping a patient, do you have any interest in detective work?
No, sir.
Do you have any interest in investigating potential crimes?
At that time, in this particular instance, because I was at the airway, that is a pretty critical aspect of a cardiac arrest. I was stuck there. I couldn't get up and kind of follow up on that at all. I was there doing that ventilation.
Is it your job to investigate cases or simply to get information to help treatment?
Just the information.
When you go out as a firefighter paramedic, do you have a purposeful cause?
Yes, sir.
And what is that?
To save lives.
And is that your only focus?
In this instance, it was attempting to restore circulation and breathing.
At some point with your colleagues, did you lift Mr. O'Keefe from the ground?
We did.
When you lift him, what do you put him on?
So we put him on, it's called a scoop stretcher. It's basically just a hard plastic moving device with some seatbelts on it, just to get the patient up and onto the stretcher. And then from there, we can move from the stretcher to the ambulance.
After you lift him to the stretcher, tell us what happens next.
So we put Mr. O'Keefe on the scoop stretcher, and we were able to get him onto the stretcher itself and then off to the ambulance. From there, I maintained my role as the airway individual on this call. So we made our way to the ambulance. I got in the tech seat, which is directly behind where the stretcher locks in. So I had access to the airway again. I was continuing to provide positive pressure ventilations to Mr. O'Keefe, and we had put in an OPA as well, which is just a plastic hook, if you will. It just keeps the tongue from falling back into the airway, so we can continue to provide positive pressure ventilations. Once we got him in the truck and we continued that effort, we set up a suction system and we prepared to intubate Mr. O'Keefe. We prepared a suction system just because as I was ventilating outside of the ambulance, there were some secretions in the airway that I could see, and you could kind of hear it as you go to squeeze in breaths into the individual. You can kind of hear the secretions kind of getting like bubbly and stuff like that. So we knew we were going to need to suction him. So we got him in the truck. We really quickly suctioned him, and then we were able to intubate him successfully to definitively give him an advanced airway and give him better ventilations, get more oxygen into his system.
Now, you mentioned that he wasn't warm, he was very cold.
No, he was still very cold.
What does the team do to try to assist with that?
The most basic thing that we did, we turned the heat on as high as it would go. We also stripped all of his clothing off, just getting all of that wet clothing off of him. I didn't really have a role in that particular part of it, just because once you're on the airway, that is kind of yours. Nobody can breathe for him. So every time I squeeze that bag, he gets a breath. So I'm kind of tied to that airway for the duration of the call.
So when your colleagues are stripping the clothes off him, is your attention on the clothes or more on the airway in your job?
No, I'm maintaining the airway. If an endotracheal tube is dislodged for whatever reason, it is typically more difficult to get one in. So the integrity of that tube staying where it is and not being dislodged, that is another key aspect of airway management.
As you're doing that, do you notice what anybody else, any of your colleagues are doing to help?
Like I said, they were working on clothing removal. I believe they were also getting intravenous and intraosseous access on this individual to begin medication administration. But again, I was quite focused on that airway, just making sure that it was maintained and we didn't lose any tube. We didn't lose any end-tidal CO2, which is just another monitoring device that we use to confirm that that tube is in place.
How quickly do you get to leave the scene and start moving towards the hospital?
I honestly couldn't give you an accurate estimate. It didn't seem to be out of the ordinary realm, though. We were able to move within the flow.
In addition to Mr. Keefe being very cold, did you notice any other injuries on him?
So I noted that he had a hematoma right above his right eye.
Could you explain to us what that is?
Yep, it's just, for lack of a better term, it's just a big egg. He had a pretty good bump over his eye.
And you said his right eye.
Yes, sir.
Did you know how that hematoma was caused?
No, sir.
No idea?
No.
In addition to the hematoma above his right eye, what other injuries did you see?
There were also several scratches on his right arm, just below his shoulder and traveling down his right humerus. They terminated right about his right elbow, just above it.
Those scratches, have you also described them as abrasions?
Yes, sir.
Is there any difference in your mind, difference between scratches and abrasions?
Nope. These were they were deep and they were not bleeding, but they were notably deep.
Did you ever describe it as furrows?
I did.
And in describing those scratches, do you have any idea how they were caused?
No, sir.
Okay. And did you notice any other injuries on Mr. O'Keefe?
No, sir. Those were the only ones that we noted. As I mentioned, we suctioned a little bit of blood out of the back of his airway as well. I believe it was blood mucus, and saliva. But those were the extent of the injuries that I was able to note.
Did you notice anything about the back of his head?
Actually, yes, I did. I apologize. There seemed to be a little bit of matted blood around in his hair around there. Really didn't see anything too obvious at the time. He was also placed in a cervical collar as well, following intubation, and that was kind of there just to maintain his cervical spine. But there was, like I said, there was noted to be a little bit of dried blood on the back of his head.
At some point, did you finally make your way with Mr. O'Keefe to the Good Samaritan Hospital?
Yes, sir.
And just share with us what happens when you get there.
So after we got there, we handed off care to Good Samaritan Medical's physicians and ER nurses. We were able to give a report to the physician of just basic what we've done, what we've given for medications. In my case, what he was intubated with and how he was being ventilated, how well he was being ventilated, and any other further pertinent information. Typically, we noted that Tony was the lead paramedic, so that is typically he kind of holds the room for a minute when we get in there and gives a big rundown, and then we back off and let Good Samaritan take over.
When the defendant told you that she hit him, did that have any significance to you?
No, sir.
Did it reconcile with the injuries that you saw before you that Mr. O'Keefe was suffering from?
No, sir.
And so at that point, was that information insignificant in perspective of your care?
Sustained.
Okay. What role did that information play in your care after the defendant told you she hit him? How did that contribute or not contribute to what you were doing?
It really didn't help at the time. Again, I wasn't able to chase anything down from that. I just kind of took it, noted it, and moved on with my aspect of the cardiac arrest.
Have you had an opportunity at any point to see any video of that morning taken from any source, a police car, dash cam?
Yes, sir.
All right, I'd like to introduce a video stream.
So this will be in evidence? There are agreements with some of the evidence already?
I believe there's no objection, but I don't want to speak for the defense.
There's no objection.
Okay, thank you. Yes, you can show it.
And for the record, if I may note, this is Cruiser 683 Stream 2. I'm sorry. It is Cruiser 683 Stream 2. I'm going to ask to play a portion of it that's relevant to Mr. Nuttall. Ms. Gillum, if you would please move to 6:11 a.m.
Okay. We'll talk about it more in a minute, but there's that what he just said about hearing I hit him is different than previously what has been said. So we'll talk about that in a minute. That has changed.
Please stop the video. Mr. Nuttall, do you see the red lights reflecting on the left?
Yes, sir.
Do you know what those red lights are?
Presumably those would be ambulance 1.
Yeah, so not what you presume. Do you know what they are, sir?
And those are the lights for ambulance 1.
Do you see the weather conditions as it's depicted on this video?
Yes, sir.
As you stood outside, was it same or different to how it appears in this video?
That is the same.
When you look to the left, you see a straight line about an inch or two from the left of the screen. Do you know what that item is?
Sorry, sir. Repeat the question.
If you look to the left of the screen, you'll see a straight item from the bottom halfway up the picture. Do you know what that item is?
I believe that's a flagpole, sir.
Do you see a little bit of movement of bodies near that flagpole?
At the present time, no.
Okay. Could we continue to play, please?
Yep, there they are.
Could you stop,
Yes.
please? Did you see the first person in line now behind the person with in front of the person with the blue hat?
I'm sorry, sir. Can you back it up like 10 seconds?
Certainly. Keep going, please. Do you know who that person is?
I believe that's me, sir.
Okay. Could you please continue? Is this your first assessment?
Yes, sir. This is ascertaining any signs of life or breathing.
Is that you approaching?
Yes, sir.
Could you stop, please? After informing you return, is that after firefighter Flamati called you?
So right after that, when I turned around, that was when Tony said, "Hey, we're working this."
Okay. Please continue. Stop, please. And do you see a person come over to where you are?
Yes, sir.
Is it at that point or another moment when the defendant said, "I hit him, I hit him, I hit him"?
It was right there, sir.
Could you continue, please?
This is all different.
Could you stop
time
for a
around.
moment? There's no voices or noises from people coming through that audio. When you were there that night throughout the event, was it silent or were people speaking? Did you hear people speaking?
There was, as I noted when I got out of the truck, there was quite a bit of screaming. It was quite chaotic. The wind was also a factor, but there were people around. They were speaking within themselves too, but there was screaming, there was wind, and there was different side conversations as well.
And when you were working on Mr. O'Keefe, were you having conversations with your colleagues?
Yes, sir.
They're not picked up on the audio?
No, sir.
Please continue. Sir, you still at the flagpole?
Yes, sir. I'm kneeling at the head of the patient.
You couldn't hear anything except for her screaming no. Yeah, it's hard to see anything on these dash cams. They're not very good condition, and everything in front of them is wet. So it's hard to see much on these. There were plenty of police around, but there are no officers who heard her say that. Well, let me rephrase. It was not in any officer's report, and the officers that were there at the time, I think it was Saraf who was there, said
Are you included in that group of first responders?
I am not, sir. I have actually exited to the side with the bags. I believe I'm entering the ambulance at this point.
Okay. Thank you. We can conclude the viewing. With the court's permission, I'd like to approach and show a few exhibits to Mr. Nuttall. They've been shown to the defense.
Yes.
Thank you. May I approach?
Yes.
Thank you.
No objection. Okay. I'm going to show you a photograph.
Yes, sir.
Sir, do you recognize what's in that photograph?
Yes, sir. Those are the scratches on Mr. O'Keefe's arm.
Does that appear the same as when you saw his arm that morning, or is there any differences? And if there's any differences, can you share them with us?
That appears how they were to me at the time of the incident.
Okay. May I approach again, Your Honor?
Yes.
I'd like to introduce this as an exhibit, please.
Okay.
Awesome.
I'm going to hand you a.
Hold on.
I'm sorry.
Thank you.
Pardon me, Your Honor. May we publish to the jury?
Yes.
Is that the photograph you just identified on the screen?
Yes, sir.
Showing you a second photograph. I'd like to ask you some questions about it.
Can we take that one down, Mr. Brennan?
Yes, of course.
Please, Ms. Gilman.
Thank you. Does that photograph, do you recognize that area?
Yes, sir.
Is that the same or substantially the same area where you helped try to treat John O'Keefe?
Yes, sir.
Does that look to be a fair and accurate representation of the area?
It does.
With the court's permission, I would introduce this as an exhibit, please.
Okay, and there's no objection to any of these three?
None.
Okay. Yes.
Thank you.
Thank you.
With the court's permission, could I publish exhibit 2?
Yes.
And sir, that's what you recognize as the area where you were helping to treat John O'Keefe?
Yes, sir.
I've left one last photograph in front of you.
Yes, sir.
And do you recognize that?
I do.
Tell us about any differences between when you were there and what you see in that photograph.
The street appears to be plowed. There's bare pavement. The weather conditions are significantly better. It is also daytime.
If we could take down that exhibit 2, Ms. Gilman. May I approach, Your Honor?
Yes.
I would move to introduce this as exhibit 3.
All right.
With the court's permission, I'd like to publish exhibit 3.
Sure.
Is that the photo you just identified?
Yes, sir.
Okay, we can take that down. Thank you. Thank you, sir. I have no further questions, Your Honor.
All right.
Okay, so the interview he did with Proctor on February 8th was the first time that he had mentioned the I hit him thing. And he said that he heard Karen Reed saying it to another female on the scene, and that the other female said, "Be quiet." But he admitted that his memory is a little faulty during the trial. He said he admits that his memory is faulty as it pertains to the time frame. So now he's saying he specifically remembers it, but it's a different time. Now he says that she said it to him, not to another female. So that whole thing has completely changed. So we'll see what Jackson points out about it.
Thank you, Your Honor. May I?
Yes, please.
Good morning, good afternoon, Firefighter Nuttall.
Good afternoon, sir.
Nice to see you again.
You as well.
Before your testimony this morning, how many conversations had you had with any member of the prosecution team in anticipation of your testimony today?
I believe it was 3, sir.
When were those?
I could not give you dates off the top of my head.
Give me a time frame within the last 3 weeks, within the last 3 months, last 3 days.
Within the last 3 weeks, I believe one the week after that, and then one last night.
One
last night.
Last night. What you did discuss, let's take them in order. First of all, who'd you meet with 3 weeks ago?
I met with Mr. Brennan and his staff.
And when you say his staff, who else?
I honestly couldn't tell you, sir.
Mr. Lally?
No, sir.
Male, female?
One female, one, I believe, state trooper.
Okay. Had you ever met State Trooper Tully previously?
Yes, sir. Actually, I believe that was him.
It was State Trooper Tully?
Yes, sir.
Whom you've met with several times, correct?
Prior to that, I believe only once or twice.
He was the one that he has formally interviewed you previously, correct?
I believe he arranged the meetings with Mr. Brennan.
Okay.
But beyond that, I can't speak to.
What did y'all discuss 3 weeks ago?
The first meeting, going in order, it was mostly just kind of an introduction. I had not met Mr. Brennan yet. I really didn't know him. So it was mostly that, and then just kind of seeing where we were at with testimony, going over previous testimony and in that sort of realm.
Prior to today, how many times have you testified under oath concerning the incident on January 29th, 2022?
Once at a grand jury hearing and once last year.
All right. As a matter of fact, last year in this courtroom.
Yes, sir.
Okay. Did you look over your testimony at the grand jury 3 weeks ago during that meeting?
No, sir.
What about the testimony from last year?
We did go over the testimony from last year. Yes, sir.
Were there any issues that Mr. Brennan or anybody else in that meeting brought up concerning any of your testimony?
There was just a question of how many times the I hit him came up. It was 3 times.
And were you advised that that's not what you said at your testimony last year?
No, sir.
2 times?
What was that?
You said it was 2 times last year?
I honestly can't recall, sir.
Okay. But you just saw that, or you just read that and went over that 3 weeks ago?
I believe so, sir, yeah.
But you can't remember, as you sit here today, just 3 weeks ago, what y'all discussed in terms of how many times you previously testified that you heard the phrase, I hit him.
So previously testified possibly to 2, but it was 3.
Okay. Your memory is clearer now than it was, for instance, a year ago when you testified.
Repeat that?
Sure. Your memory is clearer now as you sit here that it was 3 times you heard that than it was a year ago when you testified that it was 2 times.
Yes, sir.
Okay. Does your memory get better with time generally? Your memory. I'm not talking about the royal you. I'm talking about you.
In certain settings, I mean, there are certain things about different aspects that I recall better than others.
Okay. And does your memory tend to get better or does it fade over time? That's my question.
It can fade over time, but it depends on the context.
But in this case, you're telling this jury that your memory is better now than it was a year ago when you testified about the exact same circumstance, correct?
Yes, sir.
Okay. You then met about a week after that, which would be 2 weeks ago.
Yes, sir.
Who'd you meet with then?
The same group.
And what did you discuss at that meeting?
Again, just prior testimony. And that was really the gist of it.
And tell me the specifics of the prior testimony that you.
Again, it was the how many times we had talked about saying I hit him. Again, it was 3 times. And then there was also the video that was just played for me.
If I'll take the video in just a second. If y'all had met 3 weeks ago and you indicated to Mr. Brennan that it was actually 3 times, not 2 times that you heard the I hit him, why did you need to discuss it again a week later to verify the 3 times versus 2 times?
Not sure, sir. That was just the way that the conversation went. And I just, again, repeated what I said and what I remember from that morning.
Well, tell me about that conversation. Did Mr. Brennan say anything like, well, are you really sure that she said it 3 times?
It was that morning what was said to you. And I said, I hit him. That was how it went that morning, and that was how I remember it.
Okay. And did Mr. Brennan say, well, that's not consistent with how you've testified previously concerning the number of times you heard the I hit him phrase?
Yes, sir.
He did say that.
He wanted to, he acknowledged that I had said it twice. However, again, as I mentioned, it was said 3 times to me.
So now you do remember last year that you only said it, you only said that it was repeated twice.
One more time, sir.
So now you do recall that last year when you testified, it was inconsistent with how you're testifying today. Let me put it that way, correct?
I believe I said I hit him twice on the stand last year.
Right. And if you're saying I hit him 3 times instead of twice, that firefighter Nuttall is inconsistent with your testimony today, correct? You
Yes,
agree
sir.
with that?
But that is how it went that morning, sir.
Okay, that's not my question. Let me see if I can do it again. So I'm asking you, if you testified last year,
Yes, sir.
that you heard the phrase twice,
Mhm.
and now a year goes by and you're testifying in front of this jury this year that you heard it 3 times, those 2 statements are inconsistent with one another, correct?
Yes, sir.
Okay. Did you talk at the meeting 2 weeks ago about any other inconsistencies with your testimony?
Not to my knowledge, sir.
Well, you were there. And you
No.
say not to my knowledge, meaning,
No, sir. We did not.
okay. So it was just about the number of times that you heard the phrase, I hit him, correct?
Yes, sir.
All right. You cleared that up in the 2 meetings, 3 weeks ago and 2 weeks ago. What did you talk about last night?
Mostly just making sure that everything was as it had been. I mean, and by that, I mean, it was 3 times and that we were continuously making sure that everything was the way that it had happened that morning.
Everything was the way that Mr. Brennan wanted it to be.
No, sir. The way that it was I remember it and I recall it happening.
Okay. So he asked you 3 weeks ago about how many times you heard that phrase.
Yes, sir.
You changed your testimony at that time and said it was 3 times instead of 2 times. We agree on that, correct?
Yes, sir.
Then he called you a week later or met with you a week later and again reiterated, making sure you stick with that testimony that it's 3 times, not 2 times, correct?
Yes, sir.
And then last night he called you just to make sure one more time you're going to stick with that testimony that it was 3 times, not 2 times, correct?
Yes, sir.
Just a second. May I have just a moment, Your Honor?
Yes. It doesn't look good. That doesn't look good because
Okay.
it's inconsistent.
And when you talked last night, did you assure Mr. Brennan, nope. When we come in tomorrow, I'm certainly going to say it was 3 times, not 2 times.
No, sir. I told him I would tell my recollection of that morning.
Okay. And did you tell him that what my recollection is, I'm going to tell the jurors it was 3 times that I heard it?
That was what I heard.
Okay. Did you tell him that's what you were going to say today?
No, sir.
You didn't?
I told him I was going to tell him what I remembered from that morning.
Which was what?
I hit him.
Which is how many times?
3 times, sir.
And that's inconsistent with what?
I believe a year ago.
Okay. Now, you also talked about, I want to get back to the other thing that you talked about. You said that at some point, either in the meeting 3 weeks ago, the meeting 2 weeks ago, or the meeting last night, you were shown a video.
Yes, sir.
Which one of those meetings were you shown a video?
I believe the second one.
Okay. Were you shown the entire video?
No, sir.
Just the clip that we saw?
Yes, sir.
Okay. What did y'all talk about in relation to that video?
Mostly nailing down who was who in that video.
Okay.
Being the other personnel on scene, where I was, and that was about it.
He showed you the clip that you showed. He showed you the clip that you've just seen on direct examination, correct?
Yes, sir.
Did you tell him where you were?
Yes, sir.
Did Mr. Brennan ask you to define exactly where it was that you supposedly heard this phrase, "I hit him"?
No, I was able to give that to him, sir.
Okay. And what you told him was that moment when you see my client walk over sort of to the left of the screen, correct?
Yes, sir.
And you defined that's the point at which she said, "I hit him, I hit him, I hit him."
Yes, sir.
And that's in response to your question. I want to make sure I'm clear about this. You asked, "Do you know him?"
Yes, sir.
And she repeated the phrase 3 times, "I hit him, I hit him, I hit him."
Correct.
Okay. We'll talk more about that in just a second. Did Mr. Brennan ask anything else about that specific video?
No, like I said, he kind of asked me to point out different individuals on the scene, and that was really the extent of it.
You saw that same video last year when you testified, correct?
No, sir.
You didn't see it last year?
Not to my knowledge, no.
In preparation for your testimony last year?
I did not.
Did you see it before your grand jury testimony?
No, sir.
Okay, so this is the first time that you've seen it.
Yes, sir.
And you were able to establish for Mr. Brennan exactly when it was that you believe you heard the statement based on your view about 2 weeks ago of that video.
No, that was the way that I remember it.
Right. Not a trick question. My question is much more simple. You were able to establish after 3.5 years now exactly where you were and where Miss Reed was and who else was around at the time that you believe you heard those 3 statements in order. I hit him, I hit him, I hit him.
Yes, sir.
Okay. You testified last year as well that there is a normal protocol for removing clothing from a patient, and it's essential to just discard it and get it away from the patient so that you can concentrate on the life-saving measures that you're undertaking, correct?
Yes, sir.
Here comes the jacket.
That could be done you said in the ambulance, it could be done in the hospital, it could be done in situ out there in the field, correct?
Yes, sir.
But the point is you want to get as much clothing off of the person as possible so that you can assess that person's physiology.
Yes, sir.
It's not really a lot of care taken to preserve the clothing from an evidentiary standpoint in your view, correct?
And we're trained to try and, just to take example of a shooting, try not to cut through the entrance wound of the clothing.
Fair enough. I mean, when you're literally trying to save someone's life, your job is to get the clothing off and get it out of the way.
Yes, sir.
You're not sticking it in an evidence bag and sealing the evidence bag, things of that nature.
No, sir.
So it might end up on the ground.
Yes.
Right? Might end up with some debris on it.
Yep.
Might end up in the floor of the ambulance.
Yes, sir.
Could end up in the floor of the hospital or on the floor of the hospital. Is that right?
Yes, sir.
Okay. And if it's tossed in the floor of the ambulance, the clothing may well pick up debris from the ambulance.
Oh, yeah. Yes, sir.
Or the debris from the floor of the hospital or wherever.
Mm-hmm.
Is that yes?
Yes, sir.
Okay. You testified previously at the grand jury in April of 2022, correct?
Yes, sir. I believe so, sir.
Okay. So this happened in January of 2022, that same year in the springtime. You testified at a grand jury, April 20th, I think it was.
Yes, sir.
Does that sound right?
Yes.
Okay. I want to take you back to that testimony for a second. You testified at that hearing that Mr. O'Keefe was, quote, dressed appropriately for the weather. You remember that?
Yes, sir.
All right. It was obviously well below freezing at that time.
Yes.
That night that you responded.
It was.
We just seen the video. It looks cold as hell, right?
It was chilly.
All right. The wind was howling.
Yep.
It was snowing. Is that right?
Yes, sir.
And you testified that John O'Keefe, quote, had a heavy coat on and possibly 2 other layers of clothing.
Yes, sir.
In April 2024, you reiterated your very specific memory of and you even called it a puffy heavy coat that he was wearing, which was then removed so that you could assess his injuries, correct?
Yes, sir.
All right. Not to get too colloquial, but a puffy coat is like, it's got down and stuff in it, right?
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes, sir.
Okay. Pretty distinctive article of clothing.
Yep.
And you testified last year that Mr. O'Keefe was wearing that clothing, which you had to remove or somebody had to remove in order for him to be properly assessed.
I did testify that way. Yes, sir.
Okay. And you mentioned that your memory of that big, heavy winter coat was as clear as your memory of other specifics in this case, correct?
Yes, sir.
I asked you that exact question, didn't I?
You did.
And I said, your memory of him having that big puffy coat on, which stood out in your mind, was just as clear as the other specifics that you've testified to about the case.
Yes, sir.
About that night. And turns out you were completely wrong about his clothing, correct?
Correct.
Matter of fact, he wasn't wearing a coat at all.
No, sir.
He wasn't wearing a winter coat, correct?
Nope.
He wasn't wearing a heavy winter coat, correct?
Correct.
And he wasn't wearing a puffy, heavy winter coat.
He was not.
Yet you testified that he was wearing all of that, and that was clear in your mind at the time.
Yes, sir.
Did Mr. Brennan bring that up during the meeting 3 weeks ago?
He asked about what I had meant when I said appropriately dressed.
So you did talk about something other than just I hit him, correct?
Yes, sir.
When I asked what y'all talked about, why didn't you tell us that?
To be perfectly honest, sir, I did not remember until right now.
So your memory is fading even after 3 weeks.
Yes, sir.
Got
This
it.
is
The fact is,
he's a good
well, let
attorney.
me ask a different question.
Oh,
Did
he's
Mr.
good.
Brennan tell you what Mr. O'Keefe was actually wearing
No, sir. Actually, I believe you did.
last year, didn't I?
Yes, you did.
It's a short sleeve t-shirt and a little thin wool hoodie, right?
Yes, sir.
Wasn't wearing a hat.
No, sir.
Wasn't wearing, as a matter of fact, didn't even have a shoe on, correct?
Not to my knowledge.
And obviously, goes without saying, but I'm going to ask it anyway. That's not being appropriately dressed for the winter.
No, sir.
You indicated that you did notice certain injuries on Mr. O'Keefe's person.
Sir.
Once you got him back in the ambulance, obviously it's lighter, meaning brighter lights. You have more equipment in the back of the ambulance. You can better assess somebody's well-being, correct?
Yes, sir.
And you indicated you had a, quote, much better picture of what we were dealing with, correct?
Yes.
You noticed once in the back of the ambulance that he had trauma to the right side of his head.
Correct.
And as a matter of fact, when you were pointing at it, I'm doing that on purpose because you pointed to the right side of your sort of forehead above your right eyebrow, correct?
Yes, sir.
Okay. The majority or the worst injury that Mr. O'Keefe suffered was actually to the back of his head, which you indicated, you noted was quite matted with blood, correct?
Yes, sir.
I want to talk about the injury to the right side of his head as distinct from the back of the head injury for just a second. Before I get to that in detail, let me ask you, because I just sort of want to cover the bases. You noted the back of the head injury, correct? Is that yes?
Yes, sir.
You also noted the front right side of the head above the right eye, correct?
We did.
You noted some injury to his eyes. They looked blackened.
Yes, sir.
But primarily the right eye was blackened.
Yep.
And there was a golf ball size egg, I think you put it over his right eye, often called a hematoma.
Correct.
And you also noted when you got his shirt off that he had scratches along the right side of his arm. Is that right?
Yes, sir.
You indicated on direct examination today that you believe those scratches ended where? Meaning from top to bottom? And I'm not using anatomically correct language. So from shoulder to wrist, where were the scratches that you noted?
There were several. As I noted, they were on his right humerus area.
Tell me what a humerus is.
The right arm.
Biceps.
Right about here.
Okay.
No, a little further, like between where your bicep and your tricep kind of meet. Right,
Got it.
Right about in there.
Okay. And what did the scratches look like?
They were deep. Infamously referred to them as furrows. but they were quite deep. You could tell that there had been some material removed.
Okay. Material meaning skin and flesh.
Yes, sir.
Okay. Some biological material.
Mhm.
Is that yes?
Yes, sir.
And were they parallel? Meaning they were going in the same direction?
Yes.
Were there any scratches below the elbow as
There
well?
were. Yes, there
Okay.
were. They were not as significant as the ones in the upper arm, but they were noted.
Okay. And those were parallel as well?
Yes, sir.
And they look like scratches to you. That's how you described them.
They did.
Rose, that was a whole moment during the
Last year, when you described those scratches, you curled your fingers up, exposing sort of the nails, and drew it across your biceps. Is that what you were using to describe what the sort of scratches looked like?
I just kind of used that as a landmark, to be honest with you,
Okay.
sir. It was just kind of how I quantified it in my mind.
Okay. But what you did was you did this motion.
Yes, sir.
As you said, there were furrows. And remember, there was an embarrassing moment for me.
Both of us, sir.
I couldn't understand the word furrow because of the accent, right?
Yes, sir.
All right.
That was a funny moment.
Let's talk a little bit about the hematoma above the right eye for a second.
Like my cousin Biddy.
That's
remind me of.
basically damage to subdural blood vessels that causes acute swelling, right?
Correct.
And a very common cause of a hematoma over one's eye could be being hit or punched in the face. We talked about that.
There could be several causes for hematoma, such as that.
Obviously. I mean, it could be a golf club, a baseball bat, or it could be a fist.
It could be.
Okay. We talked about that last year. I asked you if the injuries that you saw on Mr. O'Keefe's face, including the laceration over his right eye, was consistent or inconsistent with a physical altercation. And you said it was consistent with a physical altercation as well.
Excuse me?
Objection to referring to past testimony before a question is asked.
So sustained.
Sure. Do you remember a laceration, in addition to the hematoma, about a 0.8 centimeter laceration over his right eye?
I do.
Tell me I'm using a word that maybe not everybody understands. I didn't understand it when we first started this thing. What's a laceration? What's the difference between that and a cut?
A laceration is they're basically the same thing. A laceration is just a deep cut.
Okay. So it's a parting of the skin.
Correct.
In other words, where the skin separates.
Yes.
And that can be from blunt force trauma, meaning something hits it rather than cuts it.
You can get
Sustained.
That's what I thought.
What are some of the causes of lacerations?
You can get a laceration, as you noted, blunt force, but you can also get a laceration from a slashing movement, from a stabbing. I mean, that is still a laceration.
What about a hematoma?
That is primarily caused by blunt force trauma.
Right. And the hematoma and the laceration were right next to each other, correct?
Yes, sir.
Okay. And you indicated last year, or let me ask you this way. Is that consistent or inconsistent with a physical altercation?
Objection.
Can you answer that?
I could not say, Your Honor.
Okay, next question.
Well, last year, you indicate you can't answer that. Last year, you did answer it, didn't you?
Objection.
So I need to see counsel at sidebar for just a minute, please.
Okay, so here's the thing. Some of his stuff from last year has changed to this year. So, of course, defense is going to jump all over that. Obviously, Brennan's not going to bring up like, hey, remember when you said that there was a big puffy coat? And we were all like, what? There's no big puffy coat. Yeah, remember that? Wasn't that funny? Of course, he's not going to bring it up. But of course, AJ is. Jackson's going to get up there and he's going to say, remember this. Now, to be fair, I think it's important to note here that getting up here and saying all of this and saying, this is not consistent, this is not consistent. This is not the defense attorney getting up here and saying, you're a liar. This is the defense attorney pointing out to the jury that for whatever reason, it doesn't matter the reason, for whatever reason, his story of what happens and what he specifically remembers changes over time. The reason that's important is because it means that we can't, as jurors, really rely on his testimony to be the gospel. Like that's not written, in stone as exactly what happened. The reason we can't say this is written in stone exactly what happened is because it's written 5 different ways and 5 different reports and testimony and grand jury stuff and all of this. If the memory of what happened is constantly changing, then we can't know that what he's testifying to today is what actually happened. So it's not to say, hey, you're a liar and, you know, we're all mad at you. It's to say, hey, jury, memory is not, you know, memory's not memory in here. You know, like this is not what we can really rely on. If you have inconsistent stories, inconsistent memories, inconsistent testimony, that is important for a jury to know, because it gives them some perspective as to what kind of weight they can put on this testimony. Now, again, like he said, his main job when he gets there is to try to save lives, right? Like, so we don't expect him to remember every single little detail about every single little thing and put every single little detail about every little thing in a report. That would have been the officers' jobs, but did they do that? No, but that's a whole nother story. We'll get there, and I'll have plenty of snark for that moment. But with this specifically, his memory has changed.
We're going to let you take a break and come back and join us after the lunch break. So this is
Sounds good.
the lunch break. There's lunch here for you. I assume Tony is it here? Okay. There's lunch here for you. We'll see you in about a half an hour.
All rise, please. Jurors, leave your notebooks in your chairs.
All right, half-hour lunch. I love how she calls it luncheon. The luncheon recess for half an hour. Okay, shorter than last year. I'm going to try to zip through it, right? What's for lunch? D&E pizza. His memory has been rehomed. And look, I get it. Like my memory is not always the best. So I get it. I think that what's important to remember here is that we, of course, all have, you know, like this is a, you know, it's a common thing. Like that's not saying, you know, that's, you know, memory is bad. I just want to be very careful about like the way that we talk about the witnesses and the way that we come at them, because this is a difficult situation to be in. And we can't assume that everybody that gets up there and changes their story is lying. I want to give everybody the benefit of the doubt. So, you know, he does a very honorable job. You know, that's an honorable profession, and I want to give him the benefit of the doubt. I think that having testimony that changes that much, having a story that changes that much is, of course, going to be problematic in a trial like this. Somebody's life is on the line. Somebody who lost their life, you know, we're looking for justice for that, whatever that looks like. We're hoping to get as much information as we can to get truth. And when you have memories that are changing and stories that are changing, that makes that process a lot more complicated. So I think that he is, I would say with him, I think his is more a memory issue and not a lying issue, especially because he wouldn't have lied about being like, yeah, I remember a puffy coat. He remembered a puffy coat, and that's fine. His memory was wrong, and that's okay. It happens. His memory was wrong, and that's okay. But that is just another example of why memory is, you know, not the most reliable thing on here. So, yeah. All right. Now, the last trial, remember, they talked about this a little bit, and the last trial, he said that he heard Karen Reed say, I hit him. Let me pull up my notes from last trial, actually. Y'all know I love to compare. See what has changed. See what is the same. See what else we hear. All right, so in my notes from the last trial, That's another thing I have. Okay, so in my notes from the last trial too, the whole thing with the clothes and the puffy jacket. He said, I have in my notes from the last trial that he said that he was dressed for the weather. He had several layers on. They put him on the scoop stretcher, took him to the ambulance, got him out of the winter clothing, and then continued CPR. So did you notice, though, that this time when the clothing process was brought up during direct examination, he's like, well, I didn't have a part in that. So I think that, he's trying to kind of, because of that issue, like maybe trying to distance himself from that whole process because that was kind of hammered home in the last one, the phantom puffy jacket. The clothing was brought up during cross-examination, of course. So that was pointed out that, it was wrong and it was kind of a whole big thing. So I can understand wanting to distance yourself from that. But here's the thing. Okay, so in his report or his interview with Proctor, because we all know how reliable Proctor's recollections of things are. Where is it? I have it in here somewhere. I know I do. Where is it? Oh. Okay, so yeah, he said to Proctor, according to Proctor, in his interview on February 8th, which is what, a little more than a week and a half, 2 weeks-ish after this happened. A week and a half after this happened. It says that in that interview, he says, this is according to Proctor's interview, that Nuttall said that he was rendering aid and he heard Karen Reed say, I hit him, to another female on the scene. And the other female said to be quiet. He did admit on the stand last time that his memory is faulty when it pertains to time frames and what was happening. But in that report from Proctor's interview with him on February 8th, that was the first time that it was mentioned that he had heard anything. It was not reported. It was, it was not in his report. He didn't tell the doctors or the nurses anything like that when they got him to Good Sam. None of that stuff. So that was obviously kind of hit home. Like, they hammered in on that too during the last trial. But here, like him saying, I was rendering aid, and then I heard Karen Reed say this to another woman, and then they talked about it in the last trial too. He's like, well, okay, so then he said, Jackson was like, well, you said that you heard her say it to Katie McLaughlin. And Katie McLaughlin was like, he pointed out that that Nuttall was in the ambulance when Katie McLaughlin was talking to Karen Reed. So he could not have heard I hit him during that time. So because this keeps changing, it shows that whatever his memory is right now, his memory has been different at least 2 other times. If this story keeps changing, it just doesn't give it as much credibility as, Hank Brennan was relying on it to give in those opening statements. So there's that. On redirect, during the last time, I have in my notes on redirect, in the last time, he said, the whole I hit him thing is his memory as it stands today, is what he said. Same thing he's saying today. His new story today is what he's saying. That is his memory as it stands today. So we'll see. Let me know what y'all think. I'm curious to see what you think. I do want to give him, like I said, though, I do want to give him the benefit of the doubt. Memory is a fallible thing. He has admitted that his memory is faulty when it comes to some of this stuff. And he's saying the things that he remembers in this moment. So let me know what y'all think. One other thing that's some good lawyering, y'all. Look, when Jackson's like, oh, so you didn't bring up that y'all talked about the puffy coat situation in the meetings. And he's like, oh, yeah, I, forgot about it or whatever he said. And Jackson's like, oh, really? So you're saying that your memory is faulty after 3 weeks? And here we are, 3 years later, and you're telling us your memory. That's some good lawyering, y'all. I don't care who you are. That's some good lawyering. That's the kind of stuff that pointing those situations out and pointing that stuff out in front of the jury is like, it's like, oh yeah, good point. Good point. So that's some good lawyering. Nuttall was the 5th witness to be called in the last trial. He testified on day 2. So doing things a little bit differently this time. It is interesting that part of, the opening statements where he's talking about, hold on, let me scroll back up. Y'all should see this. I take so many notes during this because I'm always like, I need to go back and remember exactly what was said. Where did he say it? He said, because this is something I noted too, that was like, I was like, I need to go back and listen to that because that's not what he said in the openings. Cardiac arrest. Okay, so he said that at 6:04 a.m., this is Brennan in the prosecution's openings. He said 6:04 a.m., the alarm sounded in Canton Fire. And so Nuttall knew what that meant. He picked up his bag. And Brennan said that it was a call for cardiac arrest, which is the most serious of calls for a firefighter. But Nuttall didn't know who it was or where, so they rushed to the ambulance. Okay, but the cardiac arrest, this is a small detail, but it was something that I want to hear y'all's thoughts on it. Tell me in chat. Brennan said that it was a call for cardiac arrest, but they don't get the call for cardiac arrest. They got a call for a man unresponsive. And I thought that stood out to me because I was like, that was the first time I'd heard that it was a call for cardiac arrest. Everything else I've heard is just a man unresponsive. And then when Nuttall got up there, he said that the call was, let me scroll way back down here, that there's 3 different tones that go off. There's one for fire, one for investigation, and one for EMS. So the EMS tone went off, and he said that he knows that that's typically like a more involved thing. So the crew, they get together, and he said that they didn't have any other information for it at that time. So when they get there, they get that information. But when they were first called to the scene, when they first got those tones going off to call them there, it wasn't for cardiac arrest. It was for a man unresponsive. So that was something that, it's just a random thing, but y'all know I'm a detail person. I pick up on all those weird details, and it was just something that kind of stood out to me because I'd never heard that mentioned before. I've only heard a man unresponsive because that's what we've heard all along. So, someone testified to outer clothing being on the hospital floor, I believe, but now Nuttall is saying he wasn't wearing a jacket. I'm confused. So there was no jacket. Nuttall said in the last trial that he remembered there being a puffy jacket, but there was no puffy jacket. There was an orange t-shirt that John O'Keefe had on. And then on top of that, it's technically a hoodie because it has a hood on it, but it's not like a hoodie. It's not like the kind of hoodie you steal from your boyfriend type of hoodie. It's like it's like just one of the thin, it's basically like a t-shirt with a hood on it, but it's long sleeve. It's like one of those thin ones. It's not like one of the big thick hoodies. So he had on that, and then he had on an orange t-shirt under that. So those were the 2 layers of clothing that he had on, but there was no jacket. So the memory from the jacket was just a false memory. But the hoodie and the t-shirt and all the clothing was it was thrown on the ambulance floor first, and then it was taken to the hospital. It was on the hospital floor. Then it was like it was all in a pile which again, they're focused on saving lives, not, preserving evidence at that moment. So that's, they're doing what they can to, try to save lives. So not faulting them for that, but that's just how it happens. That's why they were saying, all kinds of debris or whatever can get on the clothing because it's just kind of thrown into a pile on the floor. Brandi, I love you to death, and I know you always try to see the best in everyone, and that's good. But in this case, after everything, he to me is flatlining. I know, and I get a lot of pushback when I say these things. I just want to. It's very easy to get angry and jump to, conclusions for these, and so I get that. I just want to give them the benefit of the doubt because just like Karen Reed has, the presumption of innocence, I give the presumption of innocence to everybody else as well. So even with the witnesses in what they're saying. Now, if I if they seem sneaky about how they're changing their testimony and stuff, then I'm like, they a snake. But I do want to be, I just want to try to give the benefit of the doubt. Okay, Jasmine says Google says when someone is found unresponsive in the snow and a cardiac arrest is suspected, the immediate response should be to call for help and start cardiopulmonary resuscitation. So, yeah, I just they've never said anything about cardiac arrest being suspected. That was, so yeah, I mean, maybe they assumed it, but I don't know. It's just one of those small things that stood out to me because Brennan saying that in the openings is something that's never been said before. So, Yeah, the doctors were probably more focusing on saving his life versus evidence, 100%, which is why, like once that clothing gets into the custody of the police, that's a whole different story. But when they are in those first moments when, it's the EMT or paramedics or, whoever, like doctors, nurses, once they get to the hospital, whenever it's whoever it is in the medical field, first responder field, that is a totally different thing than once it gets into police custody. So yeah, like you're focusing on trying to do whatever you can to save them. That's the most important thing. And so, yeah, it's how it works. It just ends up sometimes on the floor of an ambulance. Let's see. It's strange how his testimony was very different the last time. Yeah. Nuttall isn't a key witness. He's testifying early, and he's already mentioned that his memory isn't great. Sounds like perfect foundation for Commonwealth to tweak his recollection. It could be. And also, I thought it was so interesting that he's the one that was brought up in the openings because he is the one who had the fallible memory. Like, if you're going to rely on one of the paramedics as the, like, I hit him, story, Katie McLaughlin was the first one, who said it. And then everybody's stories everybody's stories kind of started changing and altering and shifting, after all of that. But I guess you can't really rely on hers either because, like Jackson said, they're going to pull up the friendship between or acquaintance. She said she's not a friend, she's an acquaintance. And that's when they brought in all the pictures of them together and stuff. But they're going to bring up the fact that she was friends with Brian Albert's daughter. And so that may be why they didn't want to rely on her. But I would think after going through the first trial, which Brennan wasn't there, obviously, but he said he never watched the trial, but he's read the transcripts. He said that 100 times. I would think that if you've read the transcripts, you know that Nuttall did have the false memory about the jacket, and that there would be, you would know that the story he's giving now is different. So it seems like a strange one to rely on so heavily in the openings, but I don't know. Y'all tell me what you think. At the end of the day, we all want to see justice for John. I think that this is very important. I think it's something that kind of gets missed a lot because both sides and everybody in the middle, I think, really wants to see justice for John O'Keefe. I think that everybody just has a different idea of what that looks like. Some people think that justice for John O'Keefe is, you know, the defendant being convicted. Some people think, okay, the defendant is innocent, so justice for John O'Keefe would be them figuring out what really happened and pursuing that. Some people think, you know, well, I don't know if she's guilty or not, or I don't, and if you don't know if she's guilty, then that's an automatic not guilty because it has to be beyond a reasonable doubt. So then it becomes justice for John O'Keefe would have been a proper investigation and, you know, some integrity in that whole situation of how things were handled. And that's a really hard thing to accept, that that ship has sailed because the investigation is over and you can't, you know, you can't put that toothpaste back in the tube. Like, it's, you know, the damage is done. So that's really hard to, you know, that's a hard thing to look at. I think that everybody really does truly want that. I just think that everybody has different ideas of what that looks like. So. But at least with all of the attention on this, you know, that gives, there have been, we saw in the Canton police audit stuff, you know, like there have been changes that they made since all of this stuff happened, because there's a lot of things that they did wrong. Like, this is no secret. This isn't just like the defense picking something apart. They messed up big time in a lot of things, and you can try to defend some of it, and that's fine. But even the Canton police audit was like, no, they did this and this and this wrong. You know, this should have been whatever. This is not one of those situations where it's just a defense attorney being a defense attorney. These are serious issues with this investigation and with other investigations. And at least if we're looking at potentially some good that has come out of it, maybe we can look at it like, well, because there's so much tension on this, and, you know, the world has looked at this and it's now under a microscope or magnifying glass. What is it? Microscope, magnifying glass, whatever. You can see it like this now. Now there are changes that are being made, and changes that have already been made, so that something like this doesn't happen again. So. They didn't get the evidence and can't get it now. It's too late. Yeah, that's kind of what I mean when I say, like, you know, that ship is sailed, or that toothpaste is out of the, whichever little analogy, colloquial analogy you want to use. But yeah, that's really unfortunate, because I think that if there's so many things that if they were done differently, this whole situation would have been done differently. Because let's look at it from both sides. If she's guilty, and let's say she did this, theoretically, let's say she did this. If things would have been done properly, that would have been easier to prove, right? And if she's innocent, then that means something else happened. And if things were done properly, maybe we could get to the truth of that. But because things weren't done right, now we'll never know. Using solo cups and Stop and Shop bags is not evidence. I love that Brennan said in his openings that, you know, they used plastic containers. No, sir. No, sir. They used solo cups. Let's not get this twisted. They did not use plastic evidence containers. They used solo cups, like beer pong solo cups. That's what they used. you know, bless them. Bless him from the house of the officer who lived across the street. Yes. Solo cups. Plastic containers. All right. So they have, she said a 30-minute break and then we're coming back. Also, I'll add all of this stuff into the timeline, all the times that they mention. I have my master timeline that I have that has like everything that everybody's ever said ever, from every report, from the first trial, from all court documents, from everything. Every single time that anything has ever happened ever, I have it all in one master timeline to kind of keep up with it and compare. So anything that is said, it will not happen today. It may not happen tomorrow. At some point throughout the week, the stuff will be added in. So y'all can keep up with that. I had somebody ask me like, well, you're going to update it for us every day, right? If you have any idea what I'm doing every single day, because I'm streaming here all day and then I do the recap and then I work on the podcast stuff and having to go back and reference previous documents in the previous trial and all that. It's a whole lot happening. So I can't guarantee that the spreadsheet is going to be updated every single day. So it will be updated when I can get to it to update it. But I will do my best for y'all. We have a 30-minute break. That was at 4:11 and it is now 4:36. So it should be back in just a minute. But I am going to take Lucy, who is down here like snoozing. I'm going to take her OUT. I have to spell it or else she'll get up and start barking. I'm going to take her out real quick. I'm going to put the OnlyFan back on so that when they do come back, if I am still outside with her, you will not miss a moment. So it is unmuted and it is ready for them to come back from lunch. So just in case I'm back. Oh, you want beach cam? I can give you beach cam. Oh, I can give you some beach cam. We can do beach cam. You know I love a beach cam. Because it is a beautiful day too. And there's a whole heap of people out here. Let me get my, I feel like I'm going to sneeze. It's a little cloudy out there, but it's beautiful. All right, let me close all these. I got tabs everywhere. Okay, I want to give you beach cam, but I'm going to put it kind of off to the side so that if they do come back while I am, while I'm gone, I have to do it this way. Share screen. Oops. There you go. All right, that way, if they come back, you'll have it on there. All right, I'm going to take Lucy out. I will be right back. And I have it unmuted so that you won't miss a thing. I'll be right back, y'all. Okay. Hello. Hello. Did I scare you when I came back? Sometimes when I come back after I've been out for a minute, everybody's like, you snuck up on me. Hello, hello, hello. I see we are not back yet. Hopefully soon. I'll give you beach cam a little bit bigger. It's kind of cloudy out there today, but it's pretty. Oh, beach cam looks frozen right there. Why is it frozen? Let's see. This is oh, it can't be played now. Panama City Beach cam. This is Pineapple Willie's. Pineapple Willie's has, it's a lot of fun. They have their cameras that you can live stream all day, and they have signs out there that say, there we go. Now you can see the waves. They have signs out there that you can take. I think it's on the other one that they have it actually, where you can stand in front of it and it'll say something about wish you were here. So people will go like tell their family, you know, they're standing in front of it, like go to the camera link, and then you stand in front of it and wave to the people who are watching. You scare me. I know. I sneak back up on y'all every time. I sneak back up on you. Boo. I'm gonna start doing that now when I come back. Boo. Amber says I'll be there in a couple weeks. It is beautiful. I absolutely love it. I absolutely love it. Yeah, she scared me earlier when I had volume full up during Brennan's open, and then she spoke. I can't stand when they don't use their microphone. It drives me crazy. I can't stand it. I get so frustrated, and I just want to like phone a friend, like use your microphone, but they don't listen to me. So whatever. The camera is kind of moving. All right, I'm gonna get rid of our beach cam for now. We can have it back when we need like a woosah moment. I need to change. Where's it? Share screen. Share audio. I have to do it a little bit different. Let's see. That work? Nope. There we go. There we go. Okay, so how much do we pay for the OnlyFans? OnlyFans is better than the Only Dome, Only Globe Light, whatever you want to call it. It's become like a thing for us. And now every time I see a fan, it's like this great inside joke that we all have. OnlyFans gate. Did anyone else notice how uncomfortable this EMT is? Have you seen his expressions to the jury? Yeah, you know, he does look uncomfortable. And look, I would be uncomfortable too, being up there, especially when it's getting pointed out that, you know, my memory from before is different this time around, you know? He said, I think we're going to go to sidebar.
You are unmuted.
I was told counsel wanted to see me about scheduling.
Your Honor, my apologies. That's actually a moot point at this point, so that there's no.
Okay. All right, bring the jurors in, please.
It's a moot point. Bring the jury. Yes. Lucy is eating her treat now. She got a treat for doing her thing. I have also heated myself up a treat.
Yes, Dave.
You see me eating?
Yes, please. Yeah.
I have to try to squeeze in bites when I can around here. All rise. All right. So if you are just tuning in, I have whoever's on the stand, I will always have it pinned at the top of the chat so that you can see. This is Timothy Nuttall from Canton Fire Department. I understand being nervous. Some doctors are amazing during surgeries and stuff, but when it comes to public speaking, it's a whole different ballgame. Yeah. It's hard to speak live, especially when you're being, oh, lay off the microphone, people. Especially when you are being like grilled about
All right,
stuff.
Mr. Jackson, you can go ahead.
All right, so Jackson's back up. We're still doing cross-examination.
May I, Your Honor?
Yes,
Thank you.
please.
Firefighter Nuttall, over the lunch hour, did you discuss anything that we had discussed this morning or earlier in the session with anybody about
No,
your
sir.
testimony?
Oh, sorry.
Okay. You did mention earlier today the EMTs that were with you that responded to the scene. You mentioned, I think you said Tony Anthony Flamati, correct?
Yes, sir.
You mentioned Kelly, and I want to say Matthew.
Matt Kelly.
Matt Kelly.
Yep.
Yourself.
Correct.
And of the three of you, two of the three of you were and are paramedics, our firefighter Flamati and yourself, correct?
Correct.
Do you know the name Katie McLaughlin?
I do.
Who is Katie McLaughlin?
She is a firefighter paramedic for the town of Canton.
Was she also on the call?
She was.
You didn't mention her this morning.
It did not come up. She responded on the initial dispatch on engine 3.
You were asked who responded with you, correct?
Yes, sir.
By Mr. Brennan.
Yes, sir.
And you mentioned yourself. You mentioned Tony Flamati. You mentioned Matt Kelly.
Yes, myself, firefighter Flamati, and firefighter Kelly responded in ambulance 1 together.
Okay. And how did firefighter McLaughlin respond?
So she was assigned to engine 3 that night. She was with Lieutenant Woodbury and firefighter paramedic Frank Walsh.
She also, in addition to Walsh being, it's Frank Walsh?
Yes, sir.
In addition to firefighter Walsh being a paramedic, Katie McLaughlin was also a paramedic.
Correct.
Okay. So she responded to the scene at the same time as you, generally, but in a different ambulance.
In a fire truck, in a piece of fire apparatus. She was
Got
in
it.
engine 3.
Got it. Engine 3. Okay. And she was with you generally, when I say with you, at the scene during the entire time that you're describing the events that you described with Mr. Brennan on direct examination.
For the most part.
Okay. She then left in a particular ambulance, correct?
Yes, so she ended up driving ambulance 1 to Good Samaritan.
And ambulance 1 was which ambulance?
Ambulance 1 was the initial ambulance that myself, firefighter Kelly, and firefighter Flamati responded in.
So right after the scene you described, as you're leaving the scene, firefighter McLaughlin is in the ambulance with you and firefighter Flamati, correct?
She is driving. So the three of us are in the back in the patient compartment. She is up front in the driver's seat.
Once at the hospital, did firefighter McLaughlin go into the hospital with the other firefighters?
I believe so, yes.
So she was with you in the engine. She was, although in the driving cab, she was with you, ambulance in the driving cab. She was also with you right after the scene at the hospital, correct?
Yes, sir.
And she was also with you later after you cleared the hospital and went back to the station.
Yes, sir.
You had discussions with firefighter Flamati about the incident. That would be normal protocol.
Correct.
Almost like a debrief.
Sure.
You had the same types of discussions with firefighter Kelly, Matt Kelly.
Yes, sir.
I'm guessing that you probably had the same sorts of discussions with firefighter Walsh.
I actually don't know if I saw firefighter Walsh when we got back. The weather was right at shift change, and the weather getting back was also getting worse. So I honestly couldn't speak to that.
And you also had conversations with firefighter McLaughlin after you cleared the hospital and got back to the station as well.
She was part of the debrief. Yes, sir.
Okay. And all of you discussed what you did, saw, and heard, generally speaking, while at the scene, correct?
Those are more in terms of getting equipment wrangled, really kind of how they go. What did we use? What do we need? What are we going to have to restock when we get back?
Right. But there also was obviously discussions about what had just happened. I mean, you were dealing with a dead or dying police officer on a lawn, on a snow-covered lawn in a cold environment.
I honestly couldn't speak to that, sir. I honestly don't remember.
It's because you don't remember, correct?
Well, like I said, it's mostly those debriefs are usually, they're very equipment oriented because the goal at that point is to get back in service.
My question is not about the equipment. Obviously, you're going to discuss the equipment, make sure that the ambulance is ready for the next call, et cetera. I'm asking about a general debrief with the fellow firefighters, male and female, that you were with at that scene. You're telling me that you don't remember debriefing and discussing the incident and your observations at the incident following that incident?
No, sir.
Okay. But your memory, you indicated earlier, gets better with time, right?
Yes, sir.
You don't remember it as you sit here today?
Ask the question again.
Sure. Do you remember discussing with firefighter Flamati, firefighter Walsh, firefighter Kelly, firefighter McLaughlin, any of them, your observations and what happened while at the scene after you cleared the hospital and got back to the station?
No, sir.
Have no memory of that whatsoever?
No, sir.
When we left off before lunch, I was asking you about a hematoma and a laceration over the right eye of Mr. O'Keefe. Do you recall that?
Yes, sir.
I asked you, is being punched in the face, can that lead to a small laceration like you saw and a hematoma like you saw?
Objection.
I'm going to allow it. Can you answer that question?
I couldn't speak to how that injury occurred.
Is it consistent? Are those injuries, just those injuries, are those consistent with being punched in the face?
Those injuries could be sustained from numerous ways.
And
yes, it could be from that. It could be from others as well.
Okay, so that's what I'm asking you. It could be. In other words, it's consistent
Yes,
with
sir.
being punched in the face, correct?
Correct.
Thank you.
The sirens. See, he doesn't need him to say that it came from being punched, just that he's just showing it could
I
have.
want to ask you about this statement that you indicate that you heard that now is 3 statements, 3 phrases, correct?
Yes, sir.
When you heard this statement, describe for me exactly where you were. What were you doing and who was around you?
I was knelt at the head of John O'Keefe with a bag valve mask, delivering ventilations. Firefighter Kelly was to the right, and firefighter Flamati was on the left side of Mr. O'Keefe, and the 3 of us together were working to perform CPR and ventilations.
And your job, and I hate to butcher it, but you'll correct me.
Yes, sir.
Your job was to do the airway, correct?
Correct. Yes, sir.
And I'm picturing a big balloon-like apparatus that you put over the patient's mouth. And
Exactly.
squeeze it.
Yes.
That's as opposed to, it's an advancement on just mouth-to-mouth resuscitation, correct?
Correct. Yeah.
You were the airway person doing the squeezing of the bag.
Correct.
What was Tony Flamati, firefighter Flamati, doing?
He was starting CPR, in which that point was taken over by firefighter Kelly.
Okay. So firefighter Flamati, when you say starting CPR, describe what that means. What is the physical act of CPR?
So you put both hands together like this, one on top of the other. You put it right on top of the sternum, and you begin doing chest compressions 2 inches deep, allowing full recoil for 100 to 120 beats per minute, compressions a minute to sustain a cardiac rhythm. You're manually making the heart beat with each compression.
Which means that is a rhythmic pumping motion, correct?
Yes, sir.
So if you see someone doing CPR, you're probably going to see their shoulders moving up and down and moving rhythmically, correct?
Correct.
Do you remember what firefighter Flamati was wearing? You had just come off of a actually, you were just coming onto a shift, so you didn't have all your foul weather gear officially, correct?
I had my puffy jacket.
Okay.
I had my Canton Fire jacket.
Got it. Firefighter Flamati, on the other hand, had a bright yellow jacket,
Correct.
sort of reflective and a safety jacket.
Yes, sir.
And he was kneeling to your left at the time doing, have I got that right?
Yep. Nope. Yep. You got that right.
Okay. He's kneeling to your left at the time doing chest compressions. That's when you indicate that Miss Reed walked over and made the statement.
Correct.
And Kelly was there as well?
Yes, sir.
Kneeling right beside all three of you as Firefighter Flamati was giving the chest compressions, correct?
Yes, sir.
Okay. You indicated that the statement was in response to a question that you asked of my client. Do you know him?
Yes, sir.
Is that right?
Correct.
And she responded to you with the phrase that you've used. I hit him.
I hit him. I hit him. I hit him.
Right. So it's absolutely clear in your mind when that statement was made. You were knelt down over Mr. O'Keefe. Firefighter Flamati was doing the CPR, and Kelly was with the both of you when you posed that question.
Yes, sir.
It's a very detailed memory.
Yes, sir.
You indicated, Mr. Brennan, that sticks out in your mind. Is that right?
It does.
But that's not at all what you told Trooper Proctor on February 8th, just 10 days after this incident, is it?
I don't recall what I told Trooper Proctor.
I thought your memory got better with time.
I don't recall that meeting. Okay. I recall meeting with him, but I don't recall the extent of what was discussed.
You literally don't recall anything that was discussed in that meeting in that formal interview with the lead detective on this case.
We discussed the case, but I don't, in his words, I'm not sure what he put down.
Oh.
What you said to Trooper Proctor on February 8th, 10 days after this, was you overheard Miss Reed say, I hit him one time to another female that she was talking to. Correct?
Objection.
No, I'll allow it. Did you say that?
I have no memory of this, Your Honor.
Okay, next question.
Did you say that her statement was an answer to a question posed by the female or a discussion with the female?
Break that down for me, sir.
Sure. Did you tell Trooper Proctor on February 8th that what you heard was Karen Reed speaking to a female, not answering a question that you posed?
Again, I don't recall that specific question.
That's what the
Did you
report
tell
says.
Trooper Proctor on February 8th while you were rendering aid, and at the time you heard the statement, Miss Reed was actually praying over John, your words, praying over John?
I don't recall ever saying that.
May I have just a moment, Your Honor?
Yes.
So that's that report that we talked about earlier. I knew he would bring that up.
Did you say that you observed Karen Reed to have blood on her face from providing mouth-to-mouth breaths to Mr. O'Keefe prior to your arrival?
I remember Miss Reed having blood on her face, presumably from attempting CPR.
Do you remember telling Trooper Proctor on February 8th that you saw her with blood on her face from CPR?
I do.
So you remember that portion of your conversation with Trooper Proctor, correct?
Yes, sir.
But the praying over John, praying over the victim, you don't remember.
I don't remember ever saying that.
And
ever.
And the statement, I hit him to another female, you also don't remember that.
No, sir.
Would it refresh your recollection if you were to look at a report
Yes, sir.
authored by Trooper Proctor? May I?
Yes.
May I direct the witness's attention to the second page, Your Honor?
All right, why don't you take a look at that?
it's first witness, and this is, in my opinion, this has been stronger for defense than prosecution.
May I approach, Your Honor?
Yes.
Y'all tell me what you think.
So did you have
We'll
an
do a poll.
opportunity to glance at the report that you were just shown?
Yes, sir.
Does that refresh your recollection about your conversation with Trooper Proctor that he put in a report?
It does not, sir.
So as you sit here, you have no memory of what you just read in this report from Trooper Proctor, the lead investigator on the case?
I have no recollection of ever saying that anybody prayed over anybody ever in this case.
You did see it in his report, though.
Sustained.
You've admitted under oath that your memory of the events at that time, from that time frame, January, February 2022, is faulty, correct?
No, sir.
In your April
That's what you
2024,
said.
it's April 30th, 2024 testimony from last year.
Specifically what he said.
You were asked whether or not your memory was a little faulty, and your answer was absolutely, correct?
Could I have a page and number,
Where is
please?
that, Mr. Jackson?
Volume 8, page 151, lines 14 through 16. Lines 14 through 16. I'll just allow counsel to get that up.
Jackson's bringing up all the things I brought up earlier.
If we could pose the entire question and give content to it, please.
Content?
Okay.
Context?
May I?
Yeah, so do you intend to show the whole question?
The whole question that I asked and his answer, yes.
All right, and I'll give you the opportunity on redirect, Mr. Brennan, if it's not. Go ahead.
Is it true that in answer to the question, quote, so it's fair to say your memory is a little bit faulty as it pertains to that time frame? Your answer was absolutely. Correct?
From last year?
What you testified to last year about conversations that you had with Trooper Proctor around February 8th of 2022.
Yes, sir.
And you would agree, as you sit here, that your memory is still faulty about your conversation with him.
With
correct?
Trooper Proctor? Yes,
Yeah.
sir.
So you're not saying you didn't say that the statement was made to a woman, correct?
Objection.
Are you saying that?
No, ma'am.
Okay, next question.
Thank you. And you're also not saying that you didn't say to Trooper Proctor that you saw Karen Reed praying over John O'Keefe.
Objection.
So I'd like you to ask that differently. Did you say that?
I have no recollection of saying that ever.
Next question.
My point is, if you have no recollection of it, you're not denying saying it.
Objection.
Are you denying saying it?
Yes.
So you do have a recollection that you never said it. Do you understand the difference?
Oh, sir, I don't believe I've ever said praying. That's really not something that I would have said. I didn't see it that day. It didn't happen. I don't remember ever saying prayed
You didn't
in
see
regards
it
to this case ever.
You didn't see it that day, and it never happened. That was your words just now, correct?
Break that down for me.
You didn't see it that day, and it never happened. That's what you're saying about the praying statement, correct?
Yes, sir.
And in that same exact statement, you also included the phrase, I hit him, correct?
No, sir.
In the statement that you made to Trooper Proctor?
The report that Trooper Proctor wrote?
Correct.
Again, I don't remember ever saying the words praying over him. I do distinctly remember I hit him, I hit him, I hit him.
Which doesn't appear in that report, does it?
Objection.
I'm going to sustain that, Mr. Jackson. You directed him only to page 2.
Understood, Your Honor. I'd like to show you a short portion of a video, the same video that you were asked to look at on direct examination. And Your Honor, I pray to the court, I can certainly mark it as a defense exhibit or for
So is this going
identification?
to be an exhibit by agreement?
It is.
It
Okay,
is.
So we now that, Madam Court Reporter, thank you.
Thank you, Your Honor. With the court's permission, may I play a portion of that video for the jurors, publish it?
Okay. Which portion, so people know?
I'm going to start it at about, I want to say 6:55. Mr. Walt, could cue that up? Before you play it, can we have it on that screen as well, or is it only playing to this screen?
I don't know. When Ms. Gilman did it, it was both. Great.
There we go. All right. Before we play it, can I ask you a quick question about this?
Sure.
It appears that this is paused. Do you recognize this as being the same video that you were shown this morning by Mr. Brennan?
I do.
All right. Describe the scene.
So that is 34 Fairview Road. The lights in the background, I believe it is either right as we pulled up or right as we're pulling up.
Okay. Same dash cam video.
Yes, sir.
Can we scroll this to the 6:55 runtime spot, please?
I gotta zoom. I gotta get up here with my old eyeballs so I can
Pause
see
it.
it.
Okay. Do you see the individual on the left? Far, far, far left.
Yeah, the jacket?
Correct.
Yes, sir.
Who's that?
I believe that's firefighter Flamati.
You previously indicated that when you heard Ms. Reed make this statement, the firefighter Flamati was on his knees providing CPR at the same time you were knelt down providing the airway.
This isn't when it was
That's
stated.
not my question. Is that what you said?
Can you repeat the question, please?
Sure. You indicated earlier when you heard this statement by my client, you were very detailed. Firefighter Flamati was knelt down providing chest compressions at the same time you were knelt down providing airway support for Mr. O'Keefe, correct?
I had also said that at some point,
That's a
firefighter
yes or no
Flamati
question.
had
So I'm going to let the witness answer the question.
had
Go ahead.
transferred CPR to firefighter Kelly. Firefighter Kelly did take over compressions at one point.
Okay. That's not my question.
Okay.
My question is an easy one. Did you say that when Miss Reed walked over to you and you had this dialogue with her, she made that statement that firefighter Flamati was on his knees providing chest compressions at the same time you were knelt down providing airway support?
Yes, sir.
Okay. Firefighter Flamati, your testimony appears to be standing up right there, correct?
Yes, sir.
Let's play the video forward for just a second. Stop it. What did you see firefighter Flamati do just now?
I believe he just knelt down.
Okay. So at this point, he's kneeling for the first time, correct?
Yes, sir.
And he's about to provide chest compressions as your memory serves, correct?
Yes, sir.
All right. Let's go ahead and play it forward. Pause. Did you see my client in that photo? I'm sorry, in that clip?
No, sir.
You didn't see her?
Oh, no, I did see her. Yeah.
Yeah.
I don't see her on right now.
Right. She just walked off frame, correct?
Yes, sir.
Let's go ahead and play it forward. Stop it. You see my client walk back into the frame?
Yes, sir.
At this point, you were watching firefighter Flamati. He appears to be now providing CPR, correct?
Yes, yes, sir.
Okay. And my client is nowhere near you, correct? At least for this clip.
No, sir.
Okay.
Correct.
And the clip that I just played before, the few seconds that I played before, nowhere near you, correct?
Correct.
Is that right?
Yes, sir.
Let's go ahead and play it forward. Pause it, please. What do you see happening on the screen from screen right to screen left at this juncture?
We're bringing in the stretcher.
Okay, go ahead and play it. Pause it. Do you see where my client is right now?
Can you back it up 2 seconds? I'm sorry, I lost
With the
view.
court's permission, I need to ask the
Yes.
court's permission. Thank you. Okay, let's go ahead and play it. Pause. Did you see my client?
Yes, sir.
Where is she in the frame?
Behind that other individual.
Behind the SUV?
I believe she's in front of the SUV and behind the other individual.
Okay. I'm at the SUV, that's the white SUV that's in
Yes, sir.
the far distance.
Yes.
That's the back of the SUV. She's behind it, right?
Correct. Yes.
Okay. Not near you.
No.
Okay. Let's go ahead and play it. Go ahead and pause it. Do you see what firefighter Flamati is still doing throughout this entire clip?
Chest compressions?
Okay, let's go ahead and play it. Pause. What's happening now?
Where Mr. O'Keefe's on the scoop stretcher and he's being transferred to the ambulance stretcher.
So that's the entire time Mr. Flamati, firefighter Flamati, was giving chest compressions. It's captured right here on this video, correct?
Yes, sir.
Okay. And now Mr. O'Keefe is up on the stretcher and you are no longer knelt down.
No, sir.
And firefighter Flamati is no longer knelt down.
No, sir.
And you're now following the stretcher with, it looks like 2 or 3 other EMTs, correct?
I am not in that frame, sir.
Okay, so you've walked away.
Yes, sir.
All right. Let's go ahead and play it forward. Pause it. You see where my client is?
Yes, sir.
Go ahead and play it. Do you see firefighter Flamati or firefighter Kelly continuing to give chest compressions?
Yes, sir.
Which one is that? Do you know?
I believe it's firefighter Flamati.
Flamati?
Believe so.
Okay, so he's still doing all the chest compressions from start to finish.
Yes, sir.
Okay. And what's happening right now?
Now we are transferring to ambulance 1.
And where's my client?
Right front and center.
May I have just a moment, Your Honor?
Yes.
Oh, boy. So if he had a very specific memory of Flamati giving chest compressions beside him as Karen Reed is saying this, Jackson just showed, hey, this is the entire time he's doing chest compressions and not once was Karen over there.
If I may have just a second.
But that's why standing very firm in your memory is a dangerous thing when you have a very specific memory and then they have this video that shows, you know, and all these.
With regard, just a couple of more questions with the court's permission. Okay. I'm going to change gears with regard to what you talked about on direct examination, the hypothermic conditions. You're not a medical doctor, correct?
No, sir.
You don't diagnose patients?
Sir.
You're not diagnosing that John O'Keefe suffered from hypothermia that night?
No, sir.
Thank you. That's all I have.
Please.
That was a very effective cross-examination. That was very, very effective. Let's see what Brennan does with it. This is redirect.
Firefighter Nuttall, the video the defense just showed you, did you notice any differences between that video and when I showed it to you, and that it doesn't have the time on it?
Yes, those were 2 different time frames on that video.
And when we spoke about when the defendant said to you, I hit him, that wasn't shown to you in that video just now, was it?
No, it was not.
So if we go back, will you be able to explain where you came from and firefighter Flamati came from and when you first went over to John O'Keefe?
Sure.
With the court's permission, Ms. Gilman, if you could start that video. I think it is 6:11, please.
All right. So he's saying that it's a different
Now stop it
time.
there. Do you see that this exhibit has timestamp on the top?
Yes, sir.
Okay. Please continue. Could you stop, please? Do you see the red lights on the left?
Yes, sir.
Is that when you believe that you first arrived?
Yes, sir.
And that note says 6:11:05. Could you continue, please, Ms. Gilman? Please watch to the left. Stop, please. Is that when you first arrived and walk over to help John O'Keefe?
Yes, sir. That's me.
I'll note that the timestamp is 6:11:21. Okay, continue, please. Stop, please. Did you see firefighter Flamati come after you?
Yes, sir.
Was any of this shown to you during those questions?
No, sir.
No. Continue, please. Stop, please. Do you see the defendant in that screen?
Yes, sir.
Do you see her moving from right to left towards you?
Sustained as to the form.
Okay. What direction do you see her running in that screen from right to left?
She's running towards where the three of us are grouped.
Okay. Please continue.
I wish this video were clearer.
Stop, please. Is it at that time the defendant said to you that she hit him?
Yes, sir.
And you remember that?
I do.
Okay. I'm done with the tape. Thank you very much. Now, you were asked questions about your memory.
Yes, sir.
Okay. When you ask the questions about Trooper Proctor, when you were saying that you didn't remember, were you referring to the conversation with Trooper Proctor, or were you suggesting you didn't remember what happened that morning?
I don't remember the interview with Trooper Proctor. I remember it happened. I don't remember the substance of what was discussed entirely. I remember we discussed that morning, but.
Do you know if that conversation was recorded or just a conversation between you and the trooper?
I do not know if it was recorded.
You asked questions. I want to ask you about questions on Mr. O'Keefe, and you mentioned that there was some type of blood clotting on the back of his head.
Yes, sir.
Okay. You noticed there were abrasions on his right arm.
Yes, sir.
You noticed there was a hematoma on the right side of his head.
Yes, sir.
Did you see any bruising on his right knee?
Don't recall, sir.
Did it stand out to you that all of his injuries, all of them that you saw, other than the cut on the back of the head, that they were all on his right side?
Yes, sir.
Did you notice any hematomas on his left side?
I did not.
Did you notice any scratches or abrasions on his left side?
I did not.
Did you notice any marks that would be consistent with an altercation on the left side of his body?
I did not.
You were asked about the cause, and you said that you don't know the cause. You weren't there, were you?
No, sir.
You asked if it was consistent with being punched, and you said it could be.
Yes, sir.
Could it be consistent with being clipped by a car?
Objection.
Sustained as to the form.
You were asked questions about clothing,
Yes, sir.
and you had at one point said you thought that Mr. O'Keefe was wearing a winter jacket. Do you have any memory that when you first got there, or when you first got there, do you have any memory whether there were any towels wrapped around Mr. O'Keefe's head?
I remember there was a white cloth of some sort on the scene.
Okay. And when you were asked about your memory regarding the clothing, was the clothing of what was utmost importance to you at that time?
No, sir.
And why is that?
I was, again, focused on Mr. O'Keefe's airway and ventilation.
Okay. And when you were asked about the clothing, do you remember if you added anything else about your certainty or uncertainty about clothing when you previously gave a statement or testimony?
I believe when I testified last year, I did note I had no part in removing any articles of clothing or anything like that. That was not my job in the back of the truck.
Do you remember any recognition of the fact whether you were certain or not about clothing?
Repeat the question, sir. I'm sorry.
Well, is there anything that would refresh your memory about what you had said about clothing?
Objection.
Ask a different question first.
You had mentioned that you had some difficulty about clothing. Do you remember what you had previously said?
I remember there was some difficulty of getting the individual's fingers through clothing just because they were so cold. They were difficult to manipulate. Just they really was not conducive to getting clothing off easily.
You met with me 3 times.
Yes, sir.
I had not met you before any of your prior testimonies, had I?
No, sir.
Do you remember meeting with me and discussing this case with me?
I do.
Do you remember me asking you to tell me what you remember?
I do.
Do you remember what I told you about testimony when you come into court?
Yes, sir.
What would I tell you?
I remember we discussed that just tell the truth.
Did I tell you that it doesn't matter? There is no side. Doesn't matter if it helps or hurts, that you just tell the truth?
Sustain.
Did I ever suggest to you that you should stick to
Leading.
a story?
No, sir.
Did I ever suggest to you you should offer your testimony in any certain way?
No, sir.
When I talked to you, did I ever ask you to say anything about your testimony to this jury?
No, sir.
Other than what?
Speak to the jury.
Did I need to tell you to tell the truth?
No, sir.
And in telling the truth, did the defendant say to you, I hit him, I hit him?
Objection.
I'll allow it.
Yes, sir. 3 times.
And in fact,
3 times.
do you remember, in addition to her saying, I hit him, I hit him, I hit him, when you asked her the question, kneeling down over John O'Keefe's body, do you remember if you ever talked about other times that she said it, not to you?
I do not.
Okay.
The answer is I do not. Next question.
Okay. Do you remember testifying previously in this case?
Yes, sir.
I'm like on the edge of my seat now.
Do you remember at all discussing whether or not, after she left you, whether or not the defendant was still talking and speaking?
I'm sorry, sir. Repeat the question.
Do you remember after the defendant left you and made that statement to you, do you remember talking, did you hear her speak to other people after you?
I heard her having conversations in the background, but that was not my focus at that time.
Okay. And during those conversations in the background, did you hear her talk about that same issue again?
I believe she said it several times, but the 3 times she said it to me were what stuck out to me.
Okay. And when she said it to other people, it wasn't directly to you?
No, sir.
So watch the form of the question, Mr. Brennan.
And when she said it to-
Sustaining the objection.
When she said it to other people, do you know who she said it to?
I do not.
I'll allow it. So the answer is I do not.
I'm sorry.
Do you remember when she said it other times who she said it to?
I'm going to see counsel at sidebar for this.
Okay, so it's like we're trying to walk through this, and it seems like we're trying to prosecution is trying to kind of explain away some of the discrepancies here, because now it feels like he's trying to say, okay, well, these are both true. You heard her say it when you were knelt down beside Flamati as Flamati was doing chest compressions, but you also heard her say it to this female, even though he said he didn't remember it. And now he's like, well, you heard it in the background though, right? And he's like, oh yeah, I heard it in the background. This whole thing is just, it's like, this is a very fluid memory and fluid testimony. And that's making my head hurt. The video that he just showed. Okay, here's the thing. The time that the ambulance arrived was 6:11 a.m. And then the time that they put Officer O'Keefe on the stretcher was like 6:14, I think. Hold on, let me look at my timeline. Let me double check. BRB, let me double check. Yeah, they put him on the stretcher at 6:14 and 24 seconds is what I put down from where I saw it on the dash cam last time when I went obsessively over all of this. So that's only like a 3-minute window. I don't know. It's making my head hurt. I want to go back and look at that video again that Jackson played. Because he pointed out, he said, because here's the thing, Nuttall said that his specific memory of the I hit him thing, well, this version of it anyway, the before is totally different, but this version of it, his specific memory is that Flamati was giving compressions beside him. So it showed him giving compressions. So I need to go back and look at that video.
Sir, after the defendant came over to you and spoke and then left, do you remember hearing her make further statements?
Yes, sir.
And do you remember her making further statements similar?
I do.
To the statement to you?
Yes, sir.
Could you share with the jury what you remember her saying, not to you, but after she left you?
I remember hearing I hit him several other times. Again, not directed to me, just kind of off in the background. I'd like to reiterate, we were really focused on the patient at that point. We were trying to provide care.
Thank you, sir.
So now, after Mr. Brennan asks you a few questions, now you remember her saying, I hit him a bunch more times, correct?
I remember hearing it in the background several other times.
Really?
Sir?
Never mentioned that on direct examination, did you?
I don't remember being asked about it, sir. I remember saying what was asked to me.
You were asked, did you ever hear the defendant, Ms. Reed, say anything about I hit him? And your answer was, she said to me, in answer to my question, I hit him, I hit him, I hit him 3 times, and that's it.
To me.
You didn't clarify that, oh my gosh, she's running around like a chicken with her head cut off, screaming I hit him to everybody else under the sun.
It was, again, it was behind me in the background,
right,
as I was providing patient care. Again, that was not my focus.
Okay, so you didn't really hear her say anything in the background because you weren't focused on that, right?
I remember hearing a generalized commotion in the background, but again, that was not our focus.
So generalized commotion is very different than hearing her say, I hit him to other people, correct? You'd agree with that?
Yes, sir.
So what you actually heard was the chaos and the commotion of a chaotic scene, correct? In the background,
In the background.
as you focused on your patient care, correct?
Yes, sir.
Okay, not specific words coming out of my client's mouth, correct?
To the question that I posed, do you know him?
You're right. We're off that question.
Okay.
That question, I got it.
Yes, sir.
Triple I hitters.
Correct.
But with regard to what Mr. Brennan just asked you, the generalized commotion, to use your phrase,
Mhm.
in the background, you didn't hear any specific words coming out of my client's mouth, did you?
I heard I hit him. But again, it was in the background and it was not my focus.
Well, why didn't you say that on direct? That's kind of an important point. That's why you're here.
Again, if it was neglected on my part, it was not intentional.
Not intentional to neglect that part for the jurors on direct examination.
No, sir.
Certainly not intentional to neglect that part of your testimony on cross-examination.
No, sir.
But you decided to bring it up on on re-cross examination when Mr. Brennan is asking you questions again, correct?
It was asked of me. Yes,
And
sir.
it was after, of course, that your new statement that you've never testified to before, ever, is this generalized commotion included a bunch of items in the background, correct?
Sir.
And that comes after you saw the video that clearly shows that when you describe having heard this statement, my client was nowhere around you, correct?
That segment of the video that you showed me,
Yes.
that was not the time frame in which she said that to me.
Well, that was the time frame when Flamati was giving CPR, correct?
He was doing CPR down prior to that as well.
Really?
Yes, sir.
Well, you just testified that you saw him standing up in a big yellow jacket and then kneel down and start giving CPR. We just watched that video. Correct?
But again, the clip of the video that you showed me,
Right.
that was not the segment in which he said that to me.
Well, that's what you're saying now, but what I'm asking is you described a very distinctive scene, a very, very specific scene.
Yes, sir. I remember it vividly.
She said the I hit him phrase when Flamati was down giving CPR and you were kneeling down giving airway support and he was doing rhythmic CPR chest compression.
Yes, sir. That's what happened.
And then I showed you that very scene, didn't I?
Yes, you showed me that clip prior to that.
I showed you the very scene that you described where Flamati gets down and starts chest compressions and never stops until the gurney is taken off the frame of the camera to the end. Isn't that what I showed you?
That is,
Sure. I don't know if I can do it again. I showed you the scene where firefighter Flamati gets down on his knees, begins chest compressions, and never stops until that gurney is taken off camera, off frame, into the ambulance. That's the clip I showed you, correct?
that is the clip you showed me.
And that's exactly when you described your vivid memory from 3.5 years ago. That's exactly the scene that you described when my client supposedly said, I hit him to you, correct?
Again, the clip that you showed me, that was not when it was said. That segment that you showed, that was not when it was said. It was said prior to that, when the
Yeah.
three of us were together.
So Flamati was not giving chest compressions then.
He was. The CPR was a continuous effort throughout the resuscitation.
But we saw him start it. Firefighter Nuttall, we saw him start it. We saw him walk into the frame, kneel down, and begin the chest compressions, didn't we?
We did.
And at no point at that time or after did my client even approach you, did she, in that clip?
She did.
What?
Objection.
Just a question.
Sure, sure.
Oh boy. Oh boy. Oh boy. Oh boy.
Do you need to see the that clip again?
Yes, please.
We're not going to show the video again.
Oh,
We've
please.
seen 2 videos. Which one is marked?
Mocked.
The
Mocked.
The
Commonwealth.
one with the timestamp in
Right.
the top?
It's the exact same video. One has timestamp, one doesn't.
I
Just
want to
be
see it
clear,
again. We'll pull it up.
You described a very detailed scene in which firefighter Flamati got down on the ground on his knees and began CPR.
Yes, sir.
We saw a clip that was, it played fully through.
Mhm.
Starts and stops, but it played fully through, correct?
Yes, sir.
That was true and accurate video of what happened that day,
Yes, sir.
that morning, correct?
Correct.
And from the time firefighter Flamati began his CPR, he never stopped. Went all the way through until the burner was taken off the camera, correct?
Correct.
You also described very clearly before you saw the video that the time when my client walked over and you had this dialogue and you heard this statement, it was during the time that firefighter Flamati was given CPR, correct? You described it.
Yes, sir.
But when we actually see firefighter Flamati giving the CPR, as per your description, at no time did my client walk over and have a conversation with you, did she?
She did in the video.
In the portion that Mr. Brennan played you, was firefighter Flamati giving CPR at that point?
As I said previously,
Was
as well.
he or was he not? Yes or no?
Objection.
I'm going to let the witness answer the question.
Firefighters Kelly and Flamati were trading off CPR. Tony started doing CPR, and it was passed off at one point to firefighter Kelly. Firefighter Kelly at that time was a BLS EMT. Firefighter Flamati was a paramedic. They're going to move towards firefighter Kelly performing CPR because at that time his skill set was not as advanced as firefighter Flamati's, as Tony's. But they did switch off. That is a routine cardiac arrest. We switch off compressions.
But the video that Mr. Brennan showed you was earlier in time, a few seconds or a minute or two earlier.
Yes, sir.
You'd agree with that, correct?
I would.
And firefighter Flamati had not begun CPR, had he?
I don't believe so.
That's right. He hadn't. But that's the time that my client walked over your general area, correct?
Correct.
Before CPR was started, correct?
CPR was started immediately, sir.
Can we wrap this up?
I don't know if we can, Judge.
Give you a couple more minutes.
It needs to be clear. Why?
Do you understand the confusion?
Objection.
Sustained.
All right, a couple more questions on this. The video that Mr. Brennan showed you,
Yes, sir.
and you pointed to and said, oh, that's the time when she walked over and said the statement.
Yes, sir.
Remember that?
I do.
Firefighter Flamati was not even kneeling down giving CPR, was he at that point?
No,
The answer is yes or no?
No.
Okay, he was not. Later, as the video continues to run, at some point, we see firefighter Flamati enter the screen, kneel down in that bright, reflective yellow jacket, and begin CPR, correct?
Yes, sir.
You had previously said that when you heard the statement and she walked over to you, it was when firefighter Flamati was giving CPR, correct?
Yes, sir.
And at no point, you'll agree with me, we just played the video, at no point after he started giving CPR did my client come anywhere near. Isn't that what the video showed?
That was
Yes.
the segment that you showed me.
You indicated on redirect, that Mr. O'Keefe did not have any injuries to the left side of his body.
Not that I recall.
Isn't it true that in addition to the egg on the right side of his head, he also had a black eye on the left side?
I remember that the swelling had started to, it's referred to kind of as raccoon eyes. It's a bruising of both eyes.
Do you remember
battle
saying-
signs?
Do you remember saying, in answer to the question, did it look like in addition to the egg on the right side of his head in the front, did he also have a black eye on the left side? Your answer is, if memory serves correct, yes.
Yes, sir.
So it's not true that he didn't have any injuries on the left side of his body or face, correct?
That swelling kind of migrates over time to both sides. That is a common occurrence for both eyes to be swollen.
Did he have an injury to the left side of his face?
He did not.
Did he have a black left eye?
Yes, he did.
Would you consider a black eye an injury?
Yes, sir.
Let me ask you the question again then. Did he have an injury to the left side of his face?
Yes, sir.
Thank you.
Ugh.
One last question. You indicated that it was a chaotic scene outside on that front yard.
Yes, sir.
Fire engines, ambulances, patrol vehicles, engines running, diesel engines, flashing lights, people screaming, people talking over the howling wind, correct?
Yes, sir.
Did you ever see the homeowner come out the front door?
I don't recall.
You don't recall, or you didn't?
I have no idea who the homeowner is.
And you never saw anybody come out of the front of the house?
No, sir.
That's all I have.
One issue. Briefly.
I want to see counsel at sidebar.
Oh boy. Oh boy. What a first witness. This is going to be a long couple of months. Let me pull up what Flamati said last time. The thing is, he said specifically that he remembers Flamati. Let me go back and look and see what I typed in. He said, as Flamati was giving chest compressions, he said Flamati was starting CPR, then it was taken over by Kelly. He said, when I heard the I hit him thing, he was knelt down at Officer John O'Keefe, they were working on CPR and ventilations with the other guys. He was working on the airway. That was his specific thing. Flamati was starting CPR. As Flamati was giving chest compressions, that's when she said it in response to, do you know him?
Sir, in Mr. Jackson's questions, he asked if you had ever said that you heard the defendant say, I hit him, separate from when she approached you. Do you remember previously testifying that you heard her saying, I hit him in the background, separately from you?
Yes, sir.
You remember testifying that before under oath?
Yes, sir.
In court?
I do.
Anything, Mr. Jackson?
Yeah, just a second, Robert.
I'm sorry.
Thank you, Your Honor, if I may.
Yes.
Just a quick question, Firefighter Nuttall. When you were asked to recite your memory of that day on February 8th, 2022, just 10 days after this incident, did you ever say that you heard in the background, I hit him over and over again?
I don't recall.
All right.
When you testified at the grand jury, last question, when you testified at the grand jury, Did you ever say that?
I don't recall.
But again, your memory is better now than it was then. Right?
Yes, sir.
All right. Firefighter Nuttall, you are all set.
Thank you, ma'am.
He's like, thank little baby
Your
Jesus.
next witness, Mr. Brennan.
Thank you. The Commonwealth calls Kerry Roberts.
Oh, boy. All right. Goodness gracious.
And I did have an exhibit I would like to introduce to
Okay.
play for the jury.
Okay.
And this is clip 2.
No objection from the defense?
No, you're.
And you're marking this as an exhibit?
Yes, Your Honor.
Okay. Do you have something for the court reporter to mark?
We can put it on a zip drive. We can discuss collecting all the clips and putting them on the same zip drive, or we can use different zip drives, whatever the court's preference is.
So we need something. So we need something physical. You can play it and then we'll mark it.
Ms. Gilman, do you have a separate clip?
Jim, is that right?
Thank you. I can have this marked, Your Honor.
Thank you. All right, Ms. Roberts, please. Okay, thank you.
We'd like to play this first and then call Ms.
Oh,
Roberts.
okay, I'm sorry.
Thank you, Your Honor.
I remember it, but I questioned whether I remember it because it's been relived so much. I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually remember that. But I've seen the video so many times that you then question, did I remember it on my own? Or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that. So the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Thank you. I'd now call Kerry Roberts.
Raise your right hand. Do you solemnly swear the evidence given to the court and jury in the case now hearing to the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
All right, this is Kerry Roberts.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your
Good afternoon,
Honor.
Ms. Roberts.
Good afternoon, ma'am.
Good afternoon.
Could you please introduce yourself to this jury?
Hi, my name is Kerry Roberts.
Ms. Roberts, where do you live?
I live in Canton, Massachusetts.
How long have you lived in the area for?
I was raised in the Boston area, North Shore, South Shore. I went to high school in Braintree and I moved to Canton about 12 years ago.
Do you live alone?
No, I live with my husband and 2 children.
How old are your children presently, this day?
My son is 13, my daughter's 15.
Do you work?
Yes, I do.
Without identifying specifically where, can you share with us a little bit about what you do?
I'm an executive assistant, and I've been with my company for 18 years.
Ma'am, if you could just move the microphone just a tiny bit closer. Thank you very much. You have 2 children, you're
Yes.
married,
Yes,
and you live in the area.
yes.
I want you to tell us whether you know a person by the name of John O'Keefe.
Yes, I do.
Would you be willing to share with us when you first met Mr. O'Keefe?
Well, I went to high school with John in Braintree. He played soccer, I played soccer, so we probably hung out in middle school, but we went to 2 different middle schools. And then I hung out with him more in high school. He was a year older than me. His sister was 2 years older than him in school, and his brother was younger. So at some point, I was in high school with each of his siblings.
Did you at some point become friendly with John O'Keefe?
Yes.
Could you tell us about that?
When his sister Kristen passed away, and then her husband Steve passed away, they lived in my neighborhood. John took over for the children and moved into my neighborhood as well.
When John took in the children, did you offer any assistance or any help to him?
Yes, before John was even going to take over, he was going to potentially move in with his brother-in-law and the children to help out. And then when his brother-in-law passed away unexpectedly, John took over, and I jumped in because I was a friend from high school that he knew, and he had all kinds of people helping, but he sort of said, I'm going to lean on you for right now because I know you best. And I knew his parents and his siblings. And so I introduced him to my husband, and we jumped in. It was, preschool drop-offs, preschool pickups for my son and his son. And just from then until the time of his death, we were just friends, very close friends, and we hung out all the time. The children hung out all the time, and he was the emergency contact list at my children's school to call if something had happened.
Were you close friends before he took over the care of the children?
No, I wasn't very close friends with him then.
Were you close with his family before he took over care of the children?
No.
Did your friendship with him develop after he took care of the children?
Yes.
You mentioned you have a son.
Yes, I do.
And is your son the same age as John's nephew?
Yes.
Was there any common interest or activities that engaged your son with John's nephew?
Well, they went to in-home daycare together. They went to preschool together. They went to pre-K together. And they went to elementary school. They've played baseball together since they were T-ball. My son plays hockey. Patrick tried hockey. He didn't like that. So we spent a lot of time at the baseball fields together.
As you spent a lot of time together and had mutual care of children, did your relationship with him grow closer?
Yes.
And can you share a little bit with the jury how close you became?
Well, John was a bachelor and he didn't have any children of his own. So when he took over for the children, he sort of, leaned on us to kind of guide him and, all the things to do if someone has a headache and, if there's an ear infection or, he had his mom and dad also helping as well, but I was right up the street. So if I would go to BJ's, I would call and say, can I grab you anything? If I would go to Walmart, any of the places I would go, I would call and say, do you need anything? Can I help you? Can I grab something for you? And he did the same. We just sort of all chipped in, helped.
As your friendship grew, could you tell us a little bit about your relationship with John?
John and I were very close. We spoke on the phone and hung out. He became very close with my husband as well because he was right down the street. But we just had a friendship, a very close friendship.
Tell us about the day-to-day activities and how you would try to assist John with the children.
Well, John moved across town. I don't remember when. I forget how many. Patrick, I think, was in 5th grade or 4th grade. And I would take him home with me on Wednesdays because John would be working. So it was more of a, if he was at my house and my daughter needed a ride the other side of town, he would take her with him. We were just very close friends. We did a lot together. We would do baseball tournaments together. We would have drinks together. We would, all the things friends do.
As you grew closer to John and helped with the children, did you become closer with his family?
Yes.
And who specifically did you become closer with?
Mrs. O'Keefe and Mr. O'Keefe, his parents, and Paul, I would see from time to time, but not a lot. He doesn't live in Canton. But Mr. and Mrs. O'Keefe would be there all the time to help as well. And Mr. O'Keefe would take my son and Patrick, the nephew, out to Dunkin' Donuts all the time.
Can you tell us a little more about the collective effort of other people, including his family, helping John raise these children?
There was a lot of us that jumped in to help. It was not just me. There was a lot of Kaylee's friends' parents that jumped in and helped out for Kaylee, his niece, and Patrick. There was a lot of us that helped out with Patrick. All of the community all came together to help him because there was this guy that just lost his sister and brother-in-law, and he stepped in to take care of these 2 kids, and he didn't really know what he was doing at first, but he got the hang of it pretty quickly.
You have a son that shared a lot of interests with his nephew.
Yes,
He also had a niece.
yes,
Did you spend more time helping with his nephew or with his niece?
with his nephew.
Were there other people in the community you knew of who spent more time helping with his niece?
Yes,
And who was that?
Jen McCabe.
Did you know Jen McCabe?
I had met her once. John got a discount at Reebok, so he would take the kids, well, he would take anyone with kids up with him to get shoes, like sneakers for back to school or whatever. So one day he did take Jen and I up to Reebok, but other than that, I never talked to her on the phone. I never saw her out. Her children are older than mine, so we never really crossed paths.
As it relates to the night of January 29, 2022, how much earlier was it that John took you out with the children and Miss McCabe out with her children to get sneakers? How many years before that?
Years, like 6 or 7 maybe.
And from that time you met Jen McCabe in the years past, did you ever spend time with her again before January 29th, 2022?
No, I did not. I didn't know her.
Were you friends with her?
I was not.
Did you speak on the phone with her?
No, I did not.
So other than that one meeting, you were strangers?
Yep, that was the only time. I knew her. I knew of her. She has 4 girls, but I didn't know her.
At some point, as you were part of John's life, did you learn that he was dating a person by the name of Karen Reed?
Yes, I did.
And do you see that person here in the courtroom today?
Yes, I do.
Could you point her out and describe an article of clothing that she's wearing?
She has a black suit jacket seated at the front table.
When did you first become familiar or know about Miss Reed?
July, I think it was, of 2020. John, we were having people over, and so I invited him, and he said, I'm going to bring Karen over. And I was like, I don't know who that is, but okay. He assumed I knew because he had been dating her for a little bit, but it was COVID, so we didn't see him very often during that time. So Karen came over that night.
This is early 2020?
I think it was summer, so I think it was around June or July.
Briefly, just tell us a little bit about where and the circumstances of meeting John and Karen for the first time.
They came over to my house and we hung out on the back porch, had some drinks. There was music, kids were around. Just a nice, normal summer night. We had other people over as well.
Over the next coming months, did you become more familiar with the defendant?
Yes.
Did you see her more often?
Yes.
And could you generally describe to the jury how you learned more of her and saw her more often?
She would take care of the kids a lot. Mainly, well, not mainly Patrick, but not mainly Kaylee either. She helped out a lot with the kids. So if we were at baseball, she would come to all the baseball games, or she would drop off or pick up my son or Patrick if they were going to the golf course or the driving range.
Would you see her during events with your son and John's nephew?
Yes. We did baseball tournaments. And
so when you go to baseball tournaments, would that be away, an overnight type trip?
One of them was down the Cape.
How often would you spend time with John and the defendant?
Not that often together, but John would stop by himself. My husband would go out more with John, but I didn't spend much time with the two, not a lot of time outside of the baseball field.
Did you become friends with the defendant?
We were friendly.
Did you ever spend time alone to go out or socialize?
I did not.
Would you see her when you would pick up or drop off kids, or she would pick up or drop off kids?
Yes.
Did you ever speak to her on the phone?
Yes.
In relation to what?
Corresponding with the kids, pick up, drop off, mainly Ryan and Patrick, not about Kaylee.
Did you ever spend any important dates or times or holidays with John and Miss Reed?
No.
I want you to take us ahead to January 28th, 2022.
Okay.
On January 28th, 2022, do you remember that day?
Yes.
Generally, what do you remember about the day of January 28th, 2022?
There was a blizzard coming, and it was my daughter's friend's birthday. So we were going to be going out celebrating that night, but we did it on the early side because there was a blizzard coming.
What was your plan for that evening?
We went bowling. We got dinner, then we went bowling, and then I came home because I wanted to be in before the snow started.
Had you communicated in any way with John that day?
Yes, he texted me. My son had had an issue at school. Patrick had been dismissed, I think, for a doctor's appointment. So he did text me to see how my son was doing.
Did you simply text or did you get a chance to speak to him that day?
I believe we just texted.
Did you go out that night after bowling?
No, I did not.
Was your husband home?
Yes,
Did he go out that night?
he did. He went out with John.
And do you know where he was planning on going?
They went to McCarthy's, a bar in Canton Center.
Had you been to McCarthy's before?
Yes.
Can you just briefly describe what McCarthy's is?
It's a restaurant bar. There's a large bar in the middle, the seating on the left and the right. It's right in the center of town.
Do you remember about what time your husband went out?
I do not remember exactly. I don't know if I got home and then he went out, or if he was already gone when I got home. I don't remember, but it was he went out around the same time that I arrived home, which was on the earlier side.
How many times had you been to John's home, would you say, over the past couple of years before this night?
Oh, many.
Many times?
Many times.
Were you familiar with the house and the driveway?
Yes.
May I approach you on?
Yes.
The page is shuffling. It's very loud. So remember, it's her husband who was friends with John O'Keefe, went out with him that night. And there was one other friend.
Should I return to the podium and ask the question?
You can ask them from there.
Thank you. Ma'am, I'd ask you to take a look at that photo in front of you. Do you recognize what is in that photo?
That is John's house.
Is that a fair and accurate depiction of how his house looks?
Yes, it is.
I'd like to move this to evidence, please.
Okay, any objection?
No objection. May I publish to the jury, Your Honor?
Yes.
Thank you. Thank you. You can take it down. I've shown you a second photo. Do you recognize what's in that photo?
Yes, that's John's driveway.
Is that a fair and accurate depiction of how John's driveway appears?
Yes, it is.
I'd move that into evidence. No objection.
Okay.
Exhibit 7 so marked.
May I publish?
Yes.
Could.
These screens are a lot better than
Thank you. I'm showing you a third photo.
the
Do
last
you
one,
recognize
the last
what's in that
trial.
photo?
Yes.
And could you share with the jury what's in that photo?
It's the side of John's house looking up from the driveway.
Is there anything you notice on the side of the house?
The lights or the Ring camera.
Are you guessing or do you know that's a
No,
ring camera?
I know there's one there
And how do you know that?
because I got a Ring camera and I could look and see who was at my door. And then he said, "Why didn't you tell me about these things?" So he bought one.
I move to introduce this photo.
Okay.
No objection.
Thank you.
Exhibit 8.
May I publish, Your Honor?
Yes.
Ms. Roberts, with the laser pointer, could you just point at the picture and show where the Ring camera is?
On this screen?
Yes, please.
Whichever one you can do.
Okay. Why isn't it working?
Nope.
It's on.
Okay, well, you know what, rather than use the pointer, why don't we describe, can you describe where you see the Ring camera on that picture?
It's in where the two lights are under the top window.
Okay, thank you. We could take that down, please. How many times would you guess you had been over to his house?
I don't know. More than 50,000. I don't even know. A lot. It was weekly.
That night, you told us that your husband went out to meet John at McCarthy's, a bar.
Yes, he did.
Do you remember your husband coming home that night?
Yes.
Do you have any memory of about what time he returned?
I'm guessing, but somewhere around 10:30.
So I'm not going to let you guess. Do you know? Do you have it?
I don't know.
Okay.
It was around 10 or 10:30. I can't be exact.
Did you see him come home?
Yes,
What was the forecast for that night and the next morning?
there was a blizzard coming.
Was that part of the decision-making of going out or staying home?
Yes.
At that time, when your husband came home, did you look outside? Do you have any memory of what the weather looked like around 10:30?
I remember the snow started to fall somewhere around 12 because I remember looking out the window and I could see it starting.
And that was the beginning of the snowfall?
I believe so.
What was the weather out that night?
The weather that night, I think, was fine. It was cold, but it wasn't snowing yet.
I want to move forward ahead. At some point that night, did you go to sleep?
Yes, I did.
Did you sleep through the night, Ms. Roberts?
Yes, I did.
At some point, did you wake up?
Yes, I did.
I want you to tell us what was the reason that you woke up.
I got a phone call at 5 o'clock in the morning from Karen Reed.
Were you expecting a call?
No, I was not.
Had you ever received a call at 5 in the morning from Ms. Reed before?
No.
Share with us what happened that morning. What did you hear?
Karen called and the first thing she said was, Kerry, John's dead. And then she hung up. And then,
When she said that, did you have a chance to have a conversation with her?
no, I did not.
Describe her demeanor when she said that.
She was yelling loud enough, my name, I think it was 3 times, it might have been 2. She was yelling loud enough that she woke my husband.
Your husband was sleeping next to you?
Yes, he was.
Was she loud, yelling, screaming?
Yes, she was very loud. She was screaming.
After she said, Kerry, John's dead, did you know what she meant?
No,
And did you say this was around 5:15?
this was at 5. She called me at 5 on the
5.
dot.
After she hung up, what did you do?
I was half asleep still. I didn't know what was going on. So I started to get up and I think I tried to call her back. I know I tried to call her back, but I don't know exactly when because I was like, what? So my husband said, what was that? I said, I don't know. Something's going on. I don't know what's going on. That was Karen. And then I tried to call her back. I know I tried to call her back, but I don't know if she answered or if she called me back the next time I spoke to her.
After you or she called you again, did you have another discussion or did you hear her say something else the second time you spoke to her?
Yes, the second time she said, I think something happened to John. I think he got hit by a plow. He didn't come home last night. Kaylee was home. He would never leave her by herself, and I was not supposed to stay at the house last night. So I think something happened to him.
Did she say anything about drinking?
Yes, she said, we drank so much, I don't remember anything from last night. And I said, okay, where are you now? She said, I'm driving. And I said, you need to go home. Where's Kaylee? And she said, at home. I said, you need to go home and be with Kaylee. She cannot handle this, thinking, her uncle's missing. I said, you're going to get a DUI. You need to go home.
Was there anything else in the conversation that she said to you at that time?
She said, I'm going to drive to your house. Would you drive my car? And I said, yes. So at that point, I started to get dressed. I turned on the automatic car starter so it would warm up. Told my husband, I don't know what's going on. John didn't come home. And so I think my husband tried to call him and I tried to call him. And my husband said, you're not going anywhere. It's a blizzard. He's probably on somebody's couch. And I was like, I know, but she's really upset. I'm just going to go. She wants to come here. I'm going to drive her car. And then I went out to my car and sat and waited for her.
When you called John, did you get any response?
No, I did not.
As you were waiting for the defendant, did you make any other phone calls?
I did. When I was in the car, I thought to myself, well, she thinks he got hit by a plow. I'm going to call the police and see if there was any accidents or maybe something happened. They brought him in. And I spoke to the officer who said, no, nothing of that sort. I've been here all night. And then I called the Good Samaritan Hospital and Milton Hospital to see if they had anybody that was taken in an accident.
When you called the police to look for Mr. O'Keefe, did you call 911?
No, I called the non-emergency line.
Do you know if that call was recorded?
I believe so.
I'd like to introduce an exhibit.
Okay.
All right, we've heard this call before.
Any objection?
This is when she's calling to see who's in the hospital, any reports of anything.
When you called the police, what was your level of worry at that point?
I wasn't super worried. I mean, he didn't come home, but they were out drinking. So I assumed, like my husband said, he's probably on somebody's couch.
The second call you had was Miss Reed. Can you describe her demeanor in that second call?
She was frantic. She was frantic. I mean, she couldn't find John, so she was very worried.
How soft or loud was that phone call?
It wasn't as loud as the first one, but it wasn't a regular conversation.
With court's permission, I'd like to play the exhibit of the call.
Okay.
Can't believe sounds good. Hi, Brandi Churchwell. I'm calling because my friend's boyfriend did not come home last night. We were at Waterfall, and now she is calling me hysterical because she doesn't know where he is. You didn't take anybody outside the name of John O'Keefe, did you?
John O'Keefe?
Yeah, he's about to cop, and it would be on set, but.
No.
And she probably got a ride and passed out at someone's house. I don't know, but.
Yeah, but no, we didn't lock anybody up or anything like that. And where does he live?
He lives on Meadow, that's the present.
He lives on Meadow, Pleasant. Okay, and where's the wife home? You said your girlfriend?
His girlfriend, yeah, they were out having drinks, and then she left and expected him to come home at some point, and he never did.
Yeah.
And so I said to her, you know, my husband had been out with him earlier in the night, but then he obviously came home. And he has custody with me to nephew because their parents passed away.
Okay.
And so she's home with the week and I go, they're old enough to be home. And so she's nervous because she never even happened.
Yeah.
So she's like, I feel like something happened. And I said, okay. Well, so call the area hospital and nobody got in. I personally think he probably picked him up and he passed out. I don't know.
Yeah, where did he didn't drive last night?
No.
No. Okay. Again, it's more, it's be driven by you. She would have to, call in, come to the patient, and talk to us. But I mean, as of right now, it's more, he just didn't come home last night. Is this common sometimes to happen with him?
No, that's why. That's because he didn't tell me. That's kind of why she's more freaking out. So I figured I called the area hospital and then I call Canton police just to make sure he didn't get picked up. But like I said, he's not complete about the very old French people. If anybody could pick him up.
Yeah.
Please get it off.
Okay.
Again, we're doing a blizzard party or something.
Yeah, no. Unfortunately, I wasn't there. I was stuck here. But we didn't get any calls, anything like that. Nobody was arrested or anything like that.
Okay.
All righty.
All right, well, thank you.
All right, no problem. Good luck.
Okay,
See ya.
thank you, bye-bye.
Were you in your car when you called the police station and the hospitals looking for John?
Yes, he was.
Do you know at that point whether anybody else had called the police station?
No, I don't know.
Do you know at that point if anybody else had called any hospitals?
I don't know.
How long did you wait in your driveway?
I don't know. I'm sorry.
Okay.
Maybe like 7 minutes, 8 minutes.
What were the conditions like out that morning?
It was bad. It was in the middle of a blizzard.
When you were outside in your car in the driveway waiting, describe the lighting conditions for us.
It was still dark out. It was 5 o'clock in the morning and it was snowing. So it was not great.
How was the visibility?
Not great. It was coming down really fast at that point.
You said that night when you went to bed, the snow just started. Had snow accumulated at that point?
No, I don't think so. It was just starting to stick.
I'm sorry, that was the night before, but at this point when you were in the driveway, had the snow accumulated?
Oh, yes.
Do you know how many inches it was?
No, I don't.
Okay.
Enough that the plows are out.
As you were waiting for the defendant, did she arrive at your house?
She did not.
What happened?
Again, I don't know if I called her or she called me, but eventually we connected on the phone and she said, I said, where are you? I'm waiting. And she said, I'm at Jen's house. And I said, Jen, who? And she said, McCabe, she's going to drive my car. And I said, okay, well, listen, they don't want cars on the road because it's so bad. I'm already in my car. I'll come there to Jen's house, stay there, and we'll follow each other and we'll go back and drop your car off. Did you look in the house for John? Could he just be in the house, passed out somewhere? And she said, no, she hadn't looked in the house. So I said, okay, now I'm going to come to Jen's. We're going to take the car home, drop it off. We'll check around the house. And then I don't know what the next step at this point was. I just wanted to check the house.
At the time you directed that you were going to meet at Jen McCabe's house and then drive to John's house, was there any suggestion by the defendant where she wanted to go?
I didn't know where Jen's house was. I knew the street. I had dropping Kaylee off or picked her up a few times. So I said, stay on the phone with me so I don't know which house it is. And so when I got there, I pulled in the driveway and there was some conversation about.
Can I back you up and just ask you a little bit about the drive there? I don't mean to interrupt. When you left your house, you talked a little bit about the weather conditions. How long did it take you to get from your home to Jen McCabe's?
Oh, it's quick. Probably 4 minutes.
What was the driving like?
It was not good driving. That's why I didn't want two cars on the road.
Did you have any difficulty driving through that storm?
No, I mean, it was treacherous, but I was in four-wheel drive. I have an SUV.
You mentioned you didn't know exactly where Jen McCabe lived. Had you been there to drop off John's niece before?
Yes, but I didn't know which house it was because when I picked her up before, she was either getting out of the car at the driveway or waiting at the end of the driveway. So I didn't know which house it was.
I think I interrupted you, but were you telling us that as you drove to Jen McCabe's house, you were on a Bluetooth, on an open conversation with her to help with directions?
Yes, Jen and Karen were in Karen's car, and I was on the phone essentially with both of them.
Do you know what type of vehicle the defendant was driving at that time?
A Lexus SUV.
As you drove over to Jen McCabe's home and you had some guidance finding it, did you hear any conversations in that open line with, or even any statements by the defendant?
I remember when I pulled in behind her car in Jen's driveway, and at some point Karen said, my taillight, and I looked, and Jen she must have had the brake done because you could see that there was missing taillight.
When you say missing taillight, was it merely cracked?
No, there was a piece missing.
Could you see that as you were parked right behind the defendant's SUV or Lexus?
She must have been applying the brakes because you could see it, but there was a lot of snow.
When you saw that the taillight had a missing piece, did you say anything?
No.
Did you think anything of it?
No.
How long were you parked behind the defendant's Lexus while it was parked in Ms. McCabe's driveway?
Not long. We were just, I pulled in and then we stopped. And then the next plan at some point in that conversation as well, or maybe on the ride, because now we're heading to John's house to drop a car off. I pulled out of the driveway, Jen pulled out, and I followed behind all the way to John's house. And at some point, Karen said, I left him at Waterfall. And I heard Jen say, no, I saw you pull up in front of my sister's.
Was anything else said about the broken taillight?
No.
You followed Ms. McCabe?
Yes.
Where did you go?
To John's house.
Did you arrive?
Yes.
I want to ask you some questions about when you arrived and what you did next.
Okay.
When you arrived at Mr. O'Keefe's home, You're in two separate cars. Who pulled into Mr. O'Keefe's driveway first?
Jen pulled Karen's car in first.
So Ms. McCabe was driving the Lexus
Correct.
and the defendant was in the passenger seat?
Yes.
After you both pulled in, tell us what happens next.
We went, I wasn't sure if it was, at some point Karen showed us the taillight up close, but I didn't know if it was when we arrived or when we left. But we went into the house to look for John.
When the Lexus was parked by Ms. McCabe in Mr. O'Keefe's driveway, was it facing the street or facing away?
Facing where the basketball hoop is, not facing the street.
I'd like to approach.
Okay.
I've got my spreadsheet from the last trial up, so I'm comparing anything. So anything I can find, same or different or whatever, I'll point out for y'all.
Going to show you a photograph. Do you recognize what's in that photograph?
Yes, that's John's driveway. That's Karen's car on the left and John's car on the right.
Do you recognize both those cars?
Yes, I do.
Do you recognize that photo as a fair depiction of his driveway?
Yes,
Do you recognize it as a fair depiction of the motor vehicles?
yes.
Now, when you went there that night and you pulled in behind Ms. McCabe and the defendant, is there any differences between how that area looked when you pulled in as opposed to that photo?
Well, it was the early hours of the morning, so it was dark out and there was much more snow. And there was
Other than
snow
this-
coming down.
I'm so sorry. You want to finish?
Nope.
Other than the snow and the lighting, is there any other differences?
Nope.
I'd like to introduce this as an exhibit, please.
All right, there's no objection, Mr. Jackson?
No objection. With the court's permission, I'd like to publish.
Okay.
And to help us understand, you see on the left is the house.
Yes,
There's a motor vehicle in the middle of the driveway, but it's the vehicle to the left.
yes.
And whose vehicle is that?
That's Karen's.
Is that where it was parked that night when you went into the house?
Yes,
In the motor vehicle to the right, you recognize that?
that's John's car or SUV.
Thank you, you can take that down. I'm showing you a second photo.
Okay,
Do you recognize that photo?
yes.
What is it?
It's the back of Karen's car.
Does it look like a fair and accurate depiction of her car as it appeared that morning in the early morning hours to you?
Yes,
Do you notice anything that's distinguished in that photo?
the piece that's missing in the taillight.
Which one?
The right passenger rear.
Do you know when, I'm sorry, do you know when this photo was actually taken?
I do not.
Although you don't know when it was taken, is that a similar depiction to your memory of how it appeared that morning at 5
Yes,
or a little after 5?
yes.
I move to introduce this exhibit.
Okay.
No objection. The court's permission, I'd like to publish.
Yes.
We could take that down, please. After you arrived at Mr. O'Keefe's house, what was the plan to go inside? What were you looking to do?
To go inside and look and see if he was passed out somewhere. So we went in through the garage and I started looking. I think Jen ran upstairs to Kaylee's bedroom and I just started looking through the living room. Basement door was locked from the inside, so I knew he wasn't in the basement. And then I checked the other living room. He has a big house. Then I went to the top of the stairs to check his bedroom.
As you looked around, what was your mood?
What was my mood?
Yes, were you calm?
I mean, I was worried, so we were, at this point, Jen had already established that they went to her sister's.
Sustained.
Okay.
Hearsay.
Jen had already,
Now, let
Hold
me ask
on,
the question-
Ms.
I'll ask
Roberts.
the question better. My apologies. How many rooms did you look through in John's house?
1, 2, 5 or 6.
Did you see Miss McCabe looking in rooms as well, searching?
She went upstairs when I was looking downstairs.
At some point, as you were looking, did you see the defendant?
Yes,
Was she looking with you?
she was in John's room.
What was she doing?
She was just standing there when I came up to the top of the stairs.
Did she say anything?
No,
Did she do anything?
no,
Was she searching?
I don't know. She was in the room.
What happened next?
At some point, Jen earlier had said,
Well, let's not talk about what was said. Okay. Let's
Well,
just talk about.
the
the
plan
best
at
you
this
can,
point
your-
is
your
to go to
memory of what was
34
done.
Fairview.
Ms. Roberts, I know that I'm just going to ask you to wait for a question
Okay.
because we can only get one person at a time. So next question, Mr. Brennan.
Again, my apologies. And so as you're looking through the house, you don't find John. What happens next?
The plan was to go back to Jen's sister's house.
Who made that plan?
Karen wanted to go back there.
Well, tell us a little bit about that. How did that conversation come up, and share with the jury what was said?
And the car ride to Meadows, Karen said, I left him at Waterfall. And Jen said, no, I saw you pull up in front of my sister's. So then Karen said, we need to go back to your sister's. And I said, no, we're going to go to Meadows and we're going to drop the car and we're going to look there. Then we'll go there if we don't find him.
When you were at the house, Meadows, John O'Keefe's house, and you didn't find him, was there any further conversation about what the next steps would be?
I said, let's go. He's not here. But I didn't know where Jen's sister lived. So we got into the car. Jen was in the passenger seat. I was driving my car. Karen was in the back seat.
Did you
And Jen was
begin,
giving directions.
did you begin your way towards Meadows?
Yes,
And it was Ms. McCabe who was giving directions?
yes.
As you began driving to head towards Meadows, in addition to trying to drive, were you doing anything like looking or searching?
Well, yeah, we were looking on both sides of I was looking on both sides of the road in case he was walking home.
Did you see Ms. McCabe searching?
Yes, she was looking out as well.
So describe a little detail about what you saw Ms. McCabe doing.
She was looking out the window as we were driving. So was I, as I was driving.
And where was the defendant during that time?
She was in the back seat.
Was there any conversation, comments, statements?
Well, she would be in the back seat and then she would be in between Jen and I, in the back seat and then in between Jen and I. She was just very frantic.
Okay. Was she saying anything?
There was conversation on the way there.
Okay. Was she looking as well? Did you see her looking out the windows like you and Jen?
I don't know if she was because she was in the back seat.
As you drove to Meadows, what was the visibility? The same or better or worse?
No, it was poor.
Did you make your way towards Meadows?
I did.
As you finally got to Meadows, was the house on your left side, your side, or on the other side?
Are you talking about Fairview or Meadows?
I'm sorry, Fairview.
Okay. The Fairview house came up on the left-hand side.
Before you got to the house, is there a tree line between that house and the house before it?
Yes. There's a cluster of trees and bushes.
All right, take us back. I want to talk about that morning. As you're driving and approaching Fairview, tell us what you hear, what you see, what's happening.
Jen's giving directions, and it was really bad driving. I was white knuckling because it was getting slippery. Karen wouldn't put on her seatbelt because she was in between us again the whole ride, and then sitting back. But she was worried because we weren't finding John.
Were you having words?
Yes.
Tell us.
I said to Jen, where are we heading? And she said, my sister lives on Fairview. And I said, where is that? She said, off of Chapman. I said, oh, okay, near Spring Lane. At some point, Bella's mom came up.
Tell me what that means.
I didn't know who it was, but it was one of Kaylee's friends, Bella's mom. Well, the directions, at some point, Karen was talking about Bella's mom to Jen, saying she never liked me. I didn't know who this woman was that they were talking about, but apparently Bella's mom lived near where Jen's sister lived on Fairview.
Did you learn any more about the relevance of Bella's mom?
No. Oh, well, I think John had dated her.
I'm going to allow it.
So as you approached Fairview, tell us what happens.
As we approached Fairview, at the house. You mean the house or the street?
Yes, the house.
The house. Jen said my sister's house is right up here. And I said, okay. And as we approached the house, Karen from the back seat is now screaming, there he is, let me the F out of this car. And she's now kicking the back door to get out.
When you heard the defendant scream, there he is, and started kicking the car door, did you see anything?
I did not.
Did you see anybody?
I did not.
Did you look?
I looked.
Was there anything that impeded your ability to see far?
No, it was just snow.
How far could you see when she was yelling, there he is?
How far could I see?
Yes.
I mean, the visibility wasn't great.
Okay. Was she pointing or giving any direction?
No, she just said, there he is.
Okay. What happens next?
And then I unlocked the car. I looked over, I didn't see anything. And I unlocked it so she could get out of the back seat. I looked at Jen and I said, she's crazy. And then I turned around and watched, and she ran over to a mound of snow.
When she started running, before she got anywhere, did you see anything at that point?
I did not.
Were you looking?
I was looking. She said, there he is. So I'm looking around to see where he is.
And you could see nothing?
I did not.
Did you see her run around or directly?
She ran right over to the mound of snow.
Could you tell what the mound of snow was from the car?
Once she got to it, yes, it was. Once she got to it, you could tell it was a mound of snow that was the length of a body.
All right, I'm going to stop you there, Mr. Brennan. I need to see counsel at sidebar for just a minute, please. Regarding.
Okay, so they're getting ready to end for the day. They go till 4. So they're getting ready to call it a day. Now, some of this is the same as last time. Some of it, some of the stuff she said last time, she hasn't said yet. Of course, we're still not done yet. Yeah, they're ending at 4 every day. I ain't mad about it. I'd rather end at 4 than 5.
Ms. Roberts, we're going to have you come back tomorrow.
Okay.
Jurors, we're going to break for today. So we're going to send you home. The same 3 cautions that I'll tell you every single day. Please do not discuss this case with anyone. Don't do any independent research or investigation in this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Please be extra careful with your social media. Okay? We'll see you tomorrow morning. Thank you.
Court, all rise, please. Jurors, hold your books, put them on your seats. All me.
They are dismissing the jury. Now, remember, this morning she said that there were a couple of motions that they had to discuss. So she may be sending the jury home now to have a little bit of time to talk about those. So we'll kind of see if they do. Maybe not. Maybe they're ending the feed. If not, I'll check the docket and we'll see if anything comes up tomorrow, but looks like they may be ending the feed. So maybe they're not. We'll see. Okay, so thoughts on the first day. Thoughts on the first day. What are y'all thinking? What are we thinking? How are we feeling? The first witness, I don't think that went how the prosecution was thinking it would go. I am going to go back and look specifically at that video. I think that the whole thing that they were hung up on is, because I think this is like the biggest point of the day was that whole argument about his well, first of all, his memory changing from the last time. They did end that feed, so so I guess they're not going to be talking about any of the other stuff they had. I know they were talking about ARCCA and all that. I guess they got it worked out at sidebar and did not let us be nosy flies on the wall. Okay, so the look at Marie Moss with our official stats. We love some Marie Moss stats. 2 witnesses, 5 sidebars, 29 objections. 29 objections today already. What a day one. What a day one. Okay, so I think the biggest like moment from today, as far as witnesses go, is Nuttall's recollection of the I hit him thing. Okay, that was relied on so heavily in the last trial. You know, remember Lally said that she said it 4 times when he was doing his closings, but whatever, I digress. But they relied on that a lot in the last trial, and based on them bringing it up in the openings, they're going to rely on it a lot in this one too. So to have your first witness, you know, like for the prosecution to have their very first witness that they call, kind of have that part of his testimony picked apart and discredited, is not a great way for them to start out. Now, all trials, not all trials, some of them are like home runs one way, you know, whatever. But a lot of trials will have, some days are, you know, a win for the prosecution, some days are a win for the defense, some days it's up and down, some weeks are better, some, you know, whatever. So things will kind of ebb and flow. But for that to be something that they are relying on so heavily, and to have the very first witness kind of torn apart when it comes to that kind of stuff, that is not off to a great start for that specific thing. So I'll be interested to see what else happens with that, because that is one of those things that even in the last trial, they relied so heavily on it, but the testimony conflicted with each other on those things. So I don't want to worry too much about Kerry Roberts right this moment, because she's going to be back tomorrow. So there's going to be a lot more for her. So I don't want to get too much into her, but I do want to talk about Flammati for just a minute, because Nuttall was talking about Flammati. So this is the thing that they were going back and forth on. Nuttall said that his specific memory of the whole I hit him thing came from he had this vivid memory of being knelt down, and he said Flammati was doing the compressions, and he asked Karen Reed, "Do you know him?" And Karen Reed responded, "I hit him, I hit him, I hit him." Okay, that's all new. That's not what was said in the previous reports or at trial before. So this is all something that's new and different. So I pulled my handy dandy spreadsheet, because you know I love a spreadsheet. I pulled that because I remember there being so many discrepancies last year too in the trial about people saying when they supposedly heard this, but then it was never put in their reports and they never said it to anybody, whatever. So that got picked apart during the last trial as well. So I pulled up that, and I was looking in Flammati's testimony last year, because he said during the trial, he said that he heard it, but that was one of the big issues during the last trial, was that Flammati said now that he heard it, but he had never said it before, or did not say it before. And then he said that he had told I think he said he told the nurses or something, but he says he remembers relaying it to the nurses, but he had never said it to anyone else before the day that he testified, because he says he wasn't asked. And Jackson was like, well, don't you think that would be something important to put in your narrative when you're doing this? Because that would be something, you know, that's kind of a huge, it's kind of a huge thing. So that was, you know, one of the big issues last time too. Now, Buchanan said in the report that he did that, let me see. Buchanan said in his report from February 8th that Karen Reed said, I hit him to Katie McLaughlin. And it was, so last year on the trial, during the trial, he said that it was during that conversation. Flamati said that's when he heard it. So then the report from that same time, that February 8th from Proctor, said that Nuttall heard it when it was being relayed to a female. So everything's kind of getting very muddy about who heard it, when they heard it, when's the first time they said they heard it. And now that's kind of changing too. So it's kind of a big thing to say, especially because they're basing their case on it. So it's one of those things that if this is something you heard, it would need to be very specific, and you would need those statements to be not conflicting with the statements that you've made previously and with the statements that your coworkers are saying. So because they're conflicting and because these things are changing, that's a problem for the prosecution. So I don't know. I don't know how they're going to clear that up. The thing is, UL 7 when he says it was clearly said, but was it? If it was clearly said, we would have a clear picture of when or how it was said. And there has been nothing clear about it. And I think that's where the problem comes in, because if it was clearly said, we would have clear reports on it, but we don't. We have a lot of muddied statements that continue to change and situations that are given that continue to fall apart when they're picked at. Like, you know, if this was a clear thing, it wouldn't be a problem. The problem is there is no clarity with this. When you have memories that are constantly changing, constantly being, you know, like details here and there altered, some of it is completely, you know, completely changing at different times. It's nothing about it is clear. I think for something like that to be so heavily relied on for their argument, it needs to be clear, and it's just not. And I think that's going to continue to be a problem. So Linda Blake says, it amazes me how many witnesses say you didn't ask me. Right? That's, yeah. Yeah. Especially because some of that stuff, even before they get on the stand, some of that stuff in, you know, reports and stuff, we even heard that with people explaining why they didn't put stuff in reports. It never came up, or nobody asked me, or whatever. What? I don't get it. I don't get it. I'm curious to see with the other first responders who testify what their version of events is this time, who sticks with their first memory. And again, like I said before, I am not saying that all of them are lying. What I am saying is memories are not concrete. And that is obvious because we have seen so many of them change what they remember. And that doesn't mean that there's anything nefarious, as Brennan would say, but it does mean that it is not slam dunk testimony if we can't really rely on it to be consistent. For memories to be relied on by a jury, they should be consistent. And when they're not, that alone is reasonable doubt, at least for that specific part of testimony. So we'll see. I think that they would do better to try to rely on whatever data they're going to show, because if the rest of the cross-examinations go like that when it comes to picking apart, you know, those memories, that's going to be bad for the prosecution. So we'll see. We'll see. Why didn't Boston PD send over their own investigators? One of their officers were dead in one of their other officers' yard. That is probably why they didn't send them over. It's not their jurisdiction, but also they would be conflicted out of it because of that situation. So that would be, it would technically be Canton jurisdiction, but because it's an unaccompanied death or whatever unaccompanied, what do they call it? Nobody else was there. Is it unaccompanied? Is that how they worded it? They have a specific term for it. Because there was nobody there when they found John, that goes to the state troopers to investigate instead of Canton. Canton doesn't investigate homicides. So Proctor will be used as the fall guy. If I were him, I'd flip on Albert's like a hot pancake. So Proctor will be big time the fall guy. And some of that is all his own fault because he did a lot of things wrong. And now he's lost his job over it. Unattended. Thank you. Unattended. Look at y'all. Always got my back when I can't remember words. Because he did so many things the wrong way. And now he has lost his job in connection with this case. Now, everybody and their mom is going to be putting everything on him. Everything that was done, like, you know, oh, my statement is wrong. I don't know what Proctor did. Oh, you know, my time changed. Well, I don't know. That was on Proctor's part. I don't know what Proctor did. There will be a lot of that. I'm sure we will see. Proctor is like Proctor is no longer like just thrown under the bus. He's like, he is being drug behind it as well. This is going to be, I'm sure, a common theme for this entire trial. So he made that bed. He will have to deal with it. Thanks for referencing the last trial. I'll be so lost if you hadn't. I like to compare what has been said in previous statements, what has been said in the previous trial, what has been said in reports. I like to see all of that stuff because I think it gives you a fuller picture, especially because look, this is a bunch of drunk folks at a bar and then they go home and they're still drunk and they're getting drunker. And then everybody's trying to say what happened. Have you ever tried to get a clear story out of a bunch of drunk people? It's like herding cats. You can't do it. Nothing makes sense. You cannot get from point A to point B in any kind of cohesive manner. It is not for the faint of heart. And that's what we're basing a murder conviction on. You can't do that. So I have to try to pull together all of the information I possibly can and then filter it in with all of the timelines, the data, stuff we actually know to try to find out what the heck is actually going on. Because trying to get accurate recollections from a bunch of drunk people from, you know, like 3 a.m. or whatever, or not 3 a.m., 1 a.m., 12 a.m., whenever they left. We know they left the bar around midnight, but everything after that is just, psh. So we'll see. We'll see. This is a very different order than what we went in last time too. So I will be curious to see who else we get tomorrow. So tomorrow morning, we will be back here live. I will get my recap done of today. So if you missed some of today, or if you were kind of in and out, or if you zoned out when they're talking about snow, that's fine. I've got your back. I will have a recap video for you to kind of go over some of the main points of today. And then tomorrow we will be back live again tomorrow morning. Kerry Roberts will be back on the stand. So we'll see what, if anything, she has to say about anything else that Brennan asks. And then last year, there was no cross-examination of Kerry Roberts. So we'll see if that changes this time. Will they do cross-examination of her this go round? Will they bring up any of the stuff that was said in the last trial, or will anything else come out this trial that we didn't hear last time? TBD. We will have to see. So we'll be back here tomorrow, and then we'll see who else they call. Last year, it was day 16 of trial before Kerry Roberts actually testified. And here we are, day 1, the second witness right out of the gate. So very different. Very different. Very different time. Everything's going to be different about this one. So why wasn't Proctor considered a conflict of interest? Sage Dunn, I would love to know that as well. Part of it is because he did not, like, he kind of denied having any kind of conflict of interest. So he admitted in the federal grand jury that he misrepresented his relationship with the Alberts. So we'll see. We'll see. That has been one of the main things that has kind of backfired at this point, right? So, all right. Well, oh, court's back on. Hold on. Are we back? Let me look. Hold on. Let me swap to my Crime Junkie account. Oh, they are going to do the motions. Ah, see? Hold on. They ended the feed. Let me see if I can get. New feed up. Hold on. Hold on. Hold on. Switch account. See if I can get the feedback. Yeah, good thing we didn't go nowhere. Give me a second. Get it pulled back up. I had a feeling they would do this. And then when the feed ended, I was like, oh, I'm wrong. Yes, I know. They are back at court. I said, hold on. I'm trying to get my feed back up. What just happened? That is not my feed. That is Emily. I hear Emily Deepak. Oh, yeah, there she is. Studio. Content. I'm getting it pulled up. I have to use my feed. I'm not using anyone else. Feed me. You remember that play? What was that play? Feed Me Seymour. What was that? What was that play with the plant? He's like, feed me Seymour. What was that? You remember what I'm talking about? I'm not crazy. That's something. That's a thing. What is that? Who knows the name of that one? Little Shop of Horrors. Yes. That's the one. That's the one. We did that play in high school, and isn't it weird the things that stick out to you when you're looking back? I still remember the people who played that. Seymour, feed me Seymour. Filters. Hi, some of y'all are just now coming in. How are you just now coming in? At the end. Alan Jackson will be doing the cross-examination tomorrow. Hold on, let me get this. Okay. All right, I'm going to add, oops, let me stop this. Stop screen, present, share screen, entire, share audio. Okay. All right, I rewind it so we can start from the beginning of this part.
Please be seated, court is in session.
All right, so we'll have a quick hearing on paper now 682 and 680. First, Commonwealth's motion to enforce compliance with the court's April 16th, 2025 ARCCA discovery order. Mr. Brennan, you said you could be brief on both of these, so I'll hear you.
So this is the ARCCA stuff that they were talking about this morning.
Your Honor, I'll get right to the point. On the motion for compliance, our position is the defense did not comply with your order. This has been an ongoing issue which relates directly to the credibility of potential ARCCA witnesses. This is information based on the history and representations made in this case that we're entitled to. I did note before these were produced that we have watched video footage from unaired video from the documentary. We clearly knew that there were text messages and correspondence beyond what was represented to the court. It is not a surprise that I did receive these lists of text messages and calls after I made those comments. However, there is no text message content. There is 99 texts to Mr. Wolf, 6 texts to Mr. Rentschler. That does not reconcile with the past positions and representations of the defense to this court and to the Commonwealth. In addition, there are a number of phone calls. And those phone calls, again, I would suggest do not reconcile with the past representations. We have 52 minutes of phone calls on 5 calls with the ARCCA mainline, 133 minutes, 20 calls with Dr. Wolf, 57 minutes, 23 calls with Dr. Rentschler. I find it difficult to accept that these were all for scheduling purposes. We also had your Honor's order, not just for the communications, which are not a complete or a fair production, but there was a order by the court to provide all correspondence, text messages, emails, not just with Attorney Jackson, but with the entire team, including the defendant, Karen Reed, and we have received nothing. This is important because if we look at the first half of ARCCA's potential testimony, which is limited to their prior report, we cannot fairly and effectively cross-examine the witnesses. until we have the information we're entitled. And that's why I've also asked and suggested that ARCCA should be ordered and required to provide that evidence as well, so that we can see what is there. It is concerning that there are this many texts, this many phone calls, and the fact that this is totally in contrast to what was represented in the past. So before there's even a thought of ARCCA testifying, I think we're entitled to the full discovery that we asked for, the full discovery that the court has ordered. I don't see anything to do with billing or anything else beyond these text message and phone call logs. I want whatever content is available. I think it's relevant material. It's pursuant to your order, and this is woefully incomplete. Should I dive into the second motion?
Yes.
So I can move quickly. The second motion, part of it is moot in some respects. I won't go through the tortured history of discovery. We've gone through it too many times. We don't have time for it. But inevitably, it is clear that we have played by the rules, met our discovery obligations, and as we stand here now, the defense is proposing new opinions, new testing, and they don't even have the parts of that testing yet. This is 2 weeks into trial after we picked a jury. This is at the time of the opening. It is ambush. It is unfair, and we have no ability at this point to reconcile or deal with new opinions and new information. Importantly, the defense's position is they may or may not have a report by May 1st. Our expert will be testifying somewhere at the beginning or middle of May. He is away. He is not available. And so anything we receive at the beginning of May or end of April, we'll have no opportunity to look at, vet, test, reconcile, or even engage in our own testing. This was my concern all the way back in November. I'm not Nostradamus, but this obviously was something that worried me that actually occurred. And so at this point, it would be fundamentally unfair for the defense to get a benefit for failing to comply with discovery orders by waiting until February to seek permission with ARCCA. They could have called any expert, asked for any expert they wanted. They didn't. They chose this method, and this is the consequence of it. And at some point, the defense has to bear the burden of their decisions. We will not have the ability to rush through, have Dr. Churchwell come in days before his testimony, try to reconcile, be inadequate. I've had a brief correspondence with him. It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline, that's technical, but the reality is we're all trial lawyers. We've all tried a lot of cases. It would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new, we will not be able to reconcile. We would not be able to proceed with our expert in a fair manner. Thank you.
Okay. Mr. Alessi, is this you? I'm going to ask you to be as brief as you can be, please.
Your Honor, I understand your request to be as brief as possible, but this is the first opportunity the defense has had to respond to almost every allegation that's been made. We haven't had an opportunity. So I certainly respect the court and what the court's request is, but it is going to take a bit of time to put facts out. And I want to separate two categories that the Commonwealth has conflated. The Commonwealth has conflated the issue of what text messages exist, which text messages don't exist, what's been turned over pursuant to orders. And I would like that to be clear to the court factually, because the Commonwealth has misstated just now 3 times the facts.
So I asked this morning, there were 100 or so texts referenced in the exhibit, whatever was presented by you folks. I asked if Mr. Jackson, if he provided them, because my order was clear they were to be provided, and he said no. And I asked you at sidebar whether they were deleted, and you said yes, in due course. I have no idea what that means, Mr. Alessi. Why don't you explain that?
Well, thank you for the opportunity to explain. Here's what it means. Like anybody's phone, those text messages are 2 years old. They don't exist.
So can you also tell me, aren't the ABA guidelines the council is supposed to keep everything in a case for 5 or 7 years?
I do not believe that is the ABA rule with regard to experts. I'm unaware
In
of
regard
that.
to your client, and this was in regard to your client's case, right?
I'm sorry, Your Honor, I didn't hear you.
Records kept regard to your client's case, which these are experts that were, I mean, there's 100 text messages leading up to trial when I was told that by you that there was a pause email and then all of a sudden out of the blue, a bill appeared in July. This shows that's not true, Mr. Alessi.
Your Honor, that was a different question that Your Honor asked me back then. That was about emails. That was not about text messages.
Have emails been provided?
Yes, Your Honor.
Okay.
All emails have been provided. And that is why we are in compliance with all orders. And I will say also with regard to text messages, we have provided pursuant to every order, every single text message that exists. Mr. Brennan just said, I believe there has to be more there. There's not more there, and I don't believe there can be an order of preclusion based upon the speculation of opposing counsel that there must be more. We affirmatively created a document, Your Honor, to be more transparent than the records, where we summarize all of the communications. Yes, we don't have the text of the text messages, but we were completely forthright and set forth every text that was made. Plus, we turned over from Ms. Little, the only other person on the defense team who communicated with ARCCA, we turned over her texts and the texts of her text messages. There is nothing else in existence to provide. And importantly, the defense was under no order to preserve the text of text messages. And we have never received, as part of discovery in this case from the Commonwealth, any communications between the Commonwealth and its several experts. That has not been what has occurred in this case. But of course, once Your Honor on Friday issued that order to provide everything, we provided everything we can that we had. The bottom line is, Your Honor, we've turned over absolutely everything we have. And in addition to that, we created a document so that it would be easier. We're the one who showed all of these text messages from Mr. Jackson historically. We created that document. There's no basis for a discovery violation. There's no basis for an order violation. We are in full compliance. So that's the prong one, Your Honor. Prong one is what Mr. Brennan has alleged is incorrect because we turned over, and we did it recently and consistently. We've turned over all emails and Ms. Little's text we provided. There are no text messages in 2024, and there's no order that required those to be preserved. And there is no discovery violation because we can't be in violation of not turning over something that doesn't exist.
All right, go to the second.
Thank you, Your Honor.
Motion.
The second part of the motion, Your Honor, is the most maddening for the defense. And this is the timeline that I can go through very, very quickly.
Oh, I love a
And
timeline.
essentially, what the Commonwealth just argued is we will be so prejudiced that if we get the work that ARCCA is underway, working on, that we will be prejudiced because we won't have enough time to address it. Your Honor, the facts show that the timeline for this has been caused by the Commonwealth, not the defense. And I can do it quickly. July 2024, the first trial concludes. November 2024, 4 months later, the Commonwealth decides to retain ARCCA. Their decision to wait 4 months to retain an expert, we're the defense. We defend what the Commonwealth alleges. January 30th, 2025, 2 months after that, and 6 months after the first trial, we get an ARCCA letter report that's barely discernible about what they've done. It's a 1 page and 1/4 of conclusions and opinions in outline form. Next, January 31, 2025, we get the initial Aperture 140 slide presentation. January 31st, February 5th, we get the case file. In February of 2000, or February 19th, we finally get the raw images from Aperture in the scans. That's the first time we get raw images and scans. You can't have an expert work on anything until you even get those raw images in scans. We move, and we have a hearing on March 20, 2025 to preclude Dr. Welcher because the slides are so incoherent and the report is so insubstantial. We can't tell what it is their theory is. So then on March 24th, and at that hearing, the Commonwealth agrees to redact and revise that. So we're already into March 20th. The Commonwealth agrees to redact and revise. Your Honor put the defense on a short leash. We accepted it. And by March 24, we received the PowerPoint that was of the Aperture that was supposed to have two things happen. It was supposed to be redacted, and there were certain things that were supposed to be changed. What did we get on March 24th? It wasn't redacted, and there were 3 substantive changes to it. The Commonwealth has said twice, including today, there were no substantive changes. There's 3 of them, and to the extent Your Honor wants to hear, I can detail exactly what those changes
So
were.
why don't you highlight them very quickly, because
I
have
will,
to
Your
say
Honor.
something.
I can do it quickly. Thank you for the opportunity. First one, slide 36, they changed the image of 34 Fairview. No small change. 102, they changed the conclusion regarding the time that the tail light was broken. No small change. 123, they changed the image of 34 Fairview. No small change. So we ended up getting those changes, and I want to be clear on the date. That's March 24th. We have a hearing on March 25th. We agreed to provide our response to these revised Aperture documents. Here is the key data point. On March 26th, the defense engages ARCCA. Just 2 days after we get the revised PowerPoint with 3 substantive changes. And then we started to respond and provide more information. On March 27th, we responded to the Commonwealth's revised PowerPoint and the Welch report. And then the last 2 items, we renewed our request to preclude Dr. Welcher on Delbert Lanigan grounds. April 1st, and this is another key date, the court decision allowed Dr. Welcher to testify, but also allowed the defense to re-raise objections at trial when Dr. Welcher testified. What does that timeline show? That timeline shows that the Commonwealth took 6 months from the last trial, 6 months, and the defense took merely 2 days after they got the final report of Aperture to retain ARCCA. Last point I want to make, Your Honor, is the argument of the Commonwealth that we strategically waited to retain ARCCA. Nothing could be further from the truth. As the court knows, and has been the case with this unorthodox situation, ARCCA was retained by the U.S. government. They worked pursuant to the U.S. government, and we had to get the permission of the U.S. government to retain ARCCA. We moved expeditiously to do that. We got the permission from the government, and as soon as we got the permission from the government, and as soon as we got the final version of Aperture documents, including scans, we put ARCCA on it. It has only been since March 24th, not even a month, have we had finally the information from Aperture, which is still inadequate. Our experts still say, with regard to what Aperture did, in some instances, they can't even figure it out because the information is so inadequate. Nonetheless, because of all the considerations we're aware of, we had ARCCA proceed forthwith with post haste. And they are working post haste. But, Your Honor, we are the defense. That's where I started. We had to understand as best we could what Aperture did. In conclusion, 2 points. No violation whatsoever on text messages, emails, court orders. All complete, robust compliance. And with regard to the allegation that there was something said, that there's some surprise that there were so many text messages, on June 10th, 2024, and I've got the transcript on an, albeit on an electronic device, right in front of me, I just got to get the passcode. Mr. Jackson read a text message right live that he had with ARCCA. He read it, and here's what it said. The court, okay, Mr. Lally. So her issue is that she is available this week, but not next week. So I really need to get her in on Friday. Mr. Jackson.
Hold on. The court reporter can't hear you. She asked you to stop.
Oh, I'm sorry. My apologies. Am I going too fast? Yes. Thank you. All right.
Oh, he's fired up. He's talking too fast.
Thank you. My apologies. So, Mr. Lally, so her issue is that she is available this week, but not next week. So I really need to get her in on Friday. Mr. Jackson. Dr. Wolf just texted me and said, I presumed you were in court. Give me a call when you're available. The court reporter, I'm getting an interference. Mr. Jackson, I'm so sorry. The court reporter, that's okay. We have been completely transparent that there were text messages as opposed to emails, text messages about scheduling, about other administrative matters. Mr. Brennan is completely free on cross-examination of ARCCA to address every one of his speculations, every one of his suspicions, every one of the ghosts that have been created on this topic. He can address them. If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to ARCCA and ask those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense from putting in a defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right. What's
so,
next?
so I need you to wrap it up because there's something I want to say.
Certainly, Your Honor. I'm going to wrap it up in 10 seconds. There are no violations of any discovery order, no violations of this court's order. And with regard to the retaining of ARCCA, because we're the defense, we acted expeditiously in response to the information we're getting. And this can be tested with ARCCA, the statement I'm going to make. To this date, ARCCA still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Dalbert Lanigan motion, but we proceeded nonetheless. Happy to entertain responses to any questions.
All right. No, thank you. All right. So as you all know, I previously wanted you to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having you. I need the ARCCA witnesses here Friday morning. So we need a voir dire, if you intend to call them, a voir dire on all of this. And I will be sending an order for production of records. I just need to amend it for ARCCA to bring all these items with them. So Friday will be for ARCCA for a voir dire hearing in the morning. So we'll see you tomorrow for trial, Friday morning for this.
May I inquire briefly for scheduling purposes?
Yes.
In light of the hearing on Friday, will it still be half a day, or are we expected to call witnesses on Friday?
No, it will be, if we could do, Mr. Alessi, how long do you think this voir dire might take?
I don't have an answer for you, Your Honor, right now, because I've got to talk to ARCCA and I've got to understand what they have and what they don't have. So I think, in fairness, I think it could take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you very much.
Yes. All right. So we'll see you then. I will issue an order, hopefully before the close of business today. Jimmy, can you stay and get this out today?
Sure.
Okay. All right. Thank you.
Okay, so she's saying that there's now going to be a hearing for ARCCA on Friday without the jury there. She says that she finds that there are violations. Brennan is speculating that there are communications that have not been turned over. And there are texts that between the ARCCA experts and the defense. I guess Jackson's saying he doesn't have the ones from 2 years ago on his phone. ARCCA is like the mess that just never goes away. So now we'll have a ARCCA hearing on Friday. The defense says that they've turned over everything they have and that they are in full compliance. And Brennan says, nope. Hearing for ARCCA on Friday. Hold on to your hat. Brennan again trying to get signed. For somebody who says that I have no problem with ARCCA testifying, he sure does have a problem with ARCCA testifying. So we'll see. That's pretty interesting. They're going to give me a headache. So Friday, no jury. We will have ARCCA voir dire. I will, I'll be live for that, and I will have my timeline of everything. I'll have that because I have a big timeline of all the stuff that's happened with ARCCA when they argued about this the first time. So I'll have that ready so that we can kind of reference that as they're fussing about all of this. Brennan has said from the beginning that he thinks that the defense is lying about turning everything over. He thinks that there is there's more that he hasn't seen. He wants it. He has kind of implied that, like, because he keeps saying like the relationship between ARCCA and the defense is muddy, and that even all the information that he was giving in court that was completely false, you know, he's giving it in a way that's like kind of implying that ARCCA is just doing whatever the defense wants them to, you know, like, which if I were ARCCA, I'd be really mad about that. I'd be really mad to make it like you're trying to make it sound like I'm, you know, I have no integrity, that I'll just say whatever. I'd be really mad about that. So feds hired them the first time, not this time. So yeah, the feds hired them. ARCCA is the firm that the feds hired to determine whether or not like, do your testing, take this information, tell us, did these injuries come from a car? And did the damage to this car come from hitting John O'Keefe? They did their testing. They came to their conclusions and said, nope, that's not consistent. That doesn't work. So once the prosecution and the defense got a hold of that report in January of last year, they were like, the defense sees it and they're like, whoa, wait a minute. This is what we've been saying all along. So they contact them and they're like, hey, we want you to come tell the jury what you've got in this report, because this is what we've been saying all along. And now here you are, a third party agency who we didn't even know about, and you're saying the same thing we've been saying all along. Come over here and tell the jury this. So they tried to hire them, which is fine, except the federal government is like, they have rules about this kind of thing, because they're like, whoa, now these are our experts. We hired them to give us information, specific information, and we gave them a very specific scope of what they were supposed to do. So we don't want you coming in and hiring them, because then, for example, let's say they were just like, yeah, cool, hire them, have them do whatever. And then the defense hired them to do additional testing or hired them to do whatever. And then all of a sudden, whatever they testified to at Sorry, my kid's dropping off a package to me. So anyway, if they have bye, thank you, love you. If they have them come and do all this new testing, and then all of a sudden they have this new testimony that then contradicts or is something different or whatever to, something that was already testified to in the grand jury, that, like the federal grand jury, that could blow up their whole situation, because now they're like, whoa, now we have all of this extra stuff that we have to kind of account for. It can cause a bunch of problems, right? So the federal government is basically like, you can call them as witnesses and they can testify to what they've done their testing on. They can testify to the things that, they have in their report, what we gave them, things like that. But you can't go beyond that. We have them in this box. This box is where we need to keep them, because this is what they've already testified to. This is what we hired them for. You can't come outside of this box. That was trial number one. So defense is like, all right, cool. We can stick to that. We just want them to come in. So that's what they did. All the communications had to stay within this box, right? Now, fast forward to trial two, the federal government has closed the investigation. So now they're like, okay, now you have permission to use them for further testing if you choose to. So as soon as they get that permission, the defense is like, yes, we want to do that, because now the prosecution has this other crash reconstruction situation happening where they have somebody who's going to come in and testify to basically say the opposite of what the crash daddy said in the first trial. So the defense is like, okay, well, now that we can hire them, we want to show them the information that the other crash daddies, like the prosecution crash daddies, have, like what they've come up with, what they had, and all of that, so that they can respond to that, which is totally normal thing for experts. If you have one expert saying this and one expert saying that, each side is going to give their expert whatever it is the other expert said, because that's something that the jury is going to want to understand. If you have two different experts giving two different opinions, you're going to want that to be cleared up on cross-examination when it's your chance, right? You don't want to just be like, oh, jury, just don't even listen to that guy. Just listen to mine. It doesn't matter why. Don't worry about it. No, you want to have each of the experts know what the other is saying, so that they can explain why that does or does not matter, or why their theory or opinion is, still valid, even though they're saying this or whatever. So Brennan doesn't want any of the new stuff coming in, but that's what he's saying about the ambush. Now, is it an ambush? No. inverted video halfway through a trial is an ambush, but that's a whole nother story. I don't see it as an ambush only because he's acting like this is all new opinions. The opinions are going to be, you know, this is what the prosecution's guys said, and we still think it's wrong, and this is our reason why we think it's wrong. This is not groundbreaking new information from Crash Daddies. This is just their response to the prosecution's experts. But, you know, the judge is the gatekeeper, so she will be the one to decide whether or not this is allowed in. So there's kind of two separate issues happening here. One is the supposed discovery violations or, you know, from the text messages or whatever not being turned over. But the defense is arguing, you know, that's not valid. That's just, you know, Brennan speculating, and we've turned over everything we have to turn over. And then the other issue is the opinions from the Crash Daddies in response to the prosecution Crash Daddies. So that, in a nutshell, is why everybody's still mad over ARCCA. So we'll find out more about that on Friday. I will get together the timeline for that so that we can kind of have that to reference. Now, tomorrow we will be back live again in the morning, bright and early and bushy-tailed for trial day number 2. What do you think about trial day number 1? What do you think about it? Tell me. Tell me what you think. I want to hear. I want to hear all your thoughts, all your concerns. I will see you bright and early tomorrow. I will have a recap out this afternoon / evening to kind of put together some of the highlights from today if you had to miss some of it today. So what a first day. Who needs like a nap or a glass of wine or like to play Candy Crush for 3 hours and rest your brain? I will get 0 out of 3 of those things because I've got other stuff to do, but it would be a nice way to end trial day 1. All right. I will see y'all tomorrow. Thank you so much for hanging out. If you haven't hit the like button yet, make sure you do. If you haven't subscribed yet, make sure you do. And then hit the little bell so that you can get notified when we go live, and you'll get notified when we do the recap videos. So Linda Blake says, I took lots of notes this time. Oh, I love a good note taker. Oh, I just love it. I take a lot of notes too. I love it. All right, y'all. I am so glad that we got to hang out and watch this together today. I will see you bright and early tomorrow. We'll be back with Lucy Cam. Y'all have a great night.